Good morning, everyone. Can you hear me? May I kindly ask you to take your seats so we can start the conference, please? Thank you very much. My name is Natalia Pagu, and I work as a legal consultant for the European Bank for Reconstruction and Development. It is my great pleasure to welcome you today to the first joint conference between the Serbian Bankruptcy Law Association, our host today, the European Bank for Reconstruction and Development, and the Secretariat of the United Nations Commission on International Trade Law. We have gathered here today in Belgrade, together with our esteemed speakers, to discuss the topic of cross-border insolvency in a regional context and the use of UNCITRAL insolvency text in the Balkans. Without further ado, I will now pass the floor to Professor Radovic from the University of Belgrade and President of the Serbian Bankruptcy Law Association.
Distinguished guests, dear colleagues, it is my pleasure and honor to welcome you all here to Belgrade. On behalf of Serbian Bankruptcy Law Association and on my own behalf, I extend a warm welcome to our esteemed speakers, participants, and attendees around the world. Here we have participants from many countries. We have participants from Slovenia, Croatia, Montenegro, North Macedonia, Greece, Bulgaria, Romania, Poland, and UK. That this conference will serve as a melting pot of ideas as we discuss some interesting aspects of international. I would like to take this opportunity to express our deepest gratitude to, first of all, EBRD. UNCITRAL, United Nations Commission on International Trade Law, and EBRD, European Bank for Reconstruction and Development. Special thanks also go to our three moderators at this conference. Samira Musayeva from UNCITRAL, Catherine Bridge-Solid from EBRD, and Benjamin Risset from UNCITRAL as well. Last but not least, I have to mention one more person, that's Marko Radovic from Commercial Court in Belgrade. We hope that this conference will be a catalyst for new ideas, maybe some new projects, and why not, enduring friendships. Since we are in Belgrade, it wouldn't be logical just to focus on professional issues. So beyond those academic and professional pursuits, I hope that you will have some time to experience a rich culture and hospitality of Belgrade. Our city offers a unique blend of history, tradition, and modernity. And we are excited to share that with you. In closing, I wish you all a productive and inspiring conference. Thank you, and once again, welcome to our regional cross-border insolvency conference. And now I give floor to Samira Musayeva from UNCITRAL.
As participants, on behalf of UNCITRAL and its secretariat, I would like to welcome you all joining us in person and online to this conference and express our appreciation to the Serbian Bankruptcy Law Association for hosting the event and to the European Bank for Reconstruction and Development for providing significant support as co-organizer. We hope that none of you will be disappointed today. My name is Samira Musayeva. I'm a senior legal officer in the Secretariat of the United Nations Commission on International Trade Law, known with its name as UNCITRAL. I am participating in this conference in my dual capacity as the head of the non-legislative section of the UNCITRAL Secretariat, in charge of technical assistance, capacity building, dissemination, and other promotional activities related to UNCITRAL text, and as a secretary of UNCITRAL Working Group 5 in the area of insolvency law, currently on asset tracing and recovery, and applicable law in insolvency. UNCITRAL was established in the middle of the Cold War in 1966 to remove or reduce disparities in national laws governing international trade. Since then, UNCITRAL has become the core technical expert body in the field of international trade law, successfully bringing this at different stages of development, of different economic and legal traditions and political stances. In discussing the best and widely acceptable solution to issues that the business community faces, states in UNCITRAL, with assistance of invited organizations specializing on issues of commercial law, take apolitical and pragmatic approaches. Since the early 1990s, UNCITRAL has been working on modernization, harmonization, and unification of insolvency law, authoring such texts well known across the world as the 1997 Model on Cross-Border Insolvency, the UNCITRAL Legislative Guide on Insolvency Law, and two more recent model laws, the 2018 Model on Recognition and Enforcement of Insolvency-Related Judgments, and 2019 Model Law on Enterprise Group Insolvency. All of them will be subject of our discussion today, commencing with session 1, which I will moderate. It will discuss cross-border insolvency regulations at the international, regional, and national levels. That session will be followed by a session that will look into cross-border insolvency aspects from the judicial perspective. It will be moderated by a colleague of mine, Benjamin Harriset, a legal officer in the UNCITRAL Secretariat, who, among others, collects and analyzes case law related to UNCITRAL insolvency text. He is therefore well placed to moderate that judges-led session. Catherine Bridge-Solan, who will shortly speak on behalf of EBRD, will moderate session 3 that will focus on practitioners' perspective to cross-border insolvencies. The UNCITRAL Secretariat hopes to learn from each session. This will inform our subsequent activities in the region and beyond, in particular in countries that, like in Balkan countries, are closely connected geographically and in other respects, and are undergoing similar reforms. At the same time, what is interesting in the Balkan region is that it consists of European Union and non-European Union countries, which brings another interesting element of relevance to our work. We will hear during the conference about the KILPRO academic project, which the UNCITRAL supports. We appreciate the focus in that project on the analysis of various possible approaches to regulating cross-border insolvency cases between Union and third countries. The region also consists of countries that have enacted the 1997 model law and that haven't yet done so. We hope that the conference will promote further harmonization of cross-border insolvency frameworks across the Balkans, including by raising awareness about the two most recent model laws. The one on insolvency-related judgments facilitates recognition and enforcement of judgments related to insolvency proceedings that often originate from courts not handling insolvency proceedings. For example, judgments on avoidance, directors' liabilities, or adjudication of creditor claims. The other, on enterprise group insolvency, facilitates the development and recognition of a group insolvency solution across all affected jurisdictions, not only a few. Finally, we hope that the conference will generate the interest of the Balkan states in continued discussion of cross-border insolvency issues affecting the regions in various fora, including in UNCITRAL. We would welcome seeing more Balkan states in UNCITRAL Working Group 5 as member or observer states, which doesn't make much difference in practice. Active participation in that renowned international insolvency law forum is conducive to building local capacity of states to implement sound insolvency law reform and ensures inclusiveness and accessibility of UNCITRAL text. I thank you for your attention, and I'm happy to pass the floor to another co-organizer of the conference, Catherine, please.
Thank you very much, Samira. Good morning, everyone. My name is Catherine Bridge-Soller. I'm a senior counsel at the European Bank for Reconstruction and Development in London, and I lead the work on insolvency and debt restructuring technical assistance. So it's my turn now to welcome you all to today's conference, and I would like to start with expressing my appreciation for our hosts, the Bankruptcy Law Association, and colleagues from UNCITRAL Secretariat who've made this conference possible. It's the first conference that we have organized in the field of insolvency with both organizations, and I am proud of our partnership. I would also like to thank the EBRD's guests, Ms. Novakovic from the Ministry of Justice of Montenegro, Ms. Sokolowski and Ms. Mikovska from the Ministry of Economy of North Macedonia, and Ms. Gaci from the National Agency of Albania for traveling to be here with us in person. The EBRD's Legal Transition Program, to which I belong, is part of the EBRD's efforts to support commercial law reform and capacity building, and to contribute to a better investment climate in regions where EBRD and other international investors invest. We have a broad experience of insolvency reform across many of the jurisdictions where the EBRD operates. We cover 36 economies in total. And in the Balkans, I have had the personal pleasure of working with authorities in Croatia, Greece, Serbia, and Slovenia. I'm particularly proud of the EBRD's long-standing cooperation in Serbia with the Ministry of Economy and the Serbian Bankruptcy Agency, with whom we are working to deliver the 2024 official training program for insolvency practitioners, known in Serbia as bankruptcy administrators. And we hope to also host a few workshops and roundtables for judges together with the Serbian Judicial Training Academy. So as part of the EBRD's Legal Transition Program, we are trying also, together with colleagues at UNCITRAL, to advance the understanding of insolvency systems through research and assessments. And I'm delighted that just in time for today's conference, we have managed to pull together a fact sheet with information on insolvency systems and cross-border insolvency judgments in the Balkans region. We are immensely grateful to our partner of law firms in the region who provide on a pro bono basis contributions to us and to our research and have contributed to this publication. And I understand that there will be a QR code that you'll be able to scan later today. And the Serbian Bankruptcy Law Association have been very good and have printed out also a copy of the publication. So today, I think we are here at an important time to discuss the issue of cross-border insolvency. Trade volumes are increasing, economies are becoming much more integrated, and inevitably there is a risk that there will be some business failures and that business failure and issues will arise, legal issues will arise that span more than one jurisdiction. And I'm delighted that my colleague, EBRD lead economist, Zsoka Koczan, will be here today to give a broader overview. So we have very many interesting conversations ahead, and without further ado, I would like to pass the floor to Samira Musayeva at UNCITRAL to moderate today's first session. Thank you.
Thank you, Catherine. So the first session is on legislative approaches to cross-border insolvencies. The session will last from 9:20, now 9:16, until 11:20, with a short break in between. We hope to have time for Q&A, question and answers, and discussion after speakers' presentations. The session will have two panels. During the first panel, we will cover cross-border insolvency regulation at international and regional levels. Speakers at the second panel will present domestic cross-border insolvency frameworks. In Serbia, Greece, and Poland that enacted UNCITRAL model law on cross-border insolvency, and in Croatia that has a model law compatible regime consisting of 36 articles, as we understand, but which was put in place even before UNCITRAL adopted 1997 model law. But first, we will start with economics, and as Catherine already alerted, our first speaker is Zsoka Koczan, who is a lead economist at the Office of the Chief Economist of the EBRD, the co-organizer of this event. She holds a PhD in economics from the University of Cambridge. Prior to joining the EBRD, Zsoka worked as an economist at the International Monetary Fund on microeconomic developments in the Western Balkans and in the research department on the World Economic Outlook. We asked Zsoka, in the light of her expertise and experience in the region, to set the scene for our substantive discussion today by explaining to us, lawyers mostly, how a sound legal framework for regulating cross-border insolvencies impact in practice trade flows and investment in the Balkans, if at all. We in the UNCITRAL secretariat do not have expertise and resources to handle this type of empirical research and very much rely on and appreciate inputs of multilateral development banks, such as EBRD, in this respect. Giving a dollar sign, so to say, to a cross-border insolvency clearly helps to increase visibility of such a reform, among many other priorities that policymakers and legislators usually face. Zsoka, it's great to have you with us today, and I understand you will have slides that you will administer yourself. So the floor is yours, and you have 15 minutes, please. Thank you.
Good morning, everyone in the room and online. It is really my pleasure to be here, and I'm especially honored to be able to kick off this first session being among the minority in the room. I am an economist, as you heard, so I hope that this will be informative in setting some of the broader importance of insolvency frameworks for cross-border investment. Samira mentioned in her opening remarks that UNCITRAL was set up during the Cold War to facilitate cross-border investments. And this is a topic especially important again today, as we hear a lot of discussions of disruptions to supply chains, of geopolitical fragmentation, which presents threats, but could also present opportunities to some economies, including in the Balkans. Let me start by first looking at why harmonization of insolvency frameworks cross-border is so important. Now, we did a study recently that examined successful growth episodes. So episodes of particularly high growth in countries, and was looking at what sort of country characteristics were correlated with these episodes of high growth. And one of the things that really stood out was the importance of investment. And in emerging markets where savings rates may be low, where including infrastructure needs or needs for investment in education are particularly large, cross-border investments are very important in this respect. However, when investors, the returns and risks of their investments, they often look at what happens at exit. So in some sense, analysis by backward induction. Investment, as we know, in the Balkans. A recent survey we did of households suggests that over 5% of those who are currently in wage employment work for foreign-owned companies. So it's around 10% in Central Europe, which has also seen very significant foreign investment inflows. And this is becoming even more important in a context where investment patterns are often beaded. There has been a lot of discussion of fragmentation, of nearshoring or onshoring to reduce the risks that could come from having longer supply chains or more concentrated supply chains. And this could present opportunities for the region. Now, economists have talked a lot about the importance of governance and institutions in general for attracting investment, alongside, of course, infrastructure and skills on which the Balkans has traditionally been very strong. But specific provisions on cross-border insolvency are crucial in creating certainty that is necessary for trade and investment to support efficient judicial decision-making and also to affect outcomes. Furthermore, it can be a key signal for investors, and harmonization of such insolvency frameworks is especially important for investments into large markets that have, for instance, the market size of China, can afford the fixed costs of hiring specialists who are very in that market. For smaller markets with each other for investments, harmonization can significantly help reduce fixed costs and hence attract investment. To say a few words about some of the empirical evidence that we have so far on the importance of insolvency frameworks for attracting cross-border investment. There have been a number of recent studies, but this is very much still a growing literature. For instance, the one by Klietskova, Sabatier, and Schmidt, which examines OECD indicators on the efficiency of insolvency frameworks, also looks at insolvency frameworks in these economies, broadly speaking, in the 2010s. And what they show is that reforms to insolvency frameworks have a significant effect on cross-border investments to these economies. What could be especially interesting to note here is that this impact is especially pronounced for institutional investors, tend to be more sophisticated and are managing large with what is a much larger literature on the importance in general of transparency, information, and reducing fixed costs, including compliance costs for cross-border investments. And again, this is especially important for smaller, less sophisticated agents, which may not be able to afford the high costs otherwise. What I also thought was interesting to highlight is that frameworks can benefit small and medium-sized enterprises the most. Mentioned earlier the importance of harmonization, especially for small countries, but also within countries, this is especially important for small and medium-sized firms as the supply of bank credit increases, and overall this diversity of investment and supporting the dynamism of entrepreneurs. Well, this is a growing literature, and as you can see, there are some very encouraging results on the importance of frameworks for cross-border investments and the benefits they bring to receiving states. There's, of course, a need for much more research on this, especially for emerging markets and especially for smaller economies, and also a need for further data on the quality of insolvency frameworks. Now, EBRD has been assessing the quality of insolvency frameworks, highlighting large variation across the Balkans and also significant priorities for improvement still. My colleagues in the legal department would be able to say much more on this, so let me return to a little bit more of the broader economic picture. Mentioned earlier that investment is found to be crucial for high growth episodes. So significant investment was found to be associated with a greater likelihood of a country experiencing years of high growth. It also reduces the likelihood of underperformance. And unlike many other beneficial characteristics, such as openness to trade or finance, or in general, the quality of institutions, it was also found to help support longer growth episodes and also a soft landing when coming out of them. Now, in turn, of course, there are preconditions necessary for investment, including infrastructure, skills, but also governance. And as you'll see later on, governance is becoming increasingly important to attract cross-border investment. All of this is especially relevant to hear a lot about geopolitical fragmentation, about the scramble for resources, including the raw materials that are critical for the green transition or for the shift to more digital economies. We have seen growth of export restrictions, as you can see from the chart here, for all products, but especially for critical products that are important for the green transition. All of this presents risks globally and for individual economies, but present opportunities including for smaller economies in the Balkans to leverage new investment relationships as countries try to diversify their supply chains and rely on more suppliers than they used to in the past. Reshoring and nearshoring are being increasingly discussed, and that is literally what you can see in the chart here. This is the frequency words such as nearshoring are mentioned connotation in earnings calls. And these are associated with the shortening of supply chains, so incentives to keep your suppliers closer to home, which again could also present opportunities for some new investment relationships. EBRD did a survey of investment promotion agencies last year because many of these countries are well aware of wanting to attract investment, not just in renewable sectors, but also specifically focusing on the diversification of supply. And when asked which sectors they're targeting, you can see quite a few common threads. Lots of interest in attracting investment into renewables, the research and development, where the Western Balkans, you can also see a desire to attract further investment, for instance, into agribusiness. Now, what do we see to date? A few charts will provide an illustration of some of the foreign direct investment flows that we see to some Balkans economies. This draws on the Financial Times FDI Markets database, a project-level database that is based on announcements, for instance, in newspapers of foreign investments coming in, the estimated number of jobs these are expected to create, as the capital investment in million US dollars. You can see a very diversified picture of foreign direct investment in Serbia, with substantial investments in real estate, in renewable sectors, in the automotive sector, as well as in metals and mining. What I personally found interesting from here is that the picture in terms of job creation is actually much closer to my perception of it than that in terms of capital investments. But nonetheless, this provides significant financing for growth and development. In Montenegro, as you might expect, we see substantial foreign direct investment to sectors such as tourism, but actually also renewables and other power generation. In Albania, significant foreign direct investment into logistics, so transportation and warehousing. Again, renewables stand out as a sector attracting significant FDI inflows over the last decade. Again, quite a bit of employment generation from the automotive sector. Bosnia and Herzegovina, again, quite a diversified profile in terms of substantial investments, not just in real estate and automotives and metals. But now, investors do respond to agencies are often seen as an effective but relatively inexpensive way to attract investment into targeted sectors. And this is in line with earlier findings for emerging markets in general, that indeed foreign investment flows do increase substantially into targeted after relative to before targeting. So those double both for EU member states and for non-EU member states. Turning a little bit to the sources of where investment inflows to the Balkans have been coming from so far. It will be no surprise to you that most of this is coming from the European Union. You can see bits of green here for the UK and the US, some inflows from China recently, and more so for capital investments than for employment created, as these large and capital-intensive projects, but also some inflows from other Balkans economies, and especially for job creation. However, while we all expect the EU to be the main source of foreign direct investment, the top origin of large foreign direct investment inflows actually varies more than I think is often assumed. So for Albania, alongside Italy and Germany, you can see the UK and Korea coming up as top investors. For Bosnia and Herzegovina, increasing investment from China. We see similar patterns in Serbia. What might be interesting here is that in terms of capital investment, longer makes the top 10 investors, though it does for number of jobs created. But personally, outflows of foreign direct investment from Balkans economies mostly stay within the region. And this again highlights that, especially for smaller investors, information is really crucial. And here we see a lot of Italy into neighboring economies. For instance, from Serbia to Bosnia and Herzegovina, we see a bit, especially construction from Albania to North Macedonia, for example. Now, the top cross-border investors tend to be large industrial companies. For instance, you can see quite a bit of automotives here, also metals and household name brands. So the slide is largely here because I always wanted to bring it into an economics presentation at some point. And finally, to end on a more forward-looking note, I mentioned earlier the importance of not just infrastructure, but also skills for attracting foreign direct investment. And its strong skills base has benefited the Balkans tremendously in attracting foreign direct investment inflows over the year or two. However, as economies become more developed, governance and institutions become even more important for continuing to attract investment inflows and for building new investment relationships. So I thought that this would be a good point to end on, to emphasize the importance of cross-border insolvency frameworks in this context. And I will stop here and hand over to the panel. Thank you very much for your attention.
Thank you, Zsoka, for bringing on time, punctually, and also really relevant, predominantly, for our discussion, which is predominantly law-centric discussion, important economic aspects, and sticking to the time allotted to you. I guess even long-term scale, having heard your presentation, should by now that the insolvency law reform, institutional reform, they really do matter for economic development, in particular for the flow of foreign direct investments. Where perhaps more research is needed is on data on mutual benefits of harmonization of cross-border insolvency law frameworks on both originating and receiving states, as you mentioned yourself. Thanks a lot. And now our next speaker is Professor Omar, who is a senior lecturer in the Faculty of Business and Law, and like us, the Montfort Law School, observer to UNCITRAL Working Group 5 for a long time, and the European Commission Expert Group on Restructuring and Insolvency and EBRD. Paul has worked in academia for 20 years and published over 230 books, edited collections, chapters, and articles. Paul has been active in Insol International and also worked for the International Financial Corporation. Paul will lead us to discussion of laws and regulations applicable to cross-border insolvency at the international. At that level, we obviously first think of UNCITRAL, the United Nations body that has been active in regulating insolvency law aspects, including cross-border insolvency since the early 90s. And Omar will introduce the UNCITRAL text in this area of law, and we very much appreciate for your willingness to do so. He prepared some slides, and I understand you will be administering them yourself. And throughout our conference today, we will hear fragments to the text that Paul will describe in his 15-minute presentation. So please pay attention. Thank you.
Thank you very much for that very kind introduction. I would first like to express my gratitude for the invitation to come and speak to you today, particularly to Catherine Bridgezoller and Natalia Pag in Serbia on a training project for insolvency administrators, to Samira, Musayeva, and her colleague Benjamin Herise, who have helped very much in putting together this opportunity to speak to you about the UNCITRAL project. And of course, appreciation goes to our hosts for their very efficient and very kind invitation to be here. And of course, the organization, without which we wouldn't be able to come together and speak on a very, very vital topic. Yeah. So if the slides could come up, thank you. Yeah. Perfect. Good. Okay. They seem to have a mind of their own. Yeah. Okay. Now, where we are in terms of cross-border insolvency is a story that goes back quite some way. We've already heard the economic rationale for having robust cross-border insolvency frameworks, to which I would add the very simple logic seen from a legal perspective that having robust domestic frameworks is insufficient unless you have a bridge to connect them. Because this world is highly globalized, highly interconnected, and the cross-border investments is certainly a strong feature in many, many emerging and developing economies. So it goes without having robust cross-border insolvency frameworks to connect domestic systems to assist the of cross-border insolvencies affecting the same debtor is something that is very, very vital. And UNCITRAL adds to this story, as I said a moment in time. It is a family of initiatives have been carried out variously by the European Union, formerly the Council of Europe, and also UNCITRAL. And UNCITRAL's contribution to the story begins in the early 90s, when, prompted by Insol International, the idea came that a colloquium should be organized in Vienna in 1994, promoted the work that had already been carried out in the heart of the European Union and also in the Council of Europe, that actually forms the basis of most of the texts with which we are familiar today. And that work, which began in the European Union in the 60s, essentially came up with the framework that we have today. So the idea that there is a test to assist us with identifying the proper jurisdiction for the hearing of insolvency cases, the need to coordinate between proceedings with various hierarchies. In the UNCITRAL text, those are the main and non-main proceedings. In the European Union text, those are the main and secondary proceedings. It's also talked to the role of the courts and also that of insolvency practitioners, the representatives of foreign proceedings. Now, what has resulted from this family includes the European Insolvency Regulation of 2000, which was recast or reshaped in 2015. But nonetheless quite important, Istanbul Convention of 1990, which was part of the Council of Europe project, and also the law that we have in front of us today, the Cross-Border Insolvency Model Law of 1997, which is accompanied by a guide to enactment. And so this law is really the foundation stone of UNCITRAL's involvement in insolvency, which began in 1995. And it has been boosted, certainly within the text, by a very innovative chapter 4, which looks to the types of assistance that are possible. So interim relief pending the determination of a request for recognition, relief within the recognition process itself, the preservation of assets, and also the communication and cooperation that then becomes necessary between practitioners and courts that are involved in the administration of insolvencies affecting a common debtor. And the Model Law on Cross-Border Insolvency of 1997 functions exceedingly. It has over 50 adherents. I think the number is now 59, representing some 62 in total, as we saw in the previous presentation. There is a database of case law that is highly useful in showing the trends across the world when it comes to how the model law has been interpreted as it is applied in domestic jurisdictions. So this is a keystone text, and it is gratifying to see that a number of countries in this region have adopted it and are beginning to use it. But it is not the only text that exists in this cross-border insolvency arena. The more recently adopted model law on insolvency related 2018 is designed to assist the functioning of the relief gathering and indeed the recognition process when it comes to the original model law of 1997. But the insolvency-related judgments model law recognizes that the initial phase of proceedings that are happening, not the end of the story when it comes to communication and cooperation between instances or cases that affect debtor. We also have to recognize that cross-border insolvency law rests on a bed of private international law, and this is originally where it began with the works of Hugo de Grotius in the 17th century, like international law. So the hive off or the separation of private international law as being a part of this continuum. And the model law of 2018 is designed to minimize the impediments, which classically have been many, through the creation of a particular process to speed up that recognition of insolvency-related judgments. Not only does it define the judgments that are covered after the commencement of insolvency, in other words, the insolvency case that will be the subject of recognition, and it does so by looking to a set of judgments that are the consequence of these cases or materially associated with, for example, the determination of property rights and so on. Now, the process of the law of 2018 designs is one that essentially tries to avoid the re-examination of the judgment so as not to open up the material again for redetermination as part of the process. Now, the cross-border insolvency framework, as we see, is quite robust. At the moment, the model law on insolvency-related judgments has, I would say, very few adherents, but it is still a work in progress. And it is hoped that in this region that have already seen experience of practice with the 1997 model law will consider the 2018 as a supplement to that framework. But that is not the only contribution that UNCITRAL has made to this arena. There is law in 2019 which addresses more substantive insolvency law matters. It is a model law, and UNCITRAL's unique contribution really to the family of initiatives has been the consensus building approach that UNCITRAL takes in order to put together texts that are or will be acceptable to the various member states of the United Nations. UNCITRAL also has that very wide reach to be able to access the 210 jurisdictions that exist across the world, over a third of whom have now, or nearly a third of whom have now adopted the original model law of 1997. And UNCITRAL's creation here of the model law framework is one that is very respectful of the concerns of member states. So it allows for the transposition of the rules in a way that is domestically, politically, and legally acceptable. And being a model law, and thus not a coercive treaty or convention structure, it is a very flexible approach to have. And the 2019 model law, which addresses enterprise group insolvency, which is the predominant vehicle for cross-border investments, a related group of companies that work together to achieve the investment goals and, of course, the making of profit. So this model law is designed to operate both domestically and with view to the cross-border connections that exist certainly with the enterprise group, typical enterprise group structure. It creates that framework which is ready for adoption. So all model laws are recommended to be adopted as they are. And in particular, the enterprise group insolvency model law defines a set of what it calls planning proceedings as a baseline for participation in group-wide proceedings. The intention here being to achieve as closely as possible the idea of unity of insolvency proceedings and universality, the extension of those proceedings to cover all the assets and transactions of the debtor across the world. And to that end, it creates this concept of the group representative, or persons who are going to represent the group as a whole in determining what outcome there may well be, which in the context of an enterprise group has to be a sale or indeed a global restructuring. And in common with the project, it adds coordination and cooperation between courts in order to further a group-wide solution as a key element within that structure, because without coordination and cooperation, there will be no talking between procedures and no facilitation of group-wide solutions. So whether we are talking about a single debtor or indeed a group of debtors that are commonly facing financial distress, the element of cooperation between practitioners and the courts is vital to secure that global outcome. So UNCITRAL's comes far, having order insolvency and anti-insolvency changes to address the particular situation of enterprise group. UNCITRAL has been extreme in this area. And in particular, I'd like to address two strands of that work. The first is what I call insolvency benchmarking. The idea that there can be an ideal way of conducting insolvency, or a number of ideal ways from which the member states of UNCITRAL can choose the options most suited to the strengths of their economy, the developments, and indeed their legal cultures and history. So the legislative guide, which came very early on, 20 years ago, and has been a continuing project, this is designed to assist the benchmarking of domestic laws. So you open the legislative guide and you open your domestic law next to it, and you go down the list of recommendations and you see essentially whether your domestic law complies with the recommendations that exist. And if it doesn't comply, whether in whole or in part, then that is an opportunity to carry out law reform. So there is a very strong and very useful feature of UNCITRAL's work, which provides those guidelines that are very particularly for emerging and developing nations. Now, the legislative guide itself is quite complex. It contains two parts on substantive rules, which first emerged in 2004, two further parts. In 2010, the third part on enterprise groups, which also explains the work that has resulted in the model law on enterprise group insolvency. In 2019, part 4 on directors' obligations, particularly in what is euphemistically known as the shadow of insolvency. And in 2021, reflecting 5 on micro and small enterprises. And when one realizes that micro and small enterprises of trading forms in many jurisdictions, then addressing the particular needs of MSCs is seen as being vital to actually extending capable and useful insolvency frameworks which will actually reach those who need them. But apart from the legislative guide, the further work that UNCITRAL is currently carrying out, which is also supported by the European Union, as my colleague Miha Zebre will tell you about in a little while, includes a project on asset tracing tools, so asset tracing and recovery, very vital to the work of the insolvency office holder. And again, harking back to the private international law foundations of insolvency, an application of law to discover whether the rules that already exist in private international law to the identification of the status of debtors and to their transactions and their property can be universalized, so that there are common approaches to the identification of the proper law to apply to persons and to property. So that is a brief summary, and it probably misrepresents the very vast work that UNCITRAL is carrying out, but hopefully that will serve as a foundation stone for our further. So with these matters in the background, the discussion can continue. Thank you very much for your attention.
Thank you, Paul, for this overview of UNCITRAL text, both cross-border insolvency, model laws, and also texts that are very relevant for domestic insolvency law, legislative guide with its 5 parts. Just for information of the audience, the Secretariat prepared consolidated text of 3 model laws for those countries that haven't yet enacted model law on cross-border insolvency, that they would be able to enact it maybe in one go. If, for example, states would wish to combine model on cross-border insolvency with model on insolvency-related judgments and enact it as one act rather than one after another. And without further ado, I'm now moving the audience from national level to the regional level. And for the regional level, we have Miha Zebre, Legal and Policy Officer in the Department for Justice and Consumers at the European Commission. He will introduce us to the European Union cross-border insolvency framework. Miha is well known in the UNCITRAL Working Group 5 because he represents the European Commission in negotiating international insolvency text being prepared by UNCITRAL. Miha is joining us online, and we hope that the technology will cooperate and we will not face any connection issues. And we, in fact, to mirror Omar's presentation, how European Union regulates recognition and of foreign insolvency proceedings, and also recognition and enforcement of insolvency-related judgments, and also facilitates resolution of enterprise group insolvencies. He also in his 15-minute presentation to address regulation of post-regulation at the European Union domestic insolvency law issues. I hope, Miha, you will be able to make all of that within 15 minutes. Thanks a lot for joining.
Thank you, Samira. Thank you. I hope you hear me well. First of all, I'm very happy and very honored to be with you online. And apologies for not being able to be there in person. Thank you to all the organizers. I think this conference is extremely important, and I'm going to try to make my part as fast and as interesting as possible. I will provide briefly the outlook of the European Union insolvency framework. And this is a process that has been initiated already 30 years ago. The Europeans have been striving to bring their national insolvency regimes closer and closer for many years now. And this movement, so to speak, is gathering momentum, to be honest, because the underlying rationale for the harmonization that is more and more visible and more pressing is the construction of the Capital Markets Union. And I was very happy to hear from my predecessor from the EBRD how important the harmonization of insolvency rules actually is. This will come very handy, to be honest, for the European Commission, even to support our economic rationale when negotiating the new instrument, of which I will be speaking a little bit later. So the whole aim of this harmonization process is, of course, to reduce costs, to better reallocate resources, and also to encourage cross-border investment, as has been said before, which also has a connection with the financial stability as a whole. And this process that has been now developing for the past 30 years can be, the progress of this harmonization process can actually be detected, because according to the OECD ranking, 16 EU member states are among the 20 countries with the most advanced insolvency regimes, compared with 11 in 2016. So how did it all start? Some of you might remember that insolvency has been exempt from the '68 Brussels Convention, which is historically the pioneer of European private international law. But this exemption wasn't made because insolvency was not deemed to have any relevance to business. On the contrary, it has been seen of such high relevance to cross-border business that it actually required a specific tailor-made regime. But the insolvency regulation, which is a result of the pre-existing work on insolvency convention, so to speak, from 2000, is not the only instrument. We now have the private international law pillar, which is European insolvency regulation. We have the 2019 Restructuring Insolvency Directive. What we sometimes forget to mention are the two directives that protect employees in the event of insolvency of their employer. It's the Directive 2008/94 and Directive 2001/23, which governs the approximation of laws relating to the safeguarding of employees' rights in the event of transfer of undertakings. And last but not least, certain contractual aspects of insolvency can also be considered as a part of Brussels I recast regulation. So this is the existing framework, but the very important strain of work at the European Commission now are the negotiations with member states on the adoption of a brand new instrument which harmonizes certain targeted aspects of insolvency proper, and I'll mention that at the end of my intervention. So if we go back to the European insolvency regulation, this regulation is a typical private international law instrument. The content of the regulation is basically a uniform set of private international law, private international law rules on insolvency. In terms of a normative model, I would categorize European insolvency regulation as an instrument of mitigated universality, so to speak. And as any private international law instrument, of course, the regulation governs jurisdiction, applicable law, and recognition. If we start with the jurisdiction, it comes as no surprise. Of course, it's an old instrument by now. You all know that the core jurisdictional trigger in the European insolvency regulation is the debtor's center of main interest, which means that main proceedings can only be opened by a court in the member state of COMI. The main considerations regarding our interpretation of the center of main interest, of course, first of all, there is a need for autonomous interpretation in line with the general approach of the European Court. But then also what is extremely important is the objectivity of the test and the ascertainability of COMI by third parties. Moving to the applicable law, I will not dwell on the applicable law too long. It should be kept simple. However, there are so many exceptions to the lex fori concursus that the European insolvency regulation carefully studied and introduced exceptions where those exceptions were needed. On On the third part, on the part of the recognition, this is a very important chapter of the regulation. The regulation provides for immediate recognition of judgments concerning the opening, conduct, and closure of insolvency proceedings, which fall within its scope, and also of judgments that are handed down in direct connection with such insolvency proceedings. But so this automatic recognition basically means that the effects attributed to the proceedings by the law of the member state in which the proceedings were opened, those effects extend to all other member states. And this recognition, which is important to stress out, because we are talking about a directly applicable instrument in all EU member states, with the exception of Denmark. The recognition of judgments delivered by the courts of the member states is based on the principle of mutual trust. To that end, the grounds for non-recognition are reduced to the minimum necessary. An important chapter of the European Insolvency Regulation is also the chapter on group insolvency. This was a chapter that was introduced with the recast in 2015, and it basically introduces rules on cooperation and communication between liquidators involved, between courts involved, but also between courts and liquidators. It also provides mutual standing of liquidators in proceedings for other group members, and those group insolvency, the rules on the group insolvency are also subject to review, which will be done in 2027. It's actually quite the date is approaching quite quickly, and of course it will be also interesting to see how the group enterprise insolvency rules, as encompassed in UNCITRAL model law, how those rules live in practice, because we, of course, the European Commission is in constant dialogue with sister organizations and sister institutions, and of course it will be interesting to see what we can learn from the mistakes or the operation of the European Insolvency Regulation, but also what are the first comments coming from UNCITRAL model law. So immediately after the adoption of the European Insolvency Regulation, if I now move further, the European Commission started working on what we now call the Directive on Restructuring and Insolvency. This is the first EU text harmonizing substantive insolvency law. If I have to be very precise here, because we are talking about pre-insolvency, the directive mostly focuses on restructuring procedures. The bulk of the directive sets minimum standards for hybrid restructuring procedures, and the only downside in my view, basically now studying the effects of the transposition, is that the European Restructuring Directive offers harmonization. However, this harmonization is limited because the text of the directive includes multiple options for the implementation. So here, the question is also, when laying down rules, harmonizing rules, one has to be careful how much flexibility remains, because too much flexibility also means that harmonization actually cannot be efficient or effective. So the main considerations for the adoption of the European Restructuring Directive where of course economic, first of all, the adoption is clearly linked to the reduction of costs, lower information and learning costs for cross-border investors, more efficient insolvency proceedings. The directive also has a special chapter on how to improve efficiency of insolvency proceedings, no matter which type of proceedings, be it pre-insolvency or insolvency proper. But also there will clearly be some adjustment of costs for public sector. The restructuring and insolvency directive has several pillars. First pillar is basically the chapter on insolvency prevention mechanism and procedures. Here, what we had particularly high hopes were the provisions on early warning mechanisms, how to detect that the company or entrepreneur is in trouble. And then the second part, as I said, was basically the introduction of a EU harmonized pre-insolvency procedure, a restructuring procedure. And then, of course, a very important chapter are also the provisions on the discharge of debt for individual entrepreneurs, and how to give those entrepreneurs a second chance. Last but not least, as I mentioned, the third big chapter relates to measures to increase efficiency of insolvency proceedings, be it the training of judges, use of electronic means of communication, and also appointment, remuneration, and training of practitioners. We are now in the transposition phase, which the deadlines for the transposition has passed, and all the member states, with the exception of one who hasn't transposed the directive completely, only partially. The member states did their homework, and we are now assessing the correctness, the completeness, and the correctness of the transposition. It is a very long process. And of course, as I said, the flexibility given to member states does not make our lives easier, if I can put it mildly. Looking ahead, of course, I mentioned the most important project of the European Commission for the moment, at least I'm speaking for my own directorate, DG Justice, where I'm coming from. We have started in 2020, 2 years ago already, with the proposal for a directive harmonizing certain aspects of insolvency law. Here, so to speak, this will be the first directive that actually harmonizes the insolvency proper rules in the insolvency, in the liquidation phase even. When I was referring to the first harmonization before with the restructuring directive, this clearly meant only the pre-insolvency phase. But here we picked up, it was not cherry picking, but it was actually a targeted approach of areas of national insolvency regimes where, economically speaking, and speaking from the point of view of efficiency, where the Commission and its expert group, and also where numbers have shown that those chapters or topics require harmonization, and those topics are, first of all, transaction avoidance provisions, the classic clawback actions, we can also call them. We are aiming to introduce pre-pack proceedings as one of the most important chapters of the directive, especially in terms of the preservation of value. Pre-pack proceedings are very well known in several leading jurisdictions in the field of insolvency, and they have proved to be very successful in terms of preservation of value. We also we are also introducing rules on asset tracing and the access to registers, to the beneficial ownership registers and bank registers, but also other registers. A very important chapter of the new proposal is, of course, an introduction of a simplified liquidation proceeding for micro enterprises. And I believe this exhausts my 15 minutes. If I'm correct, I will leave it up to the chair. I'm of course happy to discuss any question in detail. Thank you very much.
Thanks, Miha, a lot for your very comprehensive and informative presentation, and also your willingness to connect online and to share with us the very important European Commission views on the complex issues of harmonization of insolvency law frameworks, both on cross-border insolvency and domestic insolvency law matters. I would suggest that we would take perhaps now a few questions to our panelists in session 1 before moving to session 2. If anyone would like from the audience to put question, please do so. Raise your hand, and I do not know whether there is microphone. If not, then I would exercise my prerogative of the moderator and put questions myself to the panelists. But first, please, the floor is yours, so to say, the audience. Okay, I think in the morning people are still shy and not yet warmed up. So I hope that I will start the ball rolling and questions will come up later. So my first question would be for Zsoka. Look, in the light of all that data that you presented, do you envisage any particular risks of cross-border insolvencies affecting the regions, the Balkans? Because this may in fact put cross-border insolvency law reform higher tasks leaders and policymakers. And my question to Paul will be related to COMI. And we all know that COMI is now under some attack from some academic circles. And what is proposed, do you think it would in fact help to resolve issues arising from COMI? For example, if enterprises would be allowed to define the COMI at the outset of their existence, would this resolve in fact issues with COMI shifts? And another question maybe to you would be, there is, as we heard from Miha, definition of COMI in the European insolvency regulation, but there is no such definition in the model on cross-border insolvencies. There is only presumption of COMI in Article 16.3. Why do you think such a mission was made, and is it helpful? And my questions to Miha would be to, European insolvency regulation recast is due for review in 2027. Which aspects do you think are strong candidates for review at that time? And another question would be, is the European Commission satisfied with the state of regulation of cross-border insolvency between European Union and non-European countries? If not, what is being considered for improvement? And obviously the second question directs to UNCITRAL model laws. and UNCITRAL cross-border insolvency frameworks, but I do not want to prejudice your answer, Miha. But we have indeed selfish interest here to promote UNCITRAL cross-border insolvency framework in this context, EU and third countries. But let's start with Zsoka, if you are ready. Yes.
Thank you very much for the question, which is very relevant on the risk of insolvencies. So taking a broader and more historical view, if we look at how GDP has evolved across the countries where EBRD invests, so emerging Europe, the Caucasus, Central Asia, Turkey, and parts of North Africa, then looking at the last 30 years or so, this region experienced 3 recessions. One in the late 1990s, which was still the transition recession, pointers, and unsurprisingly in 2020 during the COVID-19 crisis. Now, if we look at the previous 2 of these, this was very much at a time when the regions were much less interconnected with each other, including through cross-border investments, than they are today. So foreign direct investment, foreign companies as employers, foreign sources of funding through debt or equity are much more important today than they were before. Advanced Europe has also had, we all know of the recession in Germany, which of course has important implications for the Balkans in particular, given trade and investment links and integration into European supply chains. So I think there, to the extent that these macroeconomic risks were to translate into much slower growth, not just in advanced Europe, but also in the Balkans, the risk of cross-border insolvencies would increase given much higher levels of integration that we have seen during previous crises.
Thank you, Zsoka. And in fact, this confirms our as well understandings of dynamics, economic dynamics in the region, including activities related to Belt and Road Initiative and other major. We hope that this information would be relevant and timely for policymakers and legislators across the region in order to put up the priority list of insolvency law reforms and also cross-border insolvency. I see the question. Is it to Zsoka? Okay. Have Mike? Yeah, coming. Thanks.
Do you hear me now? Excellent. My name is Tomis Lešunka. I'm asset recovery lawyer. One question for Mr. Zebre. What is the approach of European Commission in the cases when sanction and insolvency cross the path? If, for instance, the assets what should be recovered is under the sanction, or if creditor coming from the sanction states or some different, we know that sanctions is instrument of foreign policy, but however, we exist some legal framework. Thank you.
Thank you, Tomislav, for this very provoking question. We will give Miha a little bit of time to digest and prepare, but maybe now for Professor Mark, you will take out those 2 questions that I put to you if you feel comfortable.
Well, I think, okay, Komi, it's always going to be a compromise. Either you choose the location of incorporation or registration, and then the chances are that that's not where reality is happening and that's not where the business activity is being carried out. Or you try to identify where the business activity is being carried out, and then you assert jurisdiction on that basis. So the problem is going to be that most people expect where the entity is incorporated or registered should encompass not just matters of life, but also of potential death. So the choice in the text is for Komi. Now, the criticisms that arise out of Komi are that it is insufficiently precise and it relies on an objective test, which is if other people can see Komi, then that is rationally where the jurisdiction should take place and where the cases should take place. Debate in the case law about, how sufficient is the engagement by creditors? How much knowledge do they have to have? How much information has been given to them, particularly where business entities may have moved their centers of activity? So it relies a lot on this objective test, and it's because its fact doesn't resolve itself into an ascertainable framework of legal rules that will allow for you to predict in every single instance where the case will take place. And because it's factual in nature, because that's the reality of business, people move, people take their assets with them, people invest in other places. Some activity grows, some activity shrinks. A certain jurisdiction on that basis is always going to come up against this factual hurdle, this impediment. But it's the best test that we have at the moment. And I think that the critical issue in all the tests is really about the entry point rather than COVID. Right? The more critical issue, when do we let people into? Is very much on preventive. So at a stage where prior to the formalization of insolvency and the ceasing of payments, that there has to be sufficient distress happening that it warrants, authorizes a case to be opened. There is an imperative, both economic and legal, for an insolvency case to occur, which involves that. It's something that I think we struggle with. Do we do it? Do we do it on a legal basis in satisfying a particular test in a text? Or do we do it on some other basis? In the French 2005 law, they put in that you could access insolvency if you had problems that arose of an economic, financial, and social nature. And by social, what they meant was things that had an impact on the life of the entity itself that might not be insolvency triggering at that point, but which could create a great continuity of that business. So we need to actually be much more flexible when it comes to the entry points into insolvency, rather than worry too much about whether the COBE definition is the right one to use.
Thank you very much for those helpful remarks, which in fact I think adding to our understanding of the discussions. And now I'm moving to Miha. I hope you are up to the task to handle this, but please do so as precisely as possible, because we need to move the session to.
Yes, thank you very much, Samira. And I as much as I appreciate the question from the floor, as I understand, I have 3 questions to answer. I will deal with the first one very quickly. I'm here in the capacity of DG Justice and not trying to avoid the answer. It's clearly the answer would have to be let's say fine-tuned with the services and the institution that is dealing with the sanction, which is the European External Action Service. And without further ado, I don't want to discard the question, which is very relevant, but I cannot provide you the answer on that. The other 2 questions are very interesting. Thank you, Samira, for raising the issues. The European regulation addresses almost exclusively just inner EU relations, and then this insolvency cooperation with non-EU countries is by large left in the hands of the member states. Some of them have opted for the model law as a basis of cooperation with non-EU countries. Others tend to apply the EU regulation to relations with non-EU countries by analogy. And then a third group of countries has no codified approach, which of course renders the cooperation extremely difficult, if not impossible. What adds to the problem is that many insolvent enterprises have business links, subsidiaries, or other property in non-EU countries. So there clearly is a need for a better, more systematic dealing with the global situations. And then you would ask me what are the possible solutions, and some are indeed saying that UNCITRAL model law, unchanged or with certain changes, could be used for relations between EU and the non-EU countries. But others also, for instance, they say that the EU insolvency regulation could be extended to relations with third countries in some modified form or any sort. The third option would be, which is basically more cumbersome, would be concluding separate treaties covering cross-border insolvency matters with non-EU countries. In the end, it will be a political decision. But what I can tell from the past experience that DG Justice, where I work, we take academics and practitioners in the field of insolvency extremely seriously, and any recommendations on this will be thoroughly considered. If I quickly then tackle your last question, what are the candidates for the review? Well, clearly, the biggest problem that we will have to tackle, and I think that the recast of insolvency regulation is the proper place to do so, is the question on how do we reconcile the limitation of the scope of the European insolvency regulation to fully public proceedings, and the fact that the preventive restructuring proceedings are very often carried out in a confidential manner. And here we clearly have a legislative gap that needs to be solved in the course of the revision. But there are also other very pertinent topics, which, of course, the panel knows very well. One is how to adapt, how to modify the rule on rights in rem, or to be more specific, the rule of the effects of the opening of insolvency proceedings on the rights of secured creditors. This is Article 8 of the European Insolvency Regulation. But then a more exotic question for lawyers who are not versed in this crypto world is also, we will have to see how European insolvency regulation deals with crypto assets and whether we need a definition of crypto assets in the European insolvency regulation. So I apologize for being lengthy, but I had I think it was important to elaborate. Thank you.
Well, thank you, Miha, very much for being really straight to the point. I think all answers that we received were very, very helpful, and they, in fact, emphasize, I think, both Paul and also Miha's answers, how important it is now to promote and put in place rescue culture. Yeah, and this again brings us to an insolvency law of UNCITRAL, which the first parts were adopted in 2004. And the reason why UNCITRAL was tasked with preparing this legislative guide was exactly to promote rescue culture, because in many countries at that time and even now, there's just liquidation option. That's it, but not really for preventive options at an early stage of financial distress in order to rehabilitate and ensure successful restructuring. And this is reflected in part 2 of legislative guide for standard business insolvency cases, and in part 5 when we adopted insolvent and small enterprises, we continued that trend and we put similar idea also for micro and small enterprises. Why only larger enterprises should benefit from rescue culture, micro and small enterprises should also benefit. At the same time, being realistic and also acknowledging that not many states have early warning signals and also quick solutions, restructuring solutions for micro and small enterprises. Part 5 also elaborates on effective and efficient liquidation of micro and small enterprises, and also discharge, in order to ensure that micro and small enterprises can integrate quickly into productive activities. And I very much liked, Miha, for that your presentation highlighted how European Commission and UNCITRAL tackles similar issues in parallel. Yeah, it's about for asset tracing and recovery. It's about for micro and small enterprises. So cooperation with the European Commission is very much cherished by us. But not to disappoint Tomislav, we do address issues of sanctions as politically as possible in our current work on asset tracing and recovery. This goes with other issues that may affect asset tracing and recovery when granting relief, for example, public policy exceptions and other things. So we've coordinate and cooperate with Tomislav and also IBA committee on asset tracing and recovery, and very much appreciate this close collaboration and also inputs of Tomislav personally and also for his committee to this project. So I think we would all agree that the session was excellent, and we should and also follow up. Answers were also a round of applause to all of us before we move to session 2. So I know that it's quite overwhelming and challenging to sit straight for 2 hours and listen presentations, but we will go ahead. Please feel free to leave if you need to refresh yourself, etc. We will go ahead with session 2, and I would introduce the panelists of session 2 in one go rather than one after another after speaking of each. We will Radovic from Serbia to the audience, professor at University of Belgrade, Faculty of Law, visiting professor at the Faculty of Economics in the same university. He is also teaching company law, commercial law, bankruptcy law, and European Commission company law in other universities. EU company law, sorry, not European Commission, EU company law, in other universities in the region and beyond, in Croatia, the host country of the UNCITRAL secretariat. He defended his LLM law school and his PhD thesis at the University of Belgrade Faculty of Law. Radovic is the author of numerous monographs and papers on company law, corporate governance, insolvency law, law of takeovers, and commercial law. The next speaker in session 2 would be Jasnica Garašić from Croatia. She is professor at the Faculty of Law in the University of Zagreb. She earned her PhD at the Faculty of the University of Hamburg with a paper on recognition of foreign insolvency proceedings, and she spent 2.5 years at Max Planck Institute for Foreign and Private International Law in Hamburg with scholarship from DAAD. For those who do not know this abbreviation, it stands for the world's largest funding organization for the international exchange of students and researchers located in Germany. As a Fulbright visiting scholar, Professor Garašić did research on international insolvency law at the School of Law of the University of Texas. Professor Garašić represents her panel Working Group 5 and has been re-elected as a rapporteur in that working group since 2019. Together with Professor Alexander Trank from the Kiel University, she leads the project by a group of scholars and legal practitioners from different countries on the European Union, international insolvency law, and third countries, which waves forward, which UNCITRAL officially supports. And I already mentioned and referred to. We will hear insights from that project throughout the conference, and perhaps also in writing from Professor Trank, who cannot be with us in person today, but he's connecting online, and perhaps as well. So The next speaker will be Elina Moustaira from Greece. She is professor of comparative law, member of the deanship of the School of Law at the National and Kapodistrian University of Athens. She holds several positions at that university, including the director of the Department of Director of the LLM International Private Law, Law of International Business, Transactions and Legal Studies, and Deputy Director of the LLM in International and European Legal Studies. Those are in English. She is the first Vice President at International Association of Science and the current member of the International Science Council Nominations Committee and the executive of the Conference on European Restructuring and Insolvency, with its abbreviated name as CIRIL, a prominent Europe-based academic non-governmental organizations invited to UNCITRAL working group sessions. Professor Moustaira is also a member of several other foreign and Hellenic law associations, and she has been delegate of Greece at various governmental experts and diplomatic conferences, and she has presented also papers and taught at law congresses and seminars in many countries, not only in Greece. To that project by Professor Garašić and for Professor Frank, which I referred. And finally, she wrote books, 8 in Greek, 2 in English. The most recent one is International Law, Spring 2019. She is also author of about 200 articles, chapters in collective books, commentary revisions, book reviews. And last but not least, we have with us Judge Kamila Sawicka. She is Chief Specialist at the Department of Commercial Law, Ministry of Justice. Kamila in UNCITRAL Working Group 5, and she cloud reporting case law on model law from Poland. Those who do not know cloud, it's case law on UNCITRAL text, our free online database that collects case law on different UNCITRAL texts. Some may wonder why Poland, not being a Balkan country and not even close to the region, is suddenly on the panel. But we thought it would be healthy to diversify by bringing a perspective of a non-Balkan country in many respects, with many Balkan countries, including as regards its experience with the transition from the planned economy and from the former bloc of socialist countries. So I think with this impressive panel, we are in good now national insolvency, and we would ask Serbia, Radovic to start, please.
Hello again. Serbian modern regulation of international insolvency started in 2004. Before that, we didn't have any specific norms on international bankruptcy. Basically, our Yugoslav laws was that on those matters, we will apply general rules of international private law. In 2004, what we did, we introduced a new chapter, chapter 12, and basically in that chapter, we overtook model law on cross-border insolvency from 1990. So from 2004, we can say model law country. After that, we adopted another law, which is our current law from 2011, law on bankruptcy. I must admit, when we were working on that law, international bankruptcy was not a priority. Other urgent matters to discuss. So international bankruptcy was not a priority. And basically what we did with that law, we just overtook the same provisions from our 2004 law, but with a lot of improvements. So the law is the same, just the language is better. Let's say like that. But our first changes of our current law, changes for 2004, they introduced some new provisions dealing with bank. Here you can see some of those provisions. I didn't want to go all. For example, we introduced international jurisdiction for opening bankruptcy. Let me just clarify why is that so important. Before that, we regulated the following scenario. For example, German main bankruptcy proceeding is open in Germany, and they could recognize that proceeding in Serbia. Or, for example, non-main bankruptcy proceeding in Italy, and it can be recognized in Serbia. But the question was, we can open main or non-main bankruptcy proceeding. We didn't have any rules. Of course, you could say it's normal that you can, but there were no rules in our law on that. So that was kind of a problem. And even in literature, it was emphasized as a problem. That's the reason why we introduced those norms. And you can see also what we did. We defined COMI. By the law, does not define COMI. We overtook that definition from EU regulation, previous EU regulation, from preamble of previous EU regulation. Now it's not in preamble anymore. Now it's an official part of recast from 2015. Then we introduce something like registered seat is presumed to be a COMI. COMI is determined upon facts existing in the moment of filing the request to open bankruptcy proceeding. By the way, this what I have read last, that derived from Susanne Staublitz-Schreiber case, decided European Court of Justice. Why I'm emphasizing this? Because with these changes, we introduced some provisions from union law as well into our international bankruptcy system. They don't contradict with model law provisions. To understand those provisions, of course, some other stuff I will because I have only 10 minutes, so I will be pretty short. Just wanted to emphasize some major problems, but of course. Concrete problems will be dealt in our second and third session. I will focus on some general problems that we have in Serbia in connection with international bank. First problem that is quite obvious. We have rare cases of international bankruptcy, but rare model law cases of international bankruptcy. So our judges do not apply model law provisions very often. That if they don't have cases, they cannot develop some specific knowledge in that field, which is quite consequence. But you should also, of course, this is not for our judges, but for the others, we have a lot of international insolvency cases. But those are not model law cases. We have a lot of international insolvency cases with Montenegro, with Croatia, with Bosnia and Herzegovina, but they are not governed by model law provisions. They are governed by law on succession, by letter. So that's the reason why although our judges have a lot of international insolvency cases, they don't apply our chapter dealing with model law, which is quite strange. And even what is interesting, that would be quite maybe surprising for people who are outside of ex-UK. For example, you can open a main bankruptcy proceeding in Belgrade, and that is a company. And that company has a property in Montenegro, which is quite obvious. It's not very rare. And our bankruptcy trustee can sell that property in Podgorica without any recognition procedure very often. So that can maybe be strange for people coming, let's say, from UK or UNCITRAL EBRD, but taking into consideration that doesn't sound so strange to us. Second problem that I want to emphasize is, of course, our petitioners probably don't know that our law is based on model law, but that's not so important. What is more important is the following. When UNCITRAL decided to adopt model law, didn't just adopt model law. That's only one document, one short document. That document is accompanied by a lot of other documents. Among others is Guide to Enactment. Guide to Enactment is basically not integral part, but it can be seen as a part of model law. I would even say that it is some kind of a short commentary of model law provisions. So for our judges, for our practitioners, it would be very able to read guide to enactment as well as our law. But also you should remember that UNCITRAL has another, some of them mentioned Professor Omar here, one side that can help you understand some issues of generally insolvency law and to a certain extent international insolvency law as well. Third problem deals with cooperation and coordination. In theory, at least, it is very well known that model law from 1997 can be summarized in 4 words: access, recognition, cooperation, and coordination. And if I skip these first 2 and focus just on coordination and action, the idea that came from UNCITRAL is the following. If you want to have an efficient international insolvency proceedings, they must be coordinated, and practitioners, meaning judges, meaning bankruptcy trustees, they must cooperate with each other. That's well, and we would say that's very normal, but for our practitioners and our judges, it's not very easy to apply those norms. What I want to say is the following. Those channels for cooperation are still closed. We haven't opened those channels. That doesn't mean that our judges don't want to cooperate. Just how? Because that's not something that our judges are used to do, to cooperate with a Romanian judge. And now we will talk how to resolve certain issues. Although it sounds perfect from theoretical perspective, in practice, it's not very easy to apply. That's why I emphasize more education from people that are coming from countries that have a lot of experience with these topics, so they can educate us and our practitioners how to cooperate, because they are not aware of the variety of cooperations that can exist and that exist in let's say Western law countries, and even in those UNCITRAL documents you can find a lot of answers to these questions. Fourth problem deals with incomplete international insolvency regulation. When UNCITRAL in 1997 decided to regulate international insolvency, they didn't say, now we will cover everything. Certain very important parts of international, I have told you, so recognition, access, cooperation, coordination. But the problem is, if you have a country like Serbia, Montenegro as well, and some other countries, so we just overtook those provisions in our law. So our international bankruptcy regulation is only model law on 1997. And UNCITRAL did not envision that just to be the option with recognition, okay, in connection with cooperation, but not the whole international insolvency law. That is the reason why we have a lot of loopholes in our regulation of international insolvency. It will be dealt in more extensively in our second session. For example, you can ask a question that was problematic for our we have a lot of problems with non-main bankruptcy proceedings that we call ancillary proceedings. That's not a good translation of non-main bankruptcy. Can we open in Serbia an independent non-main bankruptcy proceeding? We don't have an answer to that question. But what is the answer? It will be done in our second session. The following problem is a problem with bankruptcy to the same group of companies. From time to time, I cannot say that's very frequent, that it happens all the time, but from time to time, there are problems with corporate groups in Serbia. And we had some cases that made a petition to consolidate these proceedings. Plus, to nominate that one insolvency practitioner, one bankruptcy trustee should be nominated proceedings. So for bankruptcy debtors that are belonging to the same corporate group. Of course, our judges, they had to reject those petitions because they are not in accordance with our law on bankruptcy. But I must admit, even our appellate commercial court, they recognize the problem. They cannot solve that problem because they cannot solve the problem if the law is inadequate. But the problem, and even in some of those opinions, they basically said that we know what is the best, but this is what is the law, and we cannot do more than it is written in the law. So, as I can say, that is a problem, and that can be dealt in the future with some amendments of the law. And last problem deals with foreign creditors. Foreign creditors, we must say that they are not adequately protected in Serbia. Why? Because we would say how they are not protected, because in Serbia, each creditor is the same. Equal treatment of creditors, that's a principle of Serbian bankruptcy law, yes. But if you start from that perspective, then it would mean that we are discriminating foreign creditors because they are not in the same position as domestic creditors. European Union, I mean, Professor Garašić, she wrote a lot about that problem. European Union, a lot of dealing with just that question of information to creditors and lodgement of their claims. For example, there's one chapter of their insolvency regulation that regulates only this topic. I will conclude with just my suggestion for the future would be to explore the possibility of adopting these two other model laws that have been developed by UNCITRAL, so model law on insolvency plus model law on recognition and enforcement on insolvency-related judgments. Second, interact with EU insolvency. And I would say that would be my priority, education. So we should know more about international insolvency. Thank you.
Thank you, Professor Radovic, and your presentation emphasized the value of the projects that UNCITRAL Secretariat launches. It's update on cooperation, and Working Group 5 overwhelmingly supported this project. It was prepared in 2009 and mostly from common law jurisdiction perspective. And now the idea is to bring civil law jurisdiction perspective much well of practitioners from those jurisdictions to the updated practice guide. Now we are going straight to Garašić. Yeah. And we are running a little bit of time, and I would appreciate to stick to the allotted time. Thank you.
Hello to everyone. I am very grateful to our organizers for inviting me to be a speaker at this important event, especially to Professor Radovic, Samira, Musayeva, and Benjamin Harrison to be here. Professor Paul Omar already to the UNCITRAL text. So my task is to show you how Croatia stands in relation to UNCITRAL text. So let us start with UNCITRAL model on cross-border insolvency. Of course, Croatia as a member state of the European Union apply European insolvency regulation when insolvency proceedings have been opened in one of the members or when the assets of our is in one of the member states, or we have a foreign creditors who is in member states. But when we spoke about autonomous, Croatian autonomous international insolvency law, then I have to say that actually there is no need for Croatia to implement UNCITRAL because we have very developed rules on international insolvency law since 1996 that actually contains all essential rules that are contained in insolvency. In 1996, we put in our Bankruptcy Act a special chapter on international insolvency law. It has over 35 articles that regulate all important issues in connection with international insolvency law. And we have a new Bankruptcy Act 2015, and we didn't change anything in this chapter, only now it is chapter 11. There is no need to implement because, you know, UNCITRAL model law and Croatian Bankruptcy Act, they are both based on the principle of universalism. It means that we in Croatia are very open to cooperation and to recognition of foreign insolvency proceedings. We have the same preconditions for recognition of foreign insolvency proceedings, qualification of foreign proceedings, international jurisdiction for the opening of insolvency proceedings. Foreign decision has to be efficient under the law where insolvency proceedings have been opened, and public policy, that's the same. Also, COMI is this international jurisdiction. UNCITRAL model law, as Professor Vukovic emphasized, does not have a rule on direct international jurisdiction, but of course we put it in our law. We have formal proceedings for recognition as UNCITRAL model, but we also have a possibility to decide on a recognition of foreign insolvency proceedings as a preliminary rulings. So, for example, when there is in Croatia only one litigation, when we have a foreign having a litigation in Croatia, and there is no other creditors in Croatia, there is no need to, to have a formal proceedings because it costs. And then there is possibility for the judge to recognize things as a preliminary question. So it is also the question of economy. Further, there is possibility to open not only main but also non-main proceedings, not only after the recognition but also recognition, so particular and secondary proceedings. We have very detailed rules on cooperation courts and foreign representatives. So everything what is in model law we also have here, but also, for example, we give to the foreign insolvency representative even more authorities that it has under UNCITRAL model law. Then coordination between insolvency representatives, it is also very, and we have legal effects that are very precise. Unfortunately, UNCITRAL model law does not have applicable law, and that's the quite difference between Croatian model law. And for example, UNCITRAL assets insolvency state between the period of the opening of foreign insolvency proceedings and its recognizing in other countries. We have rules on that too, so that it is also covered, because that's very important period. And formal proceedings is very regulated. We know exactly who can ask for the recognition, needed for recognition, what the court does, what are legal remedies against the decision on recognizing or refusal of recognition. So it is really in connection with legal predictability and certainty. And for example, we also have hot rules. We have the model law, but for example, it is differently solved. For example, according to the UNCITRAL model law, the judge can give relief after recognition, and it is authorized to take into account interests of certain groups of creditors. For us, it is a little bit not sufficient precise, but what we have, for example, protect our workers in the case when we do not open insolvency proceedings. Foreign insolvency proceedings foreign insolvency representative cannot from Croatia without satisfy the claim of the employees first. And for example, the same is with the claims, with the public claims, claims of the states and the pensions funds and funds for health insurance. Why it is important? In international practice, if you don't have a rule that foreign public claims, they can only be filed. Therefore, European insolvency regulation has a special rule on that, and such rules that protect and weaker party. And okay, so let us go to model law on insolvency-related judgments. We have only one article, European insolvency regulation, and basically we apply rules on recognition decision to open insolvency proceedings on insolvency-related judgments. Of course, it will be better if we would have more precise rules. Therefore, model law on insolvency-related judgments should take into consideration and regulate more precise these questions. When it comes to the enterprise group insolvency, as you know, Bankruptcy Act does not have any rules on enterprise group, but we have a special act. Some of them for sure heard about that. It is Act on Procedure of Extraordinary Management in Companies of Systematic. You probably heard for Agrokor companies and insolvency proceedings in connection with that. Unfortunately, it didn't take into consideration a recommendation that are in answer to legislative guide. For example, we put in these proceedings in not only insolvent members of the corporation. It's not possible because we destroy trust that the creators of solvent companies have. And also in the text of that act, it is open so that actually substantive consolidation is possible. And we know, according to the legislative act, that substantive consolidation is only possible when the assets is so mixed between the groups of the members of the corporation group that you cannot distinguish which assets belongs to which. So there are a lot of issues with this act. I was really against such act, but of course we will discuss it later in the afternoon. I speak only from the position of the text. So what happened in the practice, you will hear today afternoon. So when it comes to the legislating guide, I will not go into details. We incorporated part 1 and 2 for many decades, even before. And I will only emphasize that Croatia, as all from Yugoslavia, have insolvency law also during other socialistic states usually didn't have insolvency law. So we have a very long tradition of insolvency law in this region. So to conclude, I would say all important solutions in legislative guidance, insolvency law, and in model law are in our creation international insolvency law, but we should see this other model law on insolvency-related judgments, on enterprise groups, and part 3, 4, and 5 of a legislative guide. And of course, what is the most problem with the international insolvency law? It's not sufficient knowledge, as my colleague Professor Vukovic said. In Croatia, we tried to educate our insolvency practitioners. We in workshops for them, also in Judicial Academy. Recently, we have a workshop on international insolvency law, specifically on European insolvency regulation. So in order to enhance consciousness about international law, because very often in the practice, it is not recognized that we have international moment. Therefore, I think also, as Professor Vukovic said, it will be very important maybe to organize maybe joint workshops for our judges and workshops for insolvency representatives in the region, so that this cooperation and coordination would be much better. Thank you.
Educational presentation, at least for us, giving comparative overview of Croatian law and model law, and also we very much welcome interest in Croatia for two other model laws, and enactment of at least some features of those model laws will our model law enacting states, and this would be very much welcome. I would now go straight to Professor Moustaira, please.
Thank you. Thank you very much. And thank you, Serbian Association of Bankruptcy Law. And I thank UNCITRAL and EBRD for the very honorable invitation. I'm very happy to be here to speak to you about Greece and international insolvency law and UNCITRAL model law. Let me say that when I started, my PhD some decades ago, it was about international insolvency law, about the equality of creditors in international insolvency law. And I was thrilled and at the same time a bit afraid, no, not much, but thrilled about the complexity and the interest that all these issues had. And not so many people back then were reading and writing about that. And it was a fresh field and a fresh field with many bankruptcies already, but the problems that are always created always interest me, and I never stopped loving that topic. So I see that since so many years, Greece was one of the countries which had no problem in recognizing foreign insolvencies. She was always doing that when the requirements of a general article in the Code of Civil Procedure were met about the foreign decision, I mean, and she was willing to recognize and let the application of a foreign lex for concursus do the work, if I may say that. And I had noticed back then, and I still notice that many countries were not willing to recognize foreign insolvencies and recognize the validity of the foreign lex for concursus, but on the contrary, they wanted their own insolvencies to be recognized abroad and the insolvency law as lex for concursus to be applied on everything that concerned the insolvency that had been opened in their own territory. Country. I'm sorry, it was the air condition which made my throat like that. So then I had read about the works that already the works in European communities back then. So they were insolvency of bankruptcy. It was excluded from the Brussels Convention of 1968. And the work started, and the works kept going on. And it was not possible to accept a solution that could have a result that would be admissible to all countries. The first very ambitious draft convention was about bankruptcy, which would be recognized everywhere in all the countries of the European communities, and the lex for concursus would be applied would be valid and applied everywhere. So that was the system, that is a system of the absolute universality. But they would not accept the members, the member yet, were not willing to accept that. So things changed, the time passed by, and they settled for a compromise. And this compromise was the mitigated, as it was mentioned, or modified, as it is also called, universality, which means one main insolvent or one or more secondary insolvency proceedings dependent on insolvency proceeding. And again, we reached 1995 when the convention with this program was adopted, the European Convention, and was never enforced, was never it never entered into force because United Kingdom did not sign the convention. So this convention, almost tale quale, almost as it was, became the first regulation. So all these years, there were very many decisions in all these countries of the European communities and then European Union, and the countries became more. And Greece, for Greece, it was very easy to accept the regulation, the first regulation, 1346 of 2000, because she was already, I mean, my country, we were already willing to recognize the foreign, we were willing to recognize more than was decided in the European regulation. No main and then the secondary, but exactly the weight. But anyway, we were ready to work as a European regulation ordered, and we were at the same time considering after 1997, we were considering the possibility to adopt the UNCITRAL model law, and you will say why? Because it would give a frame to the judges, to the practitioners, so they would be more certain about what to do when such a case would happen. And since UNCITRAL and European Convention of the 1995, as I said, and then the regulation were somehow working well, and some representatives of countries were the same in both works. So the issues were known, and center of main interest was one of them. This famous COMI, this famous acronym, which has still so many discussions and so much dispute about it. And why? Because, as we say let me say that in private international law, especially in European, in most European, if not all European countries, the rules of private international law that concern the applicable law, we say that they are neutral. We do not know from the beginning which law will be applicable. On the contrary, in insolvency matters, insolvency matters is one of the very, very few issues where there is this Gleichlauf, as Germans say. When we know the court, we know the applicable law. So lex fori concursus right away. All the countries want that, but not all the countries want the foreign lex fori concursus to be applied on the assets that are in their own territories. So, so that's why the modified universality was adopted by the European regulation and by the UNCITRAL model law, which does not have anything about the applicable law, but has much to do with that indirectly. So in 2010, we adopted with the law 3.8, we adopted the UNCITRAL model law of 1997, And at the beginning, we the scholars mostly, and the judges, not so often because there's not much case law either about the European regulation or about the or about the law that adopted the model law. But at first, we were concerned about especially the cooperation, as was already mentioned, the cooperation between the judges, because the first regulation had an Article 31, which was referring to the cooperative insolvency administrators, as they were called in that regulation, insolvency practitioners in the regulation 848 of 2015. So, and they were concerned how that cooperation would coexist with the UNCITRAL model law, with the law 3858, which ordered that there should be a cooperation between judges too, not only between insolvency practitioners. And this cooperation of judges, I fully understand that it's difficult to realize because it was somehow a proposal, the whole model law. I'm sorry, I have to say that it is mostly US oriented, US law oriented. So in USA, it is easy for them, for the judges to cooperate because they have more discretion and because they have a different legal system generally speaking. But things went smoothly, and so we managed to do that, and we see that there is no problem. One of the most important problems, according to my opinion, and it was already mentioned that too by my colleague Professor Radovic, is that we need more education about everything. Students, yes, I know. 1 minute. Thank you. Students, judges, and legal scholars. So I'm happy that I teach since many years. I write and read and write, but I also teach Erasmus students and also Greek students in the pre-graduate studies, but also since 5 years in the English LLM, in which I am deputy director. I teach international insolvency law, so I always tell them, so you will be among the ones who will know more about, if you become judges or lawyers or whatever, or academics, you will be able to handle all these issues, which are difficult but fascinating. Thank you.
Thank you, Professor, for giving us this tour that Greece, faced when finally in 2010 decided to enact a model law on cross-border insolvency. And your presentation again emphasized the approaches to practical realities on the ground. And for this is what exactly underpins UNCITRAL work in many areas of law, including cross-border insolvency. Now, Judge Sawicka has a very challenging task to conclude session 2 and the entire panel 1. But we would not ask you to do it within 1 minute. We were supposed to adjourn 11:20. So please your valuable slides, and I hope that the audience will be patient enough to stay a little bit longer before we adjourn for the lunch. Thank you.
Thank you. Good morning, ladies and gentlemen. It's a pleasure to be the part of this event. I'm aware that I'm the last one standing between you and the break, so I will try to be quick as possible. So the topic of this presentation is model laws concerning insolvency proceedings Polish experience. I focus on three major issues. I begin with how Poland implemented model law on cross-border insolvency. Then I will mention ML CBI application in the last 5 years. And I'll end with plans that we have in Poland concerning implementation of other model laws. So the model law on cross-border insolvency was introduced in Poland in 2015 when restructuring law was introduced. The enactment in Poland in 2003 was part of a broader initiative to model national trade law. Emphasized that MLCBI was designed to assist countries in developing a modern and fair insolvency framework. And Poland's adoption on the MLC influenced by the fact that Poland needs fair and efficient administration when preparing for its accession to the European Union, which took place in 2004. It was needed to align with international standards and handling cross-border insolvency cases and provide legal certainty for trade and investments in Poland. So after that, it was the restructuring proceedings were regulated. And when it comes to the international restructuring proceedings, the topic was limited only to three concerning national jurisdiction, the rights of foreign creditors, and international cooperation of judges, commissioners, judicial supervisors, and administrators. It was due to the fact that, as we are all aware, in relation to foreign proceedings, it sometimes can be difficult to clearly whether they are bankruptcy proceedings. So it was our that separate rules for recognition on the beginning of the insolvency proceedings and the opening of restructuring proceedings did not seem appropriate in that topic. So to respect the procedural consequences of insolvency in another country, it is necessary to recognize the decision to initiate a foreign insolvency proceeding within proceeding before a Polish court. And the amendment bill provides for the restoration of the principle of judgments in the place of the principle of foreign bankruptcy proceedings, which was unknown to the Polish legal system and caused many doctrinal discussion. But at the same time, however, the issuance of a decision on recognition of a judgment on the initiation of foreign insolvency proceedings means automatic recognition of all judgments in the course of these proceedings. Then in 2015, instead of the jurisdictional connecting clause at the time the debtor center of main business, a different jurisdictional link was introduced, which concerned the location of debtor center of main interest, that was mentioned here before. The term the debtor center of main interest was defined at the same way as in the EU regulation. We need to ensure the necessary uniformity of the standards of the jurisdictional norms and allows the use of the Tribunal of Justice. The need to change the jurisdictional connecting factor was also a result of the introduction of consumer bankruptcy in Poland. For obvious reason, in natural person who does not conduct the business activity, it is not possible to identify the connecting factor in the form of the main center of the debtor's business activity. And another amendment that was also important was taking into account the jurisprudence of the Court of Justice of the Europe, especially Polska. The new provision clearly determined that to appoint an agent for service in Poland applies only to a creditor who does not have a place of residence in Poland or in another member state of the European Union. So in the last 5 years, Polish courts have received 35 applications of decision to initiate a foreign insolvency proceeding. We are observing an upward trend in the number of proceedings. 12 motions were being registered in 2023, which may be caused by the growing legal awareness of the society, as well as changes in the international economic and political situations, such as Brexit. We are currently discussing the need and feasibility to implementing two other model laws in Polish legal system. I'm talking about model law on enterprise group insolvency and model law on recognition and reinforcement of insolvency-related judgments. The proposal of implementation, the approval of vehicles. It was pointed out that the introduction of this regulation would increasing the sense of security of foreign investors, which could have a significant impact on the growth of foreign investments in Poland. It was also pointed out that the most urgent legislative changes require the introduction of a separate regulation on the cross-border groups of companies. During this consultation that we made, highlighted that the introduction of a separate regulation for cross-border groups of companies aimed at creating a system that guarantees an appropriate and coordinated. It is needed to treat the member of a group as a whole, thereby achieve an effective conduct of insolvency or restructuring proceedings. Insolvency proceedings may be perceived as significant added value, especially in view of the intensification of cross-border economic relations. We should bear in mind that obtaining real protection of the group members is particularly important to conduct restructuring proceedings and agree on the moment of the opening of the restructuring proceedings by all related entities. So when it comes to the second model law, which is recognition and enforcement of judgments, the decision was also made. It was emphasized that the solution current the Polish law in that field appeared to be merely adequate and already reflecting the recommendation of the model law. Therefore, Poland needs only slight changes in the current system. We were discussing the need to consider supplementing of the ground for refusal to recognize a foreign insolvency award, not only when the jurisdiction of Polish court is exclusive, but also when the jurisdiction of courts of other member states is exclusive. With regard to the recognition and enforcement of foreign insolvency-related judgments, we also discussed that the basic issue seems to be the definition of the concept of a judgment related to bankruptcy proceedings, which should be recognized in Poland. The introduction of an effective public policy clause also remains an important issue. There is a public policy clause exception in both model laws. At the same time, the guide to enactment rightly points out that the scope of the interpretation of the public policy clause in different jurisdictions may be narrow and concerning matters of fundamental importance or broad and in aspects of due process. Therefore, an arises what should be under the purpose of Polish and community insolvency law. Last but not least, from December 1st, 2021, there was complete digitalization of bankruptcy and restructuring proceedings in Poland. The cross-border insolvency cases are also digitalized. So when we are discussing the need of implementing two other model laws in Poland, we should bear in mind that it requires not only legislation, but also changes and coordination with electronic system. With all this in mind, it seems that the implementation of the model law will not be an easy task, but it can contribute to improving of the insolvency and economic system. I try to be quick, thank you.
Thank you for taking this forward-looking approach to insolvency law reform. This is excellent. And I'm sorry I misspoke. We will adjourn not for lunch, but for a short break, maybe 10 minutes. We are running late. However, I think we would still allow some time for questions to session 2 panelists, because I think we really should the presence of such distinguished panel with much experience, in fact, implementing insolvency law reform for domestic jurisdictions. And this dialogue and exchange of views are quite fascinating, educational for us in the University. I'm opening now for the floor for questions. I understand that many exhausted and look forward to leave this route. I will again put some to panelists, but first, please, the floor is yours. Please, yes. Could we have mic, please?
Thank you. My name is Nikola Stojkovic. I'm at law from Belgrade. And I do not have a question, more a remark in relation to the Serbian part of the judicial overview, and particularly in relation to issues listed. And this, I would like to add one additional issue from the perspective of a legal practitioner more than a court. And that is the issue of implementation and enforcement of the recognition decisions, because as a practitioner, I had an opportunity to represent a foreign debtor in recognition procedure in Serbia. And although we received a decision of the commercial court in Belgrade fairly quickly, I had, I must admit, a very, very rough time in enforcing this decision before the Serbian other bodies, particularly with the Serbian Business Registration Agency and the National Bank, because nobody actually was familiar there with the foreign insolvency recognition procedures, and they didn't have tools. And then the entire procedure turned into a chase with the National Bank and with a number of bailiffs who already started enforcements, although one of the outcomes of the recognition is immediate termination of enforcement proceedings. So I would like to add as an issue and something that needs a systematic solution to automatically enforce recognition of foreign insolvencies in Serbia, like it is the case with domestic insolvencies. Thank you.
Thank you for your very valuable insight as a practitioner. Any other comments, questions to the panelists from the floor? No? Okay, then I will put the same, in fact, questions to them, to all panelists and of session 2, and please feel free to answer or skip as you wish. The first one would be with reference to the current work of UNCITRAL Working Group 5 on asset tracing, recovery and applicable law in insolvency proceeding, significance for your jurisdictions. Some of you have already highlighted and some haven't. So this would be very valuable for us as a takeaway from this conference, how valuable and relevant you see it to the current needs in your jurisdictions of these two projects on asset tracing and recovery in insolvency proceedings, and also on applicable law in insolvency proceedings. And the second question, also relevant to all panelists of session 2, would be, what do you think would influence the next wave of insolvency law reforms in your jurisdictions? What would you identify as one or two major triggers, yeah, for the next wave? We know that insolvency law reform and any law reform is never-ending process. There are always waves. Yeah, so please, those two questions. First, the relevance of asset tracing and recovery and applicable law for insolvency proceedings to the needs in your jurisdictions, and second, major triggers of the next wave of insolvency law reform in your countries. Thanks.
Thank you very
Who would
much,
like-
Samira, for the valuable insight and for the excellent moderation.
But Natalia, we are not yet done. We are now collecting answers. So who wants to start? Yeah, please.
Okay, I will be very short. Considering applicable law, we in Serbia, we have only one provision dealing with applicable law. Basically, we proclaim as a basic principle ex fori concursus, but without any explanation what this meant. And we have only two exceptions from that rule, which are only basic exceptions connected with labor law and securities. So that project would be very valuable for Serbia, that's for sure. And considering second question, it's a tougher one. I would say that consumer bankruptcy would be our priority at this point. Because we don't recognize consumer bankruptcy, so consumers are, and even entrepreneurs, they're not bankruptcy debtors in Serbia. So maybe consumer bankruptcy is something that we will introduce in next years.
Yeah. The second, consumer bankruptcy is not something that UNCITRAL is dealing with. However, I think our work on micro and small enterprises covers individual entrepreneurs, and we, in fact, have so much parallel between our work on micro and small enterprises and consumer insolvency. So we hope you will find our text relevant. Anyone else? Professor Garašić, please.
When it comes to applicable law, as I said, we already have rules on this, so it will be not necessary. Maybe one of two exceptions that are that will be provided in future UNCITRAL model law, applicable law. But I think one of the most important tasks for Croatian legislature is to regulate enterprise group insolvency, because there is a need for that in the practice. And yes, I think that's the most important issue. And maybe if I can add, you know, we all have this goal that states in the world have regulated international insolvency law. So maybe it would be good if UNCITRAL would put also on its list the states that have regulated insolvency law, but not with exact rules as in the UNCITRAL model law. As long as they have the same solution, maybe it would be good to include that in that list, because it is then some kind of securement for investors. Because model law is not convention, so we should allow to the creators in the states to express the same ideas with different words and maybe rules in another order, but the essence is the same, as UNCITRAL model law has a huge impact on all states in the world, and UNCITRAL, of course, has this same goal that we have developed in the national insolvency law.
Thank you very much for this helpful suggestion. In fact, we already expanded the wording in our status pages. Before, the wording read that states that enacted model law, and then the list followed. Now we have broader one. So not only those used it as a basis for enactment, but also those that were influenced. And perhaps on the basis of your comparative analysis and using you as the authority from Croatia, we will add Croatia to the list, and we will soon reach 60 states, which would be quite an achievement in a short run. Yeah. So thanks a lot for your answers. Anyone else? I do not want to impose, but please.
So just one remark, maybe we need more training and training programs, because it is my view that not everybody, including judges, including insolvency practitioners, are aware that the model law are existing, that they were implemented, and what they do to the country and what they do to the national jurisdiction to improve the possibility of coordinating and general overlook approach. So this is what we need to promote the model laws and its existence. Thank you.
Yes, thank you very much for that feedback. This is directly relevant to the UNCITRAL Secretariat. We do need, I think, to intensify educational awareness raising program. Professor Moustaira, would you like to answer those two questions that I put, or we would skip you? If not, then we would. I would give the floor to Natalia to conclude. Yeah. Okay. Thank you, Natalia, please.
Thank you very much, Samira. I would like to thank every single speaker from session 1 for the valuable insights and presentations. Although it's not in the official program, I would propose to have a 5 to 10 minutes break before we proceed with session 2. I would encourage you to stay in the room and just take the we have just heard from the speakers. And I would also like to kindly remind you that there are interpretation devices at the entrance of the room for people who would like to hear in Serbian or in English for the second session. So now we'll pass to session 2 on judicial perspective on cross-border insolvencies in the bulk created by Mr. Benjamin Harriset, legal officer at the UNCITRAL Secretariat. Benjamin, the floor is yours.
Many thanks, Natalia, and good afternoon, everyone. I'm really glad to be moderating this panel today, dedicated to the judicial on cross-border insolvency in the Balkans region. We have an impressive and also a very gender-balanced panel today, with judges present to share their views on this very critical issue. And I will first introduce all of them before starting the conversation. We are running a little bit late, but we will accommodate, and I hope we will have a very lively discussion. So to the left, we have Mr. Miodrag Radovic from Slovenia, who is a very seasoned judge, and he's actually since February 2023, the president of the Supreme Court of Slovenia. And he's also an expert in the field of insolvency law. He's a member or founding member of various institutions, such as the International Insolvency Institute, Insol Europe, Insol International. He used to be at Group 5 on insolvency law. To my left, we have Ms. Nicoleta Anastasie from Romania. She's a member of Bucharest Bar of insolvency practitioners. But before that, she has been during 18 years sitting judge at the Bucharest Tribunal. And she has gained a significant experience in insolvency and commercial disputes, but also in company crisis, restructuring, private international law issues. To my right, we have from Croatia. She has been a sitting judge for 14 years at the Commercial Court of Dubrovnik and Split. And she has been dealing extensively with insolvency law cases and also commercial law cases. She's also a lecturer on insolvency law at the Judicial Academy in Zagreb and in the regional center. To the right, we have Ms. Daniela Fukcevic from Montenegro. She's also a sitting judge at the Court of Appeal of Montenegro since 2022. And before that, she used to be a judge in other tribunals in the country. And before that, she also used to work in the Central Bank of Montenegro. And finally, to the far right, we have Mr. Marko Radovic from Serbia, who is currently serving at the Commercial Court of Belgrade since 4 years already. And before that, he used to serve in various other posts, including cassation in Belgrade. And I would specifically add that he's actually the person who launched the idea of this conference, and I would like to warmly thank him for that. And now I will start with our panelists. Could you tell us what is the experience of courts in your country with recognition of foreign proceedings, and specifically trends and recurring to our witnessings in cross-border insolvency cases being litigated in your jurisdiction. And I will have to warn you. I know you are used to preside over debates in your courts, or you used to do that. But here I am the one mastering the time, and we agreed on 4 minutes each answers. So I will have to cut you off if you do not comply with that rule. But without further ado, I will ask Miodrag to start from Slovenia. Thank you.
Dobar dan, pozdrav svima. Rešio sam da pričam na srpskom jeziku tako da možete svi da razumete. Najprej bih iskoristio priliku da zahvalim kolegama Vuku Radoviću i naročito Marku Radoviću koji me ubedio da učestvujem na konferenciji, a za organizatorima koji su nam dali priliku da se sastanemo i da izmenimo iskustva iz regiona. Što se Slovenije tiče, na početku treba napomenuti da treba imati u vidu da je Slovenija mala država. Ima jedva 2 miliona stanovnika. Znači i njena ekonomska snaga je ograničena. Ne mogu da kažem da je to ekonomski snažna država, ali to je i to treba imati u vidu, jer Slovenija nema puno postupaka sa elementom prekograničnosti. Ima neke sporove sa graničnim državama koji se uglavnom na radove koji se izvode u građevini ili autoputevi. I većina tih postupaka su supsidijarni postupci, teritorijalni postupci, znači nije Slovenija država u kojoj se otvara glavni postupak. Mi nismo neka porezka oaza, niti na primjer oaza u kojoj bi bili postupci reorganizacije ili stečaja brzi i jako jednostavni, jer sledimo regulativi Evropske unije i uredbi Evropske unije o postupcima zbog insolventnosti. Za Sloveniju je karakteristično small business, znači manji poslovi i family business, to je porodični biznis, javni biznisi, tako da u tim postupcima ne dolazi puno do izražaja međunarodni element. Jedini slučaj koji je onako, kako da kažem, landmark decision, koji je značajniji, koji je bio onako i predmet debate i rasprave, to je bio Agrokor case iz 2008. U tom predmetu ja sam bio judge raporter, znači onaj koji je podnosio izveštaj veću koje je odlučilo u tom predmetu. U tom predmetu možda nije toliko interesantno da je bio spor između Republike Slovenije i Republike Hrvatske u vezi priznavanja odluke Hrvatskog suda o postupku prve. Taj postupak se nije priznao u Sloveniji iz više razloga. Jedan od razloga je bio da se po našoj proceni, jer važni su učinci priznanja državi Sloveniji, nije vodio u interesu svih povjerilaca, bilo je prekršeno pravilo jednakog tretmana povjerilaca koji su u odnosu na druge u jednakoj poziciji i ocenili smo da interes tog postupka, svrha tog postupka nije prvenstveno prestrukturiranje ili likvidacija, nego je neka intervencija, zaštita države i određenih kompanija. Iz toga smo zaključili da priznanje toga postupka nije u skladu sa javnim redom i interesom Republike Slovenije. Što je bilo interesantnije u tom predmetu je to bio predmet koji nije bio samo u Sloveniji, nego se je dešavao i drugim državama. Tako je, na primjer, taj postupak bio priznat u Kraljevini Velike Britanije i Severne Irske, to je bivša država članica EU. Bio je priznat, na primjer, u Švajcarskoj koja nije članica EU, a nisu ga priznale države iz regiona, Crna Gora i Bosna i Hercegovina. To ukazuje da, na šta ukazuje to? Da su se različita pravna uređenja, različiti pravni sistemi bavili tim problemom. U Sloveniji mi nismo direktno usvojili modelo i ostale UNCITRALove dokumente kao takve, nego smo ih inkorporirali u naš zakon. A pri tumačenju odredbi toga zakona jako važno je polazna tačka, da se uzima u obzir njihov međunarodni izvor, znači da su to međunarodni dokumenti. Drugo, da je treba imati u vidu interes njihove jedinstvene upotrebe, da je to harmonizirano uređenje upotreba u okviru regiona ili Europe ili šire i svakako treba uzeti u obzir uzajamno poverenje kod sklapanja poslova i rješavanja sporova. Ja mislim da sam u vremenu zaključio, tako da zahvaljujem za sad.
Many thanks, and yes, it's all good regarding time. So thank you very much for this very informative information already. And now, Nicoleta, you have the floor to present the Romanian perspective. Thank you.
I'm honored to be here, to be invited at the conference. What to say about Romania? For EU countries, we have EU regulation 848. For non-EU countries, we adopted UNCITRAL model law, MLCBI. And I'm glad to say that I made an evaluation of case law. And in the last 5 years, I could found more than 50 cases, cross-border cases involving EU and non-EU countries. 34 are already translated with abstract in Romanian, and more than 15 are translated with abstract in English. You can find them, and 2 of them are in UNCITRAL cloud, and I'm very proud of that situation. Of course, I cannot speak about all 50 cases. I'm trying to make some summaries of case law related to non-EU countries. And I will speak, if I have time, about arbitration, public policy, automatic stay creditors. And in this respect, a first case I would like to present, it's a recent one, an application for opening insolvency proceedings filed by Ukrainian company against a company with Komi. I will say directly Komi because we don't have time for additional explanations. With Komi in Romania, it was involved, they were involved discussions about exclusive jurisdictions, and the debtor said Romanian courts has no jurisdiction, and the Romanian judge established that an arbitration agreement in the contract of sale conducting between parties cannot have any effect for the opening insolvency proceedings, since in insolvency matters, the parties are not free to determine by agreement the law governing the or to confer jurisdictions to of a particular court. This was, I think it's a relevant case about public policy. I have 3 cases, but I will speak probably about 1 or 2. We had in an application for recognition coming from New Zealand, an insurance company wanted to obtain automatic stay in Romanian proceedings, pending before ordinary courts. And here, Romanian judge established that adopting MLCBI, insurance companies from non-EU countries were excluded nation benefits. And here, we can have large discussions about implementation, how implementing the model law in Romanian legislation, and excluding insurance companies based on, let's say, a public policy matter, is in line with UNCITRAL or general principles. And another case related to public policy, it was recent, an application for recognition in Romania of arbitral decisions of UK Court of Commercial Maritime Arbitration against a debtor with insolvency proceedings in Russian Federation. The purpose was to enforce the rights of secure creditors. And here the Romanian judge decided that, because it was discussed the problem of public policy, and the Romanian judge decided that a simple statement of opening an insolvency proceedings against the debtor cannot determine the non-arbitrable nature of the dispute in the absence of certain evidence, and recognize the decisions of arbitral court, UK arbitral court, enforcing the secure creditor rights. I have an interesting case. I have 1 minute? Okay. I have an interesting case. In 2020, main insolvency proceedings in Romania, and the foreign creditor established in Serbia. The foreign creditor made the claim. It was recognized partially by a creditor in the proceeding. He made an appeal against the measure of the practitioner, and the Romanian court established that his appeal was late because he didn't respect the time deadline for appeal. And the Romanian judge said, okay, we are applying MLCBI and recognize that foreign creditors same rights as Romanian creditors, but at the moment you are part of our proceedings, you have to respect Romanian law regarding communication and the time, the deadline, and appeals. It is a problem here, and it is related to information, because communication in Romanian system in bankruptcy is made by registry, public registry. And if you, as Serbian creditor, you don't have this information, this happened, this situation was in the case, you will not know to search for public registry to see if you are contest appeal. Okay. More cases, you will find it on my website where all the cases.
Yeah, no, I mean, I am in a very uncomfortable position, but I also want to take again this opportunity to mention the cloud database, so the case law on UNCITRAL text, where we are adding all the case law that we receive that is of interest for interpretation of the model law. And actually we are in constant discussion with Nicoleta about adding more and more Romanian cases. But it's so just to really reiterate that this case law is really interesting, even the one that was not mentioned, but you will find it very soon in the 6 UN official languages on our database cloud. With this, I would ask Katarina from Croatia. Thank you.
Dobar dan svima. First, I have to say to our moderator that we are all judges, so we are used to deadlines. Although this is very short deadline, just 4 minutes. Ja ću govoriti na hrvatskom jeziku i nadam se da ćete me svi razumjeti. Our interpreters agreed with that. Što se tiče Hrvatske, bit ću brza. Ajmo reći neki problemi, odnosno prvi neki stečajevi u kojima smo imali elemente međunarodnog stečaja su se pojavili negdje 2015. godine, odnosno nakon 2013. godine kada smo ušli u Europsku uniju. Zato što do 2013. fizičke osobe nisu mogle postati vlasnici nekretnina na području Hrvatske bez nekih posebnih odobrenja ministarstva dalje. Da bi izbjegli tu dodatnu proceduru, oni su otvarali trgovačka društva, firme i te firme su kupovale te nekretnine. To se obično radilo o nekretninama blizu mora na Jadranu. Nakon par godina neki mali račun ne bi bio plaćen ili nešto u visini, ajmo reći, 100 eura. I radi tih 100 eura bi se pokrenuo, u stvari vlasnik te nekretnine negdje vani i nije vodio dovoljno možda brigu o toj nekretnini. I tu smo prvi put dobili jako puno predmeta sa elementima međunarodnog stečaja. I trebalo je u stvari to se nije na takav način radilo, našli smo neko rješenje, prodati nekretninu od 2 milijuna eura radi duga recimo od 100 eura. Nakon toga, što se tiče međunarodnog stečaja, moram reći da u Hrvatskoj je slično kao u Sloveniji, ne isto, ali slično. Imamo pretežito sekundarne postupke, glavnih nemamo. Sada trenutno se vodi samo jedan postupak. Imamo digitalnu bazu podataka, pa možemo ući u svaki predmet koji se vodi u Hrvatskoj. Neke posebnosti što se tiče Hrvatske druge nema, jedino bi istaknula razliku kod priznanja stranih odluka, odnosno priznanja otvaranja stečajnog postupka iz drugih država u Hrvatskoj. Tu je razlika između država članica Europske unije i onih država koje nisu članice Europske unije. Za one države koje nisu članice Europske unije postoji poseban postupak koji treba proći, formalan. Često iz nekih razloga pretjeranog formalizma bude takav predmet odbačen od strane suda, to je što se, ali u stvari sve je propisano vrlo jasno i tu ne bi trebalo biti nekih većih problema što se tiče zakona ni prakse. Jesam u vremenu. I mean, am I in time?
Yes, you did.
Thank you.
You did, and I'm happy also to conclude on your part that model law on cross-border insolvency may avoid you to have red tape procedures, maybe because by definition the model law has a very clear and expedited procedure that avoid all the complications. So this might be also a solution.
Thank you.
With this, I will turn to Ms. Vukčević for Montenegro.
Evo ja ću da pokušam da budem kratka. Što se tiče Crne Gore, smo čuli da je zakon o stečaju u Crnoj Gori prihvatio ovaj model zakon o prekograničnim sporovima i bukvalno ga je implementirao u svoj zakon. Tako da mi imamo poglavlje u našem zakonu o stečaju koje nosi naziv međunarodni stečaj i sadrži svega 20 članova koji regulišu ovu materiju. Po mom mišljenju mislim da je to nedovoljno u odnosu na složenost problematike koju nosi ova vrsta sporova i smatram da bi trebalo mnogo sistematičnije, detaljnije i jasnije regulisati međunarodni stečaj. Pre svega mi sudije, evo, pretpostavljam da će se složiti mnoge moje kolege, volimo da nam je sve regulisano zakonom, da znači ne bude ulutanja, tako reći, u praksi. Tako da naš sadašnji u stvari zakon je ono što je bio srpski govorio profesor Radović pre ovih poslednjih izmena. I mislim da te izmene koje je Srbija uradila nisu samo jezičke, nego po mom mišljenju su i veoma bitne i otklonile bi i da smo mi takve izmene uneli u naš zakon mnoge probleme u praktičnoj primjeni. Tu pre svega mislim na ona ograničenja o tome na koje dužnike se primenjuju odredbe o međunarodnom stečaju, zatim i ova odredba koja se tiče direktne međunarodne nadležnosti domaćeg suda, tako da očekujem da u narednom periodu i mi to u Crnoj Gori uredimo nekako jasnije da bi se izbegli mnogi problemi u praksi. Što se tiče primene, mogu da kažem da u praksi nije bilo puno slučajeva sa međunarodnim elementom koji je dolazio na nadležnost u apelacioni sud. Bilo ih je uglavnom iz susednih zemalja i oni su se uglavnom završavali na sudovima prve instance i uglavnom priznanjem stranog sudskog postupka kao glavnog. Mogla bih da izdvojim recimo jedan slučaj iz prakse koji smo imali u poslednjem periodu pre nekoliko meseci, gde je u pitanju bila jedna odluka Privrednog suda koji je zapravo odbio da prizna stranu sudsku odluku o otvaranju postupka ličnog stečaja. Znači gde je stečajni dužnik fizičko lice. I prvostepeni sud privredni je to obrazložio, naš zakon ne poznaje, zakonodavstvo naše ne poznaje lični stečaj, da bi zbog toga odluka kojom se priznaje takav strani stečajni postupak bilo u suprotnosti sa javnim poretkom. Izjavljena je žalba protiv tog rešenja, o njoj odlučivao apelacioni sud i ukinuta je ta odluka prvostepenog suda sa obrazloženjem da su u pitanju spor sa međunarodnim elementom mi ne možemo ni očekivati da sva zakonodavstva budu jednaka, niti kriterijum da li je nešto u suprotnosti sa javnim poretkom treba da bude to da li je predviđeno domaćim zakonodavstvom ili ne. I u suštini da pojam javnog poretka treba restriktivnije biti, tako da bi trebalo u konkretnom slučaju proceniti kakvi bi bili efekti takve odluke, da li bi dejstva, odnosno efekti odluke bili u suprotnosti sa javnim interesom, a u konkretnom slučaju po mišljenju apelacionog suda i po mom ličnom mišljenju ne bi, jer znamo šta je zapravo cilj stečajnog postupka, to je zaštita i namirenje zapravo poverilaca. Eto, toliko. Plotila sam sebe ja.
Many thanks. And I also know of another jurisdiction, I think Singapore, that excluded personal insolvency from the scope of recognition of the model law. So you are not alone, but it's good to see that the public policy exception was not accepted as a way of rejecting the application in this case. With this, Marko, you will have the floor to present a case law from Serbia. Thank you.
Dobar dan svima. Ja se moram ujediniti sa kolegama iz regiona i pričati na svom jeziku u svojoj zemlji. Nadovezat ću se samo na profesora Vuka koji je inače na fantastičan način obrazložio primenu model zakona u našem pravnom sistemu. Takođe, poput Crne Gore, mi spadamo u red zemalja koje su prihvatile model zakona iz 1997. godine i u praksi mogu slobodno reći da imamo otvoren pristup u priznavanja stranih postupaka kao glavnih kada se podnose zahtevi, kojih svakako, kao što je profesor Vuk rekao, nema mnogo iz mnogih razloga. Međutim, naravno, postoje i specifičnosti. Uvaženi sudija Đorđević je pomenuo Agrokor slučaj. To je slučaj i kod nas. Još 2017. godine mi smo odbili zahtev za priznanje tog stranog postupka kao glavnog. Upravo jedan od razloga bio je i onaj koji je pomenuo sudija Đorđević, a to je da cilj tog zakona nije kolektivna zaštita poverilaca, već praktično zaštita nekih sistematskih interesa te države Hrvatske koja je i zakon donela. Drugi razlog koji je takođe u našoj menuti koji bih izdvojio jeste da u konkretnom slučaju nisu ispunjeni oni stečajni razlozi koji su inače opšte prihvatljivi u našem, a i u hrvatskom zakonu o stečaju, koji bi inače predstavljali osnov za otvaranje stečajnog postupka, a potom i za priznanje u našoj državi. Poruka svega ovoga možda i jeste u tome da rešenja o stečajevima grupa ne treba tražiti u donošenju lex specialisa, posebnih zakona, već možda uz upravo odredbe model zakona o stečajevima grupa iz 2019. godine, tražiti rešenja da na jedan generalan način implementiramo odredbe koje su prihvatljive našim pravnim sistemima i tako na jedan opšte prihvatljiv način i regulišemo stečaj grupa. Hvala.
Many thanks for this very informative answer, and many thanks for those very practical and concrete examples that show really how the model law works and in the Balkans country, and it allows the court to grant recognition to foreign proceedings when they fit into the definition that is in the model law. And I just wanted to remind and to also quote the definition of the foreign proceeding as in the model law, which is a collective judicial or administrative proceeding in a foreign state, including an interim proceeding pursuant to a law relating to insolvency, in which proceeding the asset and affair of the debtor are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. And we understand that in the Agrokor case, for various reasons in Serbia and in Slovenia, this was not found to be the case because there was other rationale behind the foreign proceedings. And it's also good to see that the model law can provide recognition for individual creditors when is. And I also wanted to emphasize the link between the recognition and also the parallel proceedings or the interconnected proceedings, such as arbitration that was mentioned by Nicoletta earlier. And I think at this stage, I want also to mention the current work on UNCITRAL Working Group 5 on applicable law in insolvency proceedings that has been mentioned before, where the question of which law should apply to insolvency effects on ongoing arbitration is something that is being heavily discussed, and it is somehow also connected to that aspect. Talking about case law on model law on cross-border insolvency, I also wanted to bring your attention to the digest of case law on the model law on cross-border insolvency. It's a publication that has been released in 2021, prepared by the UNCITRAL secretariat with the assistance of judges and experts. And this publication provides article by article an analysis and of the relevant cases on the model law on cross-border insolvency from different jurisdictions. So this is also something that comes in addition to cloud, where in the future we will see more and more cases from the region, especially from Romania, I'm sure. Also wanted to mention again the enterprise group aspect, because this was also something in Agrokor that was discussed. And I actually recall that in the decision from the Slovenian Supreme Court on Agrokor, there was mention to the part 3 of the legislative guide on insolvency law on the treatment of enterprise group in insolvency. It means really that judges in many countries use those resources and those interpretative texts, the one we mentioned, the guide to enactment, the explanatory materials that are prepared by the secretariat, to help applying and implementing the model law on cross-border insolvency. With this, I will move to the second question. We heard that cross-border cases are very complex and not the day-to-day business for judges. So could you tell us what are the challenges and issues courts are facing in practice when dealing with cross-border insolvency cases, and how the legal framework is already adequately tailored to answer those issues? And I will start first by Marko Radovic from Serbia.
Naravno, kada sam počeo sa izuzecima, nastavit ću i po ovom pitanju, imajući u vidu da pored tog generalnog otvorenog pristupa u našem pravnom sistemu u praksi, a možda i zbog neke nedorečenosti ili nedovoljne jasnoće samog zakona prilikom implementacije odredaba model zakona, došlo je do problema u situaciji gde naši sudovi možda na neki uži način posmatraju odredbe model zakona, naročito u pogledu mogućnosti otvaranja stečajnog postupka nad ogrankom, stranim ogrankom i stranim predstavnikom. Naime, u našem zakonu o stečaju propisana je mogućnost otvaranja stečaja nad ogrankom, odnosno stranim predstavništvom. Namjerno sam zastao zbog toga što u zagradi pominje termin sporedni stečajni postupak na kraju te rečenice. Međutim, model zakon koristi jedan širi termin, a to je neglavni stečajni postupak. U okviru tog pojma uključeni su ne samo sporedni stečajni postupci koji podrazumevaju mogućnost otvaranja postupka samo u situaciji, nad ogrankom samo u situaciji kada je u državi domaćina otvoren glavni stečajni postupak. Pored tog pojma, u model zakonu obuhvata se i glavni i nezavisni stečajni postupci. U okviru tog nezavisnog stečajnog postupka upravo je intencija bila da se omogući otvaranje stečajnog postupka nad samim ogrankom, odnosno stranim predstavništvom. Takav pristup je inače i u samom model zakonu uspostavljen upravo u cilju zaštite domaćih poverilaca i omogućavanju njima da naplate ono potraživanje na imovini koje se suštinski nalazi i u njihovoj državi. Pa samim tim mislim da bi eventualno promjena našeg stava u sudskoj praksi dovela do usklađivanja sa model zakonom, a to bi svakako bilo i u interesu same države. Također obrazloženje u našim odlukama da ogranak nema status pravnog lica, odnosno samostalnog subjekta prava, možda i nije prihvatljivo u ovoj situaciji, jer upravo u činjenici da je samim zakonom kao lex specialissimus u odnosu na lex specialis definisan izuzetak da je moguće otvoriti stečajni postupak na stranim ogrankom i stranim predstavništvom, mi na taj način upravo imamo i imperativ obavezu da tako i u skladu sa zakonom. Hvala.
Thank you very much, Marco, for this also very interesting answers that also have a connection to Chapter 5 of the Model Law on Cross-Border Insolvency on concurrent proceedings. But I understand there are maybe difficulties in the case law. So this also underlined the need to have probably more dissemination and information about how the model law be applied, so to speak. I will give the floor to Katarina.
I will speak about different approach to creditors. Dakle, što se tiče vjerovnika, stranih vjerovnika, postoji razlika kod prijave tražbina, opet tako vjerovnika koji su domaći vjerovnici i vjerovnika koji su iz drugih zemalja. Domaći vjerovnici, kad smo razgovarali jučer neformalno sa kolegom, čula da je to tako isto i u Srbiji, imaju neki rok u kojem moraju prijaviti svoja potraživanja. Kod nas je to 60 dana, ako je naknadni postupak, onda je to nešto kraći rok, 30 dana. Međutim, strani vjerovnici nemaju tog roka, nego sudac uputi upravitelja da pozove sve strane vjerovnike koji su mu poznati da prijave tražbinu. To mogu napraviti van ovog roka, mogu i nakon pola godine ili bilo kad ih ovaj pozove za to, kad oni saznaju u stvari da je otvoren taj stečaj. Tu je opet razlika između zemalja koje su članice Europske unije i one koje nisu članice Europske unije. Samo praksa pokazuje da stečajni upravitelji, odnosno suci, na jednaki način tretiraju sve zemlje, odnosno i članice Europske unije, one koje nisu članice, i na jednak način ih obavještavaju o postojanju otvorenog stečaja, tako da i oni mogu prijaviti svoje tražbine. Naravno, nakon što ih obavijesti stečajni upravitelj, da im neki rok u kojem može prijaviti, jer opet nećemo čekati godinu dana da neko odluči prijaviti nešto u stečaj. Tako da, evo, tu bi rekla da je jedna razlika koju je praksa u stvari iskristalizirala, da na jednak način se ponašamo prema svim stranim stečajnim vjerovnicima, dok recimo domaći su u tom smislu, riječ diskriminiran je možda preteška, ali možda imaju uži rok za prijavu svojih potraživanja. Hvala.
Thank you, Katarina. And I cannot law on cross-border insolvency that provide exactly, I wouldn't say a solution, but at least some procedural rules to probably improve the situation of foreign creditors. So also again trying to fill the gap maybe with the model law. Miodrag, what's your view then on that?
Hvala. Meni je izazov naći odgovarajući primjeren koncept regulacije. Mi znamo da imamo sa jedne strane europsku regulativu o postupcima zbog insolventnosti koju države članice Europske unije ne trebaju prenositi u nacionalnu regulativu jer je obavezujuća. Onda imamo druge dokumente kao na primjer UNCITRAL ili UNCITRALovi dokumenti model law. Tu postoji mogućnost ili se u bilateralnom, u međunarodnom ugovoru po te dokumente ili odredbe tih dokumenata inkorporiraju domaće zakonodavstvo. Mi u Sloveniji odlučili smo se za taj drugi put, kao što je naš moderator ustanovio u odluci Agrokor. Mi smo se pozivali na UNCITRALov vodič za postupke zbog insolventnosti i na treći dio UNCITRALovog dokumenta i analizirali smo te dokumente u konkretnom slučaju. Šta donosi njihova primjena i njihovo tumačenje. Tako da mislim da je to jedan jako važan moment. Treba naći neko pravu razmjeru između regulative Europske unije i UNCITRALovih dokumenata da ne budu u opreci jedan sa drugim, jer potrebna je harmonizacija, jedinstven pristup kod rješavanja postupaka zbog insolventnosti. A drugo što se tiče, replicirao bi koleginici Katarini u odnosu na strane povjerioca i stranog upravitelja. U našem domaćem zakonu o postupcima zbog insolventnosti imamo posebne odredbe koje se odnose na direktan pristup stranog upravitelja sudu koji vodi postupak. Postoji ovlašćenje stranog upravitelja predložiti postupak zbog insolventnosti. Imamo još razrađeno učestvovanje stranog upravitelja u tim postupcima i njihovo obaveštavanje, tako da se trudimo da damo što veću sigurnost i pravo na učešće u domaćim postupcima. Toliko za sad, a više ću možda reći u vezi kooperacije i koordinacije, jer to mi je jedan od isto tako važnih momenata. Hvala.
Many thanks, Miodrag. And I see that Katarina wants to reply to your observation about the involvement of foreign creditors. So please, Katarina.
Ja moram reći da je naš zakon jednako tako, možda smo ga čak prepisivali, ne znam, ali isto tako izregulirao, nismo austrijski smo, izregulirao djelomično na sličan način neke odredbe. Ja samo govorim u praksi kako se događa, na koji način postupaju suci, na koji način postupaju stečajni upravitelji. Tako da ovo čisto iz prakse što se događa u stvarnosti, a ne kako je propisano u zakonu. Hvala.
Samo moja replika, ja nisam ništa kritikovao hrvatsko uređenje, nego sam samo htio da objasnim kako je uređenje u Sloveniji.
Riješit ćemo ovaj sukob večeras.
All right.
Dinner.
Thank you very much. With this, from Romania, you will also bring your contribution on that aspect. Thank you.
So I will speak about the different things to finalize the challenge before discussed. I will discuss about practical challenge related to the requirement of reciprocity. Adopting MLCBI, Romania included a supplementary requirement. You have to fulfill the condition of reciprocity between Romania and the states. Okay. and the state wanted where the insolvency proceedings, the judgment, it's pending. What happened in practice? We had case in 2020, application for recognition coming from Russian Federation as approved, and the judge, the parties found a treaty from 1958. And they interpreted the provisions of that treaty and said, okay, the condition is fulfilled and the application it's okay. The other situation we have also in 2020 application for recognition from Switzerland, and the judge found that no requirement, no reciprocity by law, and found a solution. It can be proved de facto reciprocity. How? Providing a judgment from Switzerland, or judgment approving request for recognition coming from Romania. And the judge said, okay, you can do this, but you didn't do it. And the question, the practical challenge is how to find these decisions from different jurisdictions to fulfill this requirement of recognition. And the practical problem, I think, is not for Romania, but for different countries, how to evaluate and to establish the factors for coming and for determine the jurisdictions for main proceeding and non-main proceedings. And even if we apply EU regulation, I think, and in my practice, we can go to UNCITRAL instrument to take from their experience and to apply in practical case. And I had I need another minute. Okay. In 2018, I had an application, main proceedings, just first step in main proceedings, pre-insolvency proceeding in Italy, and secondary request for secondary debates about jurisdiction, COMI, establishment. And I had to go to Romania, to European regulation practice, and I needed to go to Article 147, I think, from the Guide of Enactment, to take from there many factors and to establish if I have jurisdiction for opening main proceeding, non-main proceeding, in what conditions. This was a very practical situation where I apply UNCITRAL model law, even if in a case, in European case. Thank you.
I will never cut a person who is telling me that he used UNCITRAL instruments to apply a different. So you could have used much more time. Thank you very much. And now Daniela from Montenegro, please.
Pored onih problema u praksi o kojima sam govorila prilikom prethodnog pitanja, mogla bi da dodam ono što smo mi imali u praksi, a to su pitanja koja su se postavila vezano za primjenu drugih u postupku priznanja stranog sudskog o stečaju. Tako da smo imali recimo jedan predmet gde je prvostepeni sud, privredni sud, usvojio zahtev za priznanje postupka, a da prethodno nije omogućio stečajnom dužniku da se na isti izjasni. Tu je privredni sud se pozvao na načelo hitnosti i na odredbu konkretnu u Zakonu o stečaju da je postupak hitan, kao što je uostalom i u model zakonu takođe propisano da je taj postupak hitan. Međutim, to načelo i potreba za hitnim odlučivanjem ne znači da se zapravo trebaju kršiti prava onih na čija prava takva odluka može reflektovati. Jer pravo je tog lica protiv kojeg je podnet predlog za priznavanje stranog stečajnog postupka izjasni, da bude sa istim upoznat. To je propisano takođe i zakonom o parničnom postupku, a sa druge strane proističe takođe iz člana 6 Evropske konvencije za zaštitu ljudskih prava i sloboda, tako da je u konkretnom slučaju od strane apelacionog suda ukinuta i vraćeno na ponovni postupak. S druge strane, to ne znači da u svakom slučaju su primenjive odredbe Zakona o parničnom postupku. Zašto ovde sad govorim o Zakonu o parničnom postupku? Jer Zakon o stečaju propisuje njegovu shodnu primenu u onim situacijama kada nešto nije propisano Zakonom o stečaju. Imali smo postupak u kome je podnet zahtev za priznanje stranog stečajnog postupka nad stečajnim dužnikom koji je fizičko lice, znači lični stečaj, i stečajni dužnik je priznao zahtev i saglasio se sa tim da se otvori stečajni postupak, odnosno da se prizna stečajni postupak kao glavni. Međutim, šta se desilo? U postupak se umešalo treće lice, poslovni partner tog stečajnog dužnika, koji je tražio da mu se s pozivanjem na Zakon o parničnom postupku dozvoli učešće u postupku priznanja stranog stečajnog postupka, pozvao se na to da ima pravni interes da učestvuje u tom postupku, jer ima zajedničke investicije sa stečajnim dužnikom i odluka suda, koja bi sutra bila doneta, bi mogla eventualno da proizvede posledice po njegova prava i interese. U konkretnom slučaju prvostepeni sud je odbio takav zahtev za mešanje i to je potvrđeno od strane apeta. To isto treće lice čak izjavilo i žalbu protiv odluke kojom je priznat glavni stečajni postupak, koja je posle i odbačena, i zapravo stav je prvostepenog i drugostepenog suda da zapravo u konkretnom slučaju taj institut ne bi bio primenjiv u postupku priznanja strane sudske odluke, za razliku od parničnog postupka, gde jedna strana uspeva sa svojim zahtevom, a druga strana gubi. U postupku priznanja strane sudske odluke sud se zapravo ograničava na to da, postupajući po zahtevu stranog predstavnika koji je jedini aktivno legitimisan da podnese takav zahtev, utvrdi da li su ispunjeni zakonom propisani uslovi. Tako da je potvrđeno to stanovište da, znači, član 205, da je propisano to pravo na mešanje, nije primenjivo u postupku stečaja. Zaključak bi bio da u svakom konkretnom slučaju treba da nastoje u što kraćem roku, odnosno što hitnije, ali uz poštovanje prava učesnika u tom postupku i takođe da pokuša da se taj postupak sprovede bez odugovlačenja i da se ne dozvole opstrukcije i zloupotreba od strane nekih trećih lica. Hvala.
Thank you very much. Thanks to all for your excellent contribution. And I would want to highlight the following points. I think we cannot shy away from the text that is a result of an intergovernmental negotiation at the global stage may create difficulties of problems for courts. For example, the interaction with the civil procedure laws or any other legislation. So this is something that is, I think, well acknowledged. But I think also we have seen that for interpreting and applying concepts at the center of main interest, or the establishment or any other concepts that are found in the model law, the use of the guide to enactment and interpretation is of a paramount importance. And we have seen that in Romania, this has been quoted in the judgment. And we also have seen that it has been used even in a non-model law cross-border insolvency context, but in the European Union context. So it goes even broader than that. Another important resource that I wanted to mention is what we call the Judicial Perspective on Cross-Border Insolvency. It's also a publication that has been prepared by the Secretariat with the assistance of judges and experts. And it's really designed to assist judges face with questions that may arise in the context of a recognition application under the model law on cross-border insolvency. And It has been published only in 2022. So it's a very recent, it's available online on our website in the 6 UN official languages. And this also can really assist judges to apply the model law. One last comment regarding reciprocity. So as it has been said, this is not in the model law. This requirement is not found in the model law, but some states, probably because they were of some fears maybe that they would lose too much power, included such reciprocity condition. We also know that some states, such as Mauritius and Uganda, repealed it afterwards, this condition, because if you have such a condition, it makes the model law rarely applicable or very difficult to apply. So you don't really have the benefit of having the model law in your legal framework, because basically it cannot apply, or it's really, really difficult to apply. And it also means that the existing safeguard in the model law, the public policy we discussed already, and also the adequate protection of creditors when the court grant relief upon recognition, are probably sufficient to protect the interest of the. And I think also it's a point that it relates to the point Daniela made for Montenegro, where the enactment of the model law in Montenegro was shorter than the model law itself, so it's not exactly similar. And really, this also shows that having a text in your domestic legislation that is as faithful as possible to the original version is more amenable to harmonization, and also does not create difficulties for the judges. So this is also something I think we can conclude from this question. My last question for the panel today is that we heard that cross-border insolvency are complex, the consequences on business, on employees, on creditors, on other parties in interest. And so the cooperation between courts is really crucial to avoid a fragmented approach, parallel proceedings that would have a cost and time implications, and overall have a negative effect on protection and maximization of the value of the insolvency in state. So this cooperation aspect has been considered so important that there is a whole chapter in the model law on that. But we also know, we also heard that international cooperation between courts is not an easy task. So I would like to ask, in your opinion, whether cooperation between courts in the region and beyond is working well, and if there is a need for more cooperation and cooperation, and how to achieve that. And I will start with Nicoletta, because I know this is really a subject that is dear to her heart. So please, Nicoletta.
I will start again from my experience as a judge. I had the opportunity to promote communication cooperation with an Italian court just once, so we don't have so much experience. Meantime, I retired. I don't know what happened, and I had no occasion to cooperate with another court as a judge, but I'm trying to do it as a practitioner. Instead of, we have a recent case, a German cooperation, Romanian cooperation case in parallel liquidation proceedings, which is amazing, because the judges, German judges and Romanian one, established already some ways to have coordinated table of claims and coordinated sales of assets with main proceeding in Germany and secondary proceeding in Romania, which is, for me, it's amazing. I think for Europe, it's a new case, a new way of cooperation. What are the main challenges? I think the most important is the lack of information. We can add the lack of procedural rules, how to communicate, differences in languages. Now, before establishing, and this is not a way the judge can promote, establishing international standards, common standards for judges coming from civil law jurisdictions and common law jurisdictions. What can we do now to try to meet each other to discuss cases, to increase transfer of information, to have personal contact. In this way, maybe an increasing trust in each other, we can develop cooperation, judicial and practitioner cooperation. And I'm waiting to cooperate with a different court, of course.
Please. Yes, thank you. Ja smatram da je to jako važna. Ja mislim da je to jako važan moment i u vezi toga uvijek pominjem 3 slova K. To ne znači Ku Klux Klan, nego znači communication, komunikacija, kooperacija i koordinacija. 3 slova K. U našem zakonu imamo odredbe, posebne odredbe o saradnji domaćeg suda sa stranim sudovima i upraviteljima. Posebne odredba o saradnji domaćeg upravitelja sa stranim sudovima i stranim upraviteljima. Imamo određene oblike saradnje. Tu mislim da je jako važno imenovanje osobe ili organa koji deluje, radi po uputstvima suda. To je jedan moment koji može jako pomoći. Dozvoljava se i svaki drugi oblik po ocjeni suda primjeren. A treća stvar koja je jako važna je sklapanje i sprovođenje dogovora koji se odnose na usklađivanje postupaka. Tu mi uvijek ostaje u sjećanju primjeri iz Sjedinjenih Američkih Država i Kanade koji imaju jako puno tih bilateralnih dogovora o vođenju postupka. I još jednu stvar bih htio napomenuti na kraju. U našem zakonu imamo jednu posebnu odredbu, tu mogu da se pohvalim, to je član koji sam sam napisao, imao sam poteškoće da ga odbranim, a odnosi se na to da se u vezi saradnje može upotrebljavati domaći jezik ili engleski. Problemi su bili u tome što su neki mislili da sam s time stavio domaći jezik u podređen položaj, ali nije u podređenom položaju, nego je zbog svrsishodnosti, zbog bolje saradnje i komunikacije predviđena mogućnost da se pored domaćeg jezika može upotrebljavati i internacionalni engleski jezik. Toliko, hvala.
Thank you. Katarina?
Moram reći da također postoji slična odredba u hrvatskom stečajnom zakonu. Čak ne mislim da je problem u odredbama, više je problem sucima i stečajnim upraviteljima. Dakle, u nekom svjetonadzoru ili nekakvoj osobnoj, kako bi to rekla, karakternim osobinama. Neki suci su malo aktivniji pa se angažiraju oko nekih stvari, a neki nađu način kako izbjeći nešto ili odbiti ili odbaciti predmet. Zato mislim da je jako važna edukacija. Ovo se isto odnosi na stečajne upravitelje, odvjetnike i tako dalje. Mislim da je jako važna edukacija jer ljudi se često boje onoga što im nije dovoljno poznato, a recimo da međunarodni stečajevi nisu dovoljno poznati, da zapravo ovakve neke konferencije, ovakve neki sastanci, ovakva neka druženja imaju jako puno koristi. Evo, mogu reći osobno da je meni ovo jako bilo korisno. Nisam se uspjela zahvaliti, ovo je meni prvi put da sam ja u Beogradu, pa se zahvaljujem domaćinima, pogotovo kolegi Marku, jer mi je ovo omogućio, on me i pozvao da dođem na ovu konferenciju. Tu sam upoznala, znači evo već je sad ostvareno nešto i stečajnim pravom i srpskog sunca i Srbije i ostalih kolega. Tako da su naši putevi sad otvoreni. To su neformalni putevi, bili su naši neformalni putevi preko društvenih mreža otvoreni i ranije, preko LinkedIna i stvarili kontakt. Znači, tko hoće kontakt može ga stvoriti, čak ne mora biti formalan neki propisani pristup, nego više stvar nekako osobno angažmana i sudaca i stečajnih upravitelja. Dakle, rekla bi još edukaciju i znanje stranaka. Mislim, evo sad mi govorimo ovdje, ja govorim hrvatski, publici koja većinom govori srpski, ali smo i par osoba koje nažalost moraju slušati prijevod. Međutim, bitno je znanje stranih jezika, bitno je znanje pogotovo engleskog jezika, da možemo lakše komunicirati sa svima, mislim to je činjenica. Tako da treba poticati suce i stečajne upravitelje i na jednu tu komunikaciju engleskog jezika i to stručnog engleskog jezika da mogu ostvariti lakšu komunikaciju. Hvala.
Thank you. At this stage also, we cannot really help with the meeting and the language when we are talking and use the language in the secretariat. But the good news is we can help with one of the publications we have, which is the practice guide on the cooperation, which really provide examples on cooperation agreements between courts and insolvency representatives, and also how to use them. And it's not only available in English; it's available in the 6 languages again. It's dated 2009, so it's a bit old. But the good news is we are now starting the update and the refreshment of this publication, which I understand you would find useful, at least when it's time to put it on the paper. But when it's time to shake hands and everything, it's another story. Marko, you have the floor.
Hvala, ja bih se samo nadovezao na izlaganje koleginice Katarine i svakako, pored ove procesne koordinacije, ja mislim da je možda i važnija koordinacija ne postupaka, nego koordinacija i kooperacija sudija. I upravo zbog toga na samom kraju osjećam ličnu potrebu da se zahvalim UNCITRAL-u što je našu inicijativu da upravo ovakvu konferenciju na regionalnom nivou i da prosto kroz jedan vid pokušaja ostvarivanja ove lične saradnje, kako sa nosiocima visokog obrazovanja, tako i sa sudijama, razvije ovu temu i podstakne na razmišljanje i o spornim pitanjima, ali ono što je mnogo važnije po meni, a to je i potvrda ovog skupa, ove sesije, upravo ostvarivanja međusobne saradnje, stvaranja međusobnog poverenja i jedino tako mislim da stvaramo budućnosti, zanemarimo i stavimo po strani političke razlike među interesima država, a da se nekada u budućnosti opredelimo za stvaranje mostova i onih osnovnih ideala pravde, a u ovom slučaju ponajviše zaštite poverilaca, nezavisno iz koje države potiču. Hvala svima i na samom kraju posebnu zahvalnost i lično Benjaminu Harrisu, koji je svakako jedan od glavnih krivaca što je i UNCITRAL i EBRD i Udruženje za stečajno pravo ostvarilo saradnju na.
Thank you, and I would ask Daniela Vukcevic from Montenegro for a quick answer, please. Thank you.
Šta da kažem posle svega ovoga, nemam, stvarno mi nije ni ostalo mnogo toga da kažem, znači potpuno podržavam kolegu Radovića i koleginicu, smo rekli, sama činjenica da se radi o sporu sa međunarodnim elementom, gde se uključuju različitim zakonodavstvima, nameće potrebu jače saradnje kako bi prevazišli te razlike i ostvarili cilj, znači stečajnog postupka koji je bez obzira na razlike u zakonodavstvima uvek isti. I mislim da je ova konferencija u tom smislu veoma važna, prepoznala je značaj ove teme, omogućila nam da razmenimo svoje iskustva, ukazala na potrebu za jačanje komunikacije između nas samih i ja bih želela da se zahvalim kolegi Marku Radoviću na pozivu za učešće u ovoj konferenciji u svoje lično ime, ime suda iz kojeg dolazim i predsjednice suda i evo kao jednu inicijativu i mislim kao jedan jako dobar način kako da se stvori neka dobra osnova za saradnju je da apelacioni sud poziva Udruženje za stečajno pravo da u budućnosti možda zaključimo memorandum o saradnji gde ćemo uspostaviti osnovu za regionalnu saradnju i razvoj te saradnje u ovoj materiji. Hvala.
Thank you very much. It's really encouraging already. I will use my prerogative to allow 5 minutes for question and answer. And I know we are the last person standing between you and your lunch. And also I would like to conclude, but first 5 minutes question and answer. I would ask people to be brief, especially if there are judges in the room. They might want to contribute or to ask questions to our distinguished panelists. Yes. Microphone, please.
Ja ću se pridružiti našim dragim sucima pa ću govoriti na hrvatskom. Možda samo par rečenica. Htjela bih reći da Hrvatska nije pripisivala odredbe o međunarodnom stečaju, govorim iz prve ruke jer zapravo sam ih ja pisala. U to vrijeme kad su one stvarane 96. godine nismo imali ni Europsku uredbu o insolvencijskim postupcima, niti UNCITRAL model law još nije bio napravljen. Zapravo su bila samo razmišljena u teoriji kako riješiti najvažnija pitanja o stečaju. Budući da je to bio moj doktorat, vjerujte mi, duboko sam se potrudila da nađem prava rješenja i bila sam jako sretna kada je godinu dana kasnije UNCITRAL praktički ima ono što smo mi već stavili godinu dana prije u naš zakon, s time što smo mi imamo i ta pravila o pravu, tako da su naša rješenja kompaktnija i ona su više prilagođena kontinentalnom pravu zato što naš sudac točno zna što mora raditi u određenoj situaciji kad dođe međunarodni stečaj. Problem je, vjerujem da ćete se svi složiti, da ima puno više slučajeva međunarodnog stečaja nego što možemo naći u sudskim odlukama. Naprosto se ne prepoznaje da postoji međunarodni element, a dovoljno je da stečajni dužnik ima samo jednog stranog vjerovnika, već morate primijeniti pravila međunarodnog stečaja. Dovoljno je da dužnik ima samo jedan komad svoje imovine u inostranstvu, morate primijeniti pravila o međunarodnom stečaju. I samo još malo o Agrokoru. Dakle, nijedan stručnjak za stečajno pravo ko razumije materiju za ta rješenja koja su u tom posebnom zakonu. Ja sam 2 dana prije nego što je trebao biti izglasan taj zakon u našem Saboru uputila javno pismo našim zastupnicima da to ne izglasaju. Međutim, znate kako su zastupnici po političkoj liniji se glasa, to je izglasano. I svi ovi razlozi zbog kojih su i naš poštovani sudac, predsjednik Vrhovnog suda Slovenije i naš sudac Radovic, koji su naveli zašto nisu priznavale okolne države, u pravu su, potpuno su u pravu. I zapravo je naša jedina nada da se taj zakon nikada više neće u Republici Hrvatskoj primijeniti, jest da treba imati poseban zakon koji regulira ta društva koja su od važnosti za čitav gospodarski sustav, no tada to ne radite na način da kršite osnovna načela stečajnog prava, što nažalost jest slučaj sa našim tako lošim zakonom o izvanrednoj upravi. I reći ću vam još nešto. Taj zakon, taj postupak izvanredne uprave stavljen na listu Europske uredbe insolvencije. Tako da sudac, bilo koji u međunarodnoj, koji je u državi članici Europske unije, mora sad priznati taj postupak izvanredne uprave. Premda taj postupak nikad nije smio doći na tu listu. Zašto? Zato što Europska uredba o insolvencijskim postupcima kaže jedan dužnik, jedan postupak, jedna stečajna masa. Dakle, vi ne možete u jedan stečajni postupak ugurati 70 nešto članova korporacijske grupe. Ja? To je naprosto totalno rušenje tih načela pravne predvidljivosti, posebno kreditora, vjerovnika, solventnih kompanija. Eto.
Any other comments, remark? No? Yeah, please, Samira.
Yeah, thanks a lot for this excellent presentation. And now it's my turn, after Tomislav, to be provocative, because we know that Agrokor case was recognized, in fact, in 2 jurisdictions, United States and United Kingdom. So what was the reaction from Serbia and Slovenia to that thing? that there was recognition by UK and US courts for that proceeding. And also to supplement what Professor Garašić said, that the work on model law on cross-border insolvency, in fact, started already in 1994. And that's why it gives us even more comfort to put Croatia into our list of states. Yeah, just to supplement that and to present a comprehensive picture, as also Professor Omar was saying, that roots of the model law are already coming also to European Union Convention, and there was also in Seoul International. So there was already basis before we reached that stage, model law. But this is just historical background, but question really to Serbia and to Slovenia judges, distinguished judges from Slovenia and from Serbia. What was your reaction when UK and US, in fact, recognized Agrokor proceedings? Thanks.
So, Miodrag, you want to answer? Your microphone. Your microphone.
Can you repeat the question?
So, how did you? Because we know Agrokor was not recognized in Serbia and in Slovenia, but it was recognized in the UK and in the US, and also apparently, I think, in Switzerland. So, what's your views on the fact that under the same model law, at least the model law as enacted in the different jurisdiction, it is recognized somewhere and it's not recognized elsewhere, so to speak?
Okay. Okay, now I understood. My reaction is that I was writing the decision that the countries da države koje nisu priznale taj postupak sve proizlaze iz bivšeg zajedničkog zakona. To je zakon o prinudnom poravnanju, stečaju i likvidaciji koji se dalje razvijao samostalno u ja ću mogu ponoviti. Repeat.
Yes, please, can you repeat?
Kad smo, moja reakcija, ja sam taj koji je pisao tu odluku, je bila ta da sam pri svojoj odluci koju sam ponudio ostalim članovima vijeća proizlazio iz toga da sam uzeo u obzir odluke koje su doneli sudovi Crne Gore, Srbije i Bosne i Hercegovine. Zanimala me argumentacija na kojoj se temelji njihova odluka, a isto tako pročitao sam odluku engleskog suda, ali tamo sam da je engleski sud pri tumačenju te odluke se upro na common law system, common law tumačenje nekih instituta u isto, kako se kažemo, oslonio na odluke koje su donesene na osnovu common law interpretacije. Tvrdio u mojoj odluci da to nije sasvim u skladu i sa u duhu tumačenja koje su odluka drugih država. A te drugih država osnovane su na temelju bivšeg zajedničkog zakona, a to je zakon o prinudnom poravnanju, stečaju i likvidaciju. I iz tog zakona proizašli su nacionalni zakoni i svaki za sebe pojedinačno doneli su odluku na osnovu svojih pravnih propisa, na osnovu tih principa da taj postupak nije primjeren za priznanje.
Thank you. Marko?
Ja bih samo se nadovezao na izlaganje sudije Đorđevića i rekao kao sudija, to je za nas presuđena stvar. Tako da mi kao sudije ne možemo da tumačimo, a svakako moji su predlozi upravo u onom prvom odgovoru bili da treba tragati za opštim rešenjima, upravo oslanjujući se na odredbe model zakona.
Yeah.
Ja bih kratko, ja sam iz Makedonije, Severna Makedonija. Hvala Srbije Marko što me pozvao da danas budem tu. I htio bi pošaljem jedna poruka koja je vrlo važna, jer upravo sad se mi suočavamo sa jednim predmetom koji je međunarodni i koji se upravo odvija kod nas, koji je izazvao velika bura u Evropskoj uniji, tako da je predmet koji jako drma i naša država i nekoliko evropske države. A mi kao sudije, kao pravnike, ja kao bivši sudija, sad kao advokat, moram poručiti jedna stvar, da mi moramo biti čekor ispred ovih ljudi, ovi biznismeni koji zloupotrebljavaju stečeno pravo da bi sakrili svoje imovina i da bi napravili kriminal, da zarade veliki novac koji zarađuje na takav način. Upravo šta želim reći, da ono što je moj dragi i moj počitovani predsjednik Vrhovnog suda Miodrag napisao u jedan njegov izveštaj da se razvija stečajni turizam. Upravo sad imamo mi taj stečajni turizam koji se rana. Tako da određena preduzeća, odnosno firme, odnosno društva, prelaze u idu u druga država, dolazi u Srbija, ide u Bugarsku, ide u, ne znam, u Hrvatska, i onda vi žurite za njima i jurite gde ih možete naći, šta ko da ima imot. A oni samo promene naziv, promene sedište i onda vi izgubite pojma da se radi o istim subjektom. Zato mi kao pravnici, kao sudije i kao stručnjaci u ovoj oblasti moramo biti čekor ispred njih i da ova pravila koje su UNCITRAL postavili kao model, da mi razvijamo i već ugrađujemo naše zakone i to vrlo jako i vrlo uspostavimo mreža. O tomu smo pričali sa sudijom Markom, da moramo uspostaviti jedna mreža sudije i advokate i države u kojoj ćemo neposredno surađivati baš upravo na to polje da se spreče ta zloupotreba stečaja za izigravanje doverioca, kreditora i da bi mogli da postignemo uspeh. To je moj ujedno poziv do gospodina Benjamina i sa UNCITRAL da ovakva konferencija sazivi u Makedonije, u Crna Gora, da Hrvatska i da uspostavimo neka mreža koja bi nas povezala svi nas i bi bili stvarno ono što treba da budemo kao pravnici. Ipak da mi idemo čekor ispred naših stanki koji su jako vrlo promučeni i jako brže ide. Hvala vam.
Many thanks, and the invitation is well received and welcomed. So I will close now.
I have 1 minute. I think the network can start now. On voluntary measures, each of them give an email address and a phone number. And of course, it will not be mandatory. And in this way, UNCITRAL or the association will make a first list of possible networking of professionals. This is one proposal. I don't think it's impossible. Thank you.
Thank you, Nicoletta. So as this has been a very insightful discussion, I think very rich. I think we can conclude that the model is well enacted and well implemented in the Balkans. Although disseminating the case law and the explanatory materials I mentioned would certainly assist judges dealing with cross-border insolvency. So here the UNCITRAL Secretariat is always happy to assist. I think communication and cooperation between courts and insolvency representative is always challenging, but it can be successfully undertaken when mechanisms rely on a solid legal framework and on mutual trust between courts. And I think this meeting and the call that was just made prove that this aspect is also moving in the right direction. With this, I would like you to join me in giving a round of applause to our speakers and interpreters for their participation today. Thank you.
So good afternoon, everyone. Today's session will be in English and Serbian and Croatian. So we're going to continue the approach taken in session 2. And I'm delighted to be here today and to welcome an excellent group of practitioners who will give you the practitioner perspective on cross-border insolvency in the Balkans region and beyond. So to my right, I think I will start with Luka Andrić. Luka Andrić has over 25 years of experience in legal practice and has been focusing on complex legal transactions in Serbia in the region and advising on both international and domestic issues. And he is also a founding member of the Serbian Turnaround Management Association and a partner law firm of the EBRD Legal Transition Program. So we've been working together closely, our project with the Serbian Bankruptcy Law Association. Mr. Andrić, or Luka Andrić, has been also an expert to USAID and the World Bank and has participated in legal reform activities in Serbia and the drafting of various iterations of the Serbian bankruptcy law. Then here to my right, I have the pleasure of introducing Josipa Jurčić, who is a law firm partner and an insolvency practitioner from Croatia with 10 years of experience in law, including 6 as an insolvency practitioner, and has practiced a range of commercial and corporate law, tax law, M&A law, due diligence, employment law, and dispute resolution. So has a very broad experience to contribute to today's discussion. Then here on my left, we have the pleasure of introducing, or I have the pleasure of introducing Stephen Harris, who's an associate partner and an insolvency practitioner at EY London. So Stephen has been in the insolvency market since 1989 and has of taking insolvency appointments in major high-profile complex groups. And he's acted on a number of successful trading administrations. He has unique insight into the practical application of the European Union regulation on insolvency because Stephen was, in fact, one of the administrators of the Nortel Europe group, appointed in the UK and France, I believe, and recognized throughout the various European jurisdictions. Stephen is also an English insolvency subject matter expert for the Foreign and Commonwealth Office, and he was and is a founding co-chair of the Insolvency Office Holders Forum for Insol Europe. Then, last but not least, I have the pleasure of introducing Tomislav Sunjak, who is a founder and principal of Sunjak Law, which is an independent, specialized, and focused law firm in Serbia. So Tomislav has a focus on asset recovery, and inevitably encounters some of this in the context of insolvency proceedings. He's a current co-chair, as we've heard, of the Asset Recovery Committee of the International Bar Association, and has been very much involved in UNCITRAL working group related to asset recovery in insolvency. And he's been involved on numerous other initiatives, including the World Bank STAR initiative, which is for which relates to stolen asset recovery. So I'd like to kick off today's discussion with just your impressions, everyone, on what we've heard from panel 2. And how do you perceive the international developments in national instance since 1997 and since this introduction of the model law on cross-border insolvency? Are we moving towards greater harmonization? I will start with Luka, if I may. Thank you.
Hvala. Pa evo ja samo da počnem panel sa konstatacijom da smo u drugom panelu čuli neke interesantne momente. Znači, ono što je meni posebno bilo pošto model zakon, iako je usvojen u Srbiji i u još nekim zemljama regiona, očigledno se ne primenjuje svuda na isti način. A to je zato što je model zakon napisan tako da treba da bude primenjen svuda u svetu, a suštinski naše zakonodavstvo, ono što je već konstatovano na drugom panelu, nisu nužno u potpunosti u skladu sa terminologijom koja se koristi. I naši sudovi ne umeju ili ne žele često da primene dobar deo njegovih odredbi, posebno oko saradnje, to smo već čuli i na drugom panelu, tako da mislim da je možda u nekoj narednoj iteraciji izmena zakona možda dobro razmotriti da se odredbe malo više prilagode ili dodatno prilagode problemima koje smo videli u praksi. Jedan od problema je bio baš i ovaj o kome se pričalo, to je što kod nas nije moguće otvoriti trenutno stečaj nad ogrankom bez postojanja stranog glavnog postupka. Ali mislim da generalno gledano suština je tu, naši sudovi prihvataju, iako nema previše prakse, da otvore, da priznaju strani glavni postupak i da postupaju u skladu s takvim zahtjevima. To je, da kažem, veliki napredak i to se očigledno može postići u svim zakonodavstvima koji su usvojila model zakon u ovom regionu. Toliko za početak.
Thank you very much. Luka, may I turn to you, Josika, for your comments?
Thank you, Catherine. Dobar dan svima. Prvo bih htjela zahvaliti organizatorima na pozivu na ovaj event. Jako mi je drago i počašćena sam što sam ovdje, a osobito želim zahvaliti sucu Marku Radoviću koji me pozvao da ovdje sudjelujem. Dakle, već smo čuli u par navrata. Dakle, da Hrvatska nije usvojila ovaj model law. Međutim, u zadnjih 10 godina smo imali jako u Hrvatskoj što se tiče stečajnog prava. To se prvenstveno tiče utjecaja Europske unije. Dakle, mi smo EU regulativu pokušali usvojiti u naš sustav. Ne samo da smo usvojili, neke stvari smo jednostavno počeli tumačiti u skladu sa odredbama europskog prava, što je imalo zaista jako veliki utjecaj. Osobito iz razloga što mi vrlo mnogo surađujemo sa kompanijama iz Europske unije. Jako usko smo tu povezani, kao mala država zapravo smo ovisni o Europskoj uniji i to zapravo stvara veliki utjecaj na stečajno zakonodavstvo u Republici Hrvatskoj. Što se zadnjih 10 godina recimo dogodilo u Hrvatskoj, zapravo više od 2015. i od ovog zadnjeg zakona, stečajnog zakona, kada je on bio implementiran u Hrvatskoj, sve je postalo dosta javno. Dakle, dobili smo tu e-oglasnu ploču koja je na webu. Kada jednom nešto dođe tamo, to je tamo do smaka svijeta, kako to sada biva. Dakle, ništa se ne briše, nema GDPR zaštite, jednostavno je sve svima dostupno. I svi izvještaji se objavljuju, sva rješenja o otvaranju stečajnih postupaka, sve što je prethodilo otvaranju stečajnog postupka, a i kako je došlo do zaključenja. Dakle, to je sve javno dostupno, je na hrvatskom jeziku, pa ima možda ta nekakva jezična barijera, ali je dostupno. Tako da to je i od nas kad radimo kao stečajni upravitelji utjecalo na naš rad i jednostavno se više potrudite kad znate da to netko može pročitati i da će to netko pročitati. Ima jednostavno velik utjecaj javnosti na sve stečajne postupke koji se događaju u Republici Hrvatskoj i smatram da je to zaista dobro i da je tu bilo velikog napretka od prije 2015. godine kada su se postupci provodili po starom zakonu, kada nisu bili objavljivani i kada je to bilo na neki način pomalo i prikriveno i misteriozno. Eto, toliko od mene. Hvala.
Josika, may I ask? May I turn first to Tomislav and then to Stephen? So Tomislav, can you perhaps give us your perspective? I mean, you see you see this more broadly through your work through asset recovery. What are you seeing in terms of development and cooperation among practitioners in different jurisdictions? Thank you.
Kao prvo, hvala. Ekstremno je teško nakon ručka sedeti na panelu sa obe strane. To je uvek najteže. Hteo bih da zahvalim Samiri i UNCITRAL na pozivu što sam ovde, profesoru Radoviću i sudiji Radoviću takođe kao divnim hostovima i domaćinima ovog skupa koji su odlično vodili. Vezano za vaše pitanje, puno je bolje što imamo model ugrađen u sistem nego da ga nemamo. Otprilike bih tako sa tim započeo. Postoji puno prostora za poboljšanje. Određeni delovi za poboljšanje nisu toliko prijemčivi civilnim pravnim sistemima kao što je u Srbiji, više su prijemčivi komunalnim sistemima, ali ima prostora za poboljšanje. Neke ću dotaći, a neke ćemo kasnije. Sistem za poboljšanje je, na primjer, obavezna atrakcija sudske nadležnosti, suda koji vodi stečaj. Ne mora da bude nužno. Treba se dozvoliti da se arbitraže vode paralelno pred sudovima, pred arbitražnim tribunalima gde je to ugovoreno ili pred ugovoreno u trećim zemljama, zato što će svakako izvršenja nakon toga biti u trećim zemljama. Skraćuje se čitav postupak priznanja u koraku 2. Dalje, mi u Srbiji nemamo sistem, reći ću na engleskom, ne mogu sve da prevedem, pa onda ono što mogu ću prevesti na srpski. Company will, šta znači to? Ako imamo asset recovery instrument, ako imamo pravosnažnu izvršnu sudsku arbitražnu odluku, order bilo koje vrste, bilo kakvu naredbu, naš pravosudni sistem i legislativa to tumači na način da se može izvršiti samo prema direktnom dužniku ili tuženom. Company will omogućava da vi u postupku izvršenja menjate sledeći entitet u izvršenje bez vođenja dodatne parnice, skraćujući vreme i baveći se suštinom, a suština je zaštita prava poverioca. Ovde ću stati. Hvala.
Thank you very much, Tomislav. Now, Stephen, you are a UK insolvency practitioner, and I think a non-lawyer, but you work very closely with lawyers, so I know you're very well versed in the subject. How do you see things from the practitioner standpoint, looking in? How do you perceive these international developments? Do you think we're moving closer?
So, if I look back to 1997, which was, the launch of the model law, I think the environment in which we work together has completely changed. So, cross-border insolvency back in 1997 was a very rare thing. I remember one case, a ferry company, Sonago, and it made headlines when a judge in England telephoned a judge in New York. That was regarded as a massive step. It was like landing on the moon. And now we have traveled through UNCITRAL in parts of Europe. We have been utterly blessed with the EC insolvency regulations, which personally I have found one of the most powerful tools of all, having utilized them extensively over a 14-year period. And what stands out for me is the iterative cycle of cases, best practice, enactment. So I look at the challenge between secondary proceedings and main proceedings, and some things do stand out, like, for example, the MG Rover case, which was a case that started in the United Kingdom, but involved substantive operations in Germany. And out of that came the custom of giving promises to creditors in a foreign country that their priorities would be respected from assets situated in that foreign country. And a lot of enormously good practice of that. But I worry that it's not And in an attempt to move things forward and shape insolvency regimes, one size fits all, we face certain risks. So in the latter years, the prevalence of plans, restructuring plans, have become very prevalent. And the jury is out on the economic effectiveness of that, because at the heart of those plans is restructuring, realization and business sales, and the concept of no worse off and cross-class cram downs. And it all feels good, but if the covenant of the surviving debtor is not properly structured, then the loss in the long term may be very painful. But that's my headline direction of travel. But I think, when I listened this morning, everybody's hearts and minds in exactly the right place. No doubt.
So I'd like just to pick up that point about on one size perhaps doesn't fit all, and just to ask really, because we talked today about the UNCITRAL model law texts and how they don't tackle certain substantive law issues in relation, to cross-border insolvency, but these are touched upon in the European Union insolvency regulation, which has been very useful. May I just ask the other members of the panel just to also maybe comment on that, about harmonization and any risks associated with that? Luka, I'm sorry, I would like to start.
Da. Pa mislim, lakša je naravno harmonizacija u zemljama bivše Jugoslavije, ali tu su se sistemi razvijali donekle drugačije, posebno u Hrvatskoj i Sloveniji, koje su sada u Europskoj uniji. Mislim da sudije prosto za sada još uvek, što se tiče cross-border slučajeva, odnosno prekograničnih slučajeva, nemaju dovoljno ni smelosti, ni mogućnosti, ni volje da primenjuju ni model zakon, ani, da kažem, saradnju sa drugim organima na onaj način kako je to zamišljeno 1997. godine kada je model zakon donet. Kada je Srbija uvela model zakon 2004. i onda ga još, da kažem, doradila 2009. godine, nije bilo previše takvih predmeta, nije ih bilo ni do danas, a nije mi poznato da se u praksi dešavalo da je bilo, da kažem, situacija gde su se različitih zemalja, regiona povezivali i sarađivali na način koji je malo čas spomenut, a što se vjerojatno dešava mnogo više u Evropskoj uniji. I mi imamo drugi problem što ne postoji automatic recognition, odnosno automatsko priznanje, i samim tim cela stvar je mnogo komplikovanija ako su u pitanju zakonodavstva van Evropske unije. Toliko.
Thank you very much. And Josipa, your comments?
Pa ja bih se htjela i na ono što smo već danas čuli od sudaca, a to se tiče zapravo pozitivne diskriminacije vjerovnika koji nemaju sjedište u državi članici u kojoj se vodi stečajni postupak. Konkretno evo baš u Hrvatskoj kada je bio Agrokor, mi smo tu zastupali više vjerovnika i jedan konkretni vjerovnik nije na vrijeme prijavio svoju tražbinu. Dakle, rok za prijavu tražbine je bio 60 dana, on nije plus 8 dana, ali dobro, to sad manje detalje jer ima nešto kako se računa isto taj rok od objave i tako dalje. Nije prijavio jednostavno tražbinu u roku. I on je imao sjedište u Francuskoj. I on je nas kontaktirao i htio je podnijeti prijavu tražbine. On nije dobio e-mail sa porukom da je otvoren postupak izvanredne uprave nad Agrokorom i da može prijaviti svoju tražbinu. Međutim, ipak to nije učinio. I tada smo se mi pozvali, kada je njegova prijava tražbine bila odbačena, mi smo tu podnijeli žalbu i pozvali smo se na odredbe europskog prava, konkretno na činjenicu da njemu ta obavijest nije bila dostavljena na propisanom obrascu. Ta naša žalba je bila usvojena i njemu je na kraju bila njegova prijava usvojena i on je bio priznat kao vjerovnik u postupku izvanredne uprave. Tako da, ono što sam na početku rekla, dakle, taj utjecaj europskog prava, harmonizacija zaista ima veliki utjecaj u Hrvatskoj na razvitak stečajnog, na razvitak sudske prakse, što je još bitnije, jer se i neke odredbe koje su prije postojale trebaju tumačiti u skladu sa odredbama i ciljevima europskog prava. I ja se zato baš i veselim onome što je Miha spominjao danas, da će biti isto za restrukturiranje nešto novo iz Europske unije, tako da možemo se malo kasnije toga taknuti kada bude prilike. Hvala.
Thank you very much, Josipa. Tomislav, have you got any comments on harmonization and also in the context of asset recovery? Thank you.
Hvala. Ovo pitanje nije pravno, ali kao nezavistan ću sebi da dozvolim malo slobode da odgovorim. Delimično se slažem sa kolegom Andrićem, sa Lukom, međutim, kao i sve, potreban je tone from the top. Potrebna je poruka sa vrha. Mi smo jutro čuli profesora Radović. Ja sam to razumeo, bit ću sada malo rečitiji, kao vapaj za pomoći da se vrata nečega otvori, da krene da se nešto radi. Šta je etimologija toga? To je drugo pitanje. Etimologija toga je naš prethodni sistem, ratovi 90-ih, ali i to što naša privredna društva, naše kompanije nisu imale toliko aseta u inostranstvu. Njihovi aseti su bili kod kuće. U podsvesti ljudi koji treba da implementiraju te zakone i da donesu je u stvari omogućavanje zaštite interesa stranih poverioca u Srbiji. Ljudi imaju naprosto na ovim prostorima automatsko oklevanje da to primere. Šta je lek tome? Lek tome je edukacija, edukacija, edukacija. Na ovim prostorima rastu talentovane ljudi, veoma talentovane sudije. Ja želim da kažem da je pravosudni sistem u Srbiji najbolji deo vlasti, bolji od izvršni i od parlamenta. I najozbiljniji. Nadam se da će tako ostati. Omogućiti sudijama da putuju preko, da se edukuju. Ja sam malo prepotrebio reč company will. Ja znam da to ovde ljudi znaju. 85% sudija ne zna šta to znači u terminu, u meaningu. Znači, nakon neke edukacije, nakon 3 godine edukacije sa tonom od vrha da se vrata otvori, da stvar krene, ja verujem da bi to išlo i tekako u pravom smeru. Izvinjavam se, nadam se da je Chatham House Rules, ono što se ovde kaže može da se iznese, a ne ko je to izneo, ali ako nije, nema nikakve veze. Hvala.
Thank you very much, Tomislav. So I think this is the opportune moment to perhaps turn to the role of insolvency practitioners or bankruptcy administrators, because we have heard from the judicial perspective now, the insolvency practitioner or bankruptcy administrator plays a critical role in the administration of insolvency proceedings and accompanies the judge. And of course, is subject to a certain level of court oversight in many of the Balkans countries. And this profession is also supported by a whole eco professionals, including lawyers and asset recovery professionals. So could I invite, perhaps starting with Stephen, could I please invite you to share your experience on what you think practitioners need to handle cross-border insolvency cases effectively? Thank you.
So I'm going to lay my cards very bluntly on the table. It's not just cross-border insolvency. Insolvency practitioners need a very thoughtful skill set, and they have to get the basics right, because the responsibility of the restructuring or the outcome of the liquidation more often than not falls squarely on their shoulders. And in an insolvency, if you've been brought up in the United Kingdom, it's very simple. It goes as follows. You've got a distressed debtor, and the practitioner has to make decisions as to what is going to happen to that debtor. It's either going to be restructured or it's going to go through a sale of its assets, and the proceeds, whether it's a going concern sale or a liquidation sale, will be returned to the creditors. And at the core of those processes is something that we take for granted, and it is the decision whether or not to trade the debtor through insolvency. So we have these marvelous frameworks, we have marvelous legislation on the books, We have emerging legislation coming through on the books. We have cooperation frameworks, but full square on the practitioner's shoulders is, do I trade this business or not? And then after that, two things follow. If you're going to restructure the business and return it to the live side, then your restructuring plan has to deliver a debtor with a good covenant that is not going to implode and crash and burn in the afterlife. And that is a real talent to get that. Is the going concern covenant of a restructured debtor good? It's a very difficult question. And if you're not going to restructure the debtor, it's a very simple numeric algebraic equation. It's A over B. And A are the assets and B are the aggregate claims of creditors, and that's the outcome. And the challenge for the practitioner, I think, is that no one situation, every situation is unique. So the application of insolvency techniques, proceedings, laws is so fact specific. There is no one size fits all. So the poor old practitioner has to have a very open mind, I think, and has to have enormous access to subject matter experts, whether, in my case, they're lawyers, because I'm not a lawyer, whether they are valuers, whether they are tax advisors, whether they are economists. In the United Kingdom, a practitioner doesn't have the ability to speak to the judiciary. Only lawyers can do that. But I know in certain European jurisdictions, practitioners do have the ability to speak with the judiciary. I think you're very lucky, by the way.
May I just ask very quickly, is that the case in Serbia and Croatia?
Yes, they actually, act like a body of the court, if you wish. So it's a remnant of the old times. They are more inclined into speaking with the court as opposed to lawyers.
And then beyond that, so insolvency brings a number of smaller challenges. Dealing with employees and cutting costs and redundancies, no matter how many times you've done it, if you're my age, it is an awful and awkward thing to have to do. So there is a skill set around that. And then when the assets that are supposed to be there aren't there, that ability to investigate and recovery are just a small number of the toolkits that a practitioner needs.
Thank you very much, Stephen. Yes, I think Josipa would like to have a word. Thank you.
I would like to add this na hrvatski, pardon. Znači, vezano za stečajno upraviteljstvo u Hrvatskoj, ja smatram da to je jedna profesija koja je u velikom padu zadnjih 4-5 godina, da ide u lošem smjeru i da bi to trebalo generalno unaprijediti. Više je razloga tome, jer se sve veće obveze stavljaju na teret. Evo, primjerice, ja konkretno trenutno sam upisana u sudskom registru kao stečajni upravitelj za preko 150 društava. Neka od njih su zatvorena, ali neovisno o tome što su ona zatvorena i izbrisana iz sudskog registra, mene vrlo često kontaktiraju neke osobe koje imaju nekog pravnog interesa, zanima ih što je s tim, traže neku dokumentaciju staru, traže da provodim još neke ovrhe zato što smatraju da bi to moglo dovesti do stečajne mase nove i tako dalje. Dakle, ima jako mnogo posla oko toga, ali generalno nema nagrade za tako nešto. I što je još gore, te nagrade se smanjuju. Dakle, kada troškovi sve ide gore, u Hrvatskoj nagrade za stečajnog upravitelja idu prema dolje. Troškovi koje odobravaju suci su sve niži i niži. Vi nemate pravo na troškove. A ako ste odvjetnik, oni vama u većini slučajeva ne daju niti da angažirate odvjetnika da vam vodi parnične postupke u ime stečajnog dužnika. I onda kada ja uspijem u takvom sporu, onda mi kažu, ali ne, to nije imovina i nemaš pravo na nagradu iz toga. Tako da mislim da imamo vrlo velike probleme u tome da to, ako se tako nastavi, neće biti dobro. Da neće biti ljudi koji su adekvatno obrazovani i zainteresirani za tu profesiju na niti jedan način. I onda vi jednostavno nećete imati jednu neovisnu osobu koja će moći samostalno djelovati. To su uvijek neki kritični slučajevi, uvijek je to nešto je bilo prije toga što netko nije uspio riješiti, nekakva problematika i zaista ne znam kako će se to nastaviti. Ja puno razgovaram sa kolegama, naše udruženje je neaktivno, moram priznati, nisu ujednačeni, neki se boje izaći u javnost, jednostavno ne ide u dobrom smjeru. Tako da mislim da bi trebalo sa zakonodavnog aspekta to malo poboljšati i zaštititi poziciju. Kao prvo, meni je vrlo teško doći do policije kada trebam preuzeti imovinu. Puštaju me samo na teren, što ja ne želim neki put otići i sud se me pitaju zašto nisam otišla. Onda pokažem malo slike, mislim, vrlo je lako kad si ti u sudnici, a druga priča je kada izađeš na teren. A i ovo što se tiče pristupa sudu, znači u Zagrebu, ja generalno radim na sudu u Zagrebu, a tamo su zatvorili pristup sudu od covida. Jednostavno se morati doći do suca da bi vas pustili na porti samo da se popnete 2 kata gore i jednostavno s nekim porazgovarali jer ti predmeti nisu jednostavni. Znači tu uvijek ima nešto što se ne može riješiti iz zakona i dobro je što je zakon napisan kako je, tako da nema za svaku situaciju točan odgovor jer onda može pokriti više različitih predmeta nad više različitih stečajnih dužnika. Eto, toliko mi hvala.
Thank you. I think first Stephen and then Luca. Thank you.
So I listened to that, and my reaction is I've come from a very lucky and privileged background. And it's not the first time I've heard comments like that made. And clearly, if we're going to have effective model laws and effective harmonization, the position of the office holder has to be properly thought through and adequately buttressed. And it is very important, I think, that, quite aside from remuneration, I'm not even going to talk about it, it's such a contentious issue. People think you should work pro bono. I'm not joking. That can be the attitude of some creditors. As well as being remunerated, have to be released from liability at the end of their cases. And the liability regime for the acts or the acts and omissions of office holders needs to be very carefully. And if it is thought through properly, one will have a very effective profession, I've got no doubt.
Thank you, Stephen. And to you, Luca.
Hvala. Pa, samo 2 stvari, znači, da se nadovežem na ovu temu generalno položaja upravnika, dosta se o tome priča u posljednje vreme i kod nas. Mislim da je problem u tome što generalno ima malo stečajeva, manje nego 50 godina. Još manje ima nekih koji imaju imovine u nekom značajnijem obimu, tako da pretežu ovi stečajevi sa malo ili malo imovine, gde suštinski za stečajne upravnike nema prave nagrade, odnosno nema zarade. I sad, ako gledamo s tog aspekta, profesija ne može da se razvija, naprotiv, sve manje ljudi je zainteresovano da uđe u profesiju, oni koji su u profesiji su u dobroj meri ili barem dobar deo njih nezadovoljni i to ne može da doprinese razvoju tog, da kažem, skill seta, odnosno nekih sposobnosti i mogućnosti za upravo ovu saradnju u prekograničnim stečajevima koji su kod nas i dalje malo egzotika. Drugi komentar koji sam imao je da nije mnogo realno očekivati da se te njihove sposobnosti i znanja razvijaju u situaciji kad takvih slučajeva ima jako malo. I prosto oni po prirodi stvari nemaju interes da se time previše bave, jer ne vide konkretnu korist. Evo mi imamo baš jedan modul na tu temu, vidjet ćemo koliko će biti interesovanja, to je u septembru, ali sveukupno gledano mislim da je tema za njih i dalje egzotična i mislim da je prosto situacija takva da u našem regionu te međusobne veze ekonomski su bile pokidane 90-ih, sve što je bilo, a bilo jako puno imovine iz jedne republike u drugu, to je sada pod nekim pitanjem sukcesije, a novih situacija ima manje, tih velikih, da kažem, grupacija koje imaju imovinu po različitim republikama ili državama regiona, toga nema još uvijek toliko, tako da i tih stečajeva realno ima jako malo, gde bi pričali o pravom prekograničnom stečaju. Agrokor je to mogao biti da nije, upravo je imao i bilo je dosta i u različitim republikama, bivšim, da nije bio specijalan zakon, pričali bismo verovatno dosta drugačiju priču za taj predmet danas.
Thank you very much, Luka and Josipa and Stephen. I'd now like to turn to Tomislav and just to ask you to tell me a little bit about your views on the interaction between the insolvency practitioner and the asset recovery professional. I mean, to what extent does the insolvency practitioner also need an asset recovery specialist, and do you work hand in hand? Thank you.
Let's make the joke because previous statement was said da napravimo šalu, prethodna izjava je bila prilično onako tužna. Stečajni upravnici 50% mrze, 50% vole asset recovery advokate, zavisi sa koje strane oni nastupaju. Ja ću iskoristiti samo pola mog vremena u ovom sada što ću izlagati, polovinu ću tradovati sa Steveom ako smem. Imam dva pitanja za njega, on potiče iz engleske stare trgovačke nacije, vratit će mi kasnije kad budem ponovo imao reč. Stečajni upravnici su vezani za sporove koje vode u stvari voljom i budžetom. Voljom poverioca i budžetom koji raspolažu. Pored toga ne ulazeći u njihovo znanje, u kulturološki položaj razumevanja svoje uloge i tako dalje i tako dalje. Znači, dve stvari su bitne, volja poverioca i budžet kojim raspolažu. Sudije će odobriti svaki postupak koji se vodi. Obrnuto, mi kad zastupamo različite poverioce ili neke nove institute, mi smo to malo pitanje preskočili, kasnije ću ga vratiti na sto, neke nove institute koje postoje u svetu, u Srbiji još ne postoje ili postoje jako retko. Mislim da smo se kolega Luka i ja sreli na jednom predmetu tako gde to postoji. To je third party funding, znači finansiranje od strane trećih lica i vođenje postupaka. Ne pričam nužno o otkupu potraživanja, mada je i to deo third party fundinga. Pričam o bukvalnom finansiranju sudskih i arbitražnih postupaka, jer obično stečajni upravnici nemaju dovoljno budžeta da te postupke vode. Recimo, to je jedna od delova gde se može poboljšati postojeći pravni sistem. Jer možda na tržištu postoji neko kome je interesantno da neki postupak finansira, neki aseti vrate nazad u stečajnu masu. Iako to možda osnovnim poveriocima nije važno. Ali je važno iz ugla nečega što kad završimo današnji panel možemo da zaključimo, da se podsjetimo zbog čega smo počeli da se bavimo pravom. Nismo počeli da se bavimo pravom da bi slali fakture i bilovali, nego aseti su otišli iz stečajne mase. Neko je na tome napravio dobitak koji mu ne pripada. Treba ga vratiti nazad. Znači, po svaku cenu naći način da se to uradi. To je ono što mi sa asset recovery strane možemo da pomognemo. Steve, imam pitanje za tebe, ako smem, vezano za ono što je izlagao. Da li smem? Da li nam možete objasniti, Steve, poziciju receivership u anglosaksonskom pravu? Mi to nemamo kod nas.
So, a receiver is a very English thing. I am going to nail my colours to the mast. Receivership or administrative receivership for well over 100 years was the very ornament of our profession. And we let it go, or the legislators took it away from us. So a receiver is an insolvency practitioner who acts under a contract between a company and its creditor, and the creditor will have security, and the receiver's job is to realize the security for the benefit of the secured creditor, and any surplus is paid to the creditors without security. The proceedings that we wrestle with today, call it what you want, call it administration, call it a plan, call it a scheme of arrangement. I don't know the foreign terms, I'm so sorry. But these collective proceedings are proceedings that are adopted on behalf of all creditors, and they respect, to a certain extent, the rights of secured creditors, the rights in rem. But the important point, and I think it's an economic one, And it's a shame our colleague from the EC is not present, who joined us earlier on this morning. Because if you are a creditor and you have security, you love and you cherish your asset and you look after it. And if you find that your security is in jeopardy, you will appoint a receiver to realize that asset and manage it. And therefore you avoid the catastrophic problem of nobody being prepared to take action until the fortunes of the debtor have withered on the vine. So I'm afraid unashamedly, I am a fan of receivership because each looks after their own.
May I have another one?
One more, thank you.
Thank you. Da li Steve možete u vašoj ulozi receivershipa u trećoj zemlji van UK da preuzmete svojinu, obtain the title na nekom asetu?
Well, that depends. I think it does depend on the law of the specific country and where the asset is situated. So there are certain jurisdictions which quite simply do not recognize receivers. And then the next problem for a receiver is with collective proceedings, once they are enacted, a receiver is told to stand back and let the collective proceeding office holder, be it the administrator or the liquidator, get on. He has to do. So the receiver may not be able to access the assets for legal matters. He's in the wrong country, or because the law is shaped in such a way that the collective proceeding takes priority. So right now, I'm afraid receivership is not very fashionable.
Okay, thank you, everyone. I think we've heard, I think, that the role of the insolvency practitioner is critical, and also just helping to determine the outcome of the case. And Stephen, you've also shared your views on the skills that are necessary to handle the case. I mean, it's worth noting that as a profession, it differs significantly across different jurisdictions. In Serbia, it's a mixture of backgrounds and not necessarily lawyers. I think often they have business background. Croatia, is it also a mixture?
Trenutačno u Hrvatskoj samo pravnici i ekonomisti, a prije toga je mogao biti bilo tko visoko stručna sprema.
Yeah. And in the UK, I think technically lawyers can be insolvency practitioners, but most aren't. Is that the case?
Oh, yes, they can. But most of the work, for historic reasons, has been done by accountants.
Thank you. So I think it's worth also just bearing that in mind when we talk about the cross-border insolvency proceedings and harmonization efforts. That while I mean there will of course be differences among the judiciary in different jurisdictions, but also amongst the insolvency practitioners and backgrounds. So I'd like to turn now to talking a little bit more about the model law on cross-border insolvency, which focuses on four elements, which are identified as key to the conduct of cross-border insolvency cases. So access, recognition, relief, and cooperation. I'd like to touch on this theme of recognition, perhaps starting with Stephen, given your experience in the Nortel case. And I'd like you just to perhaps talk us through what recognition meant for you in that case. Thank you.
So of the four, I think they're all very important, but if one did have to pull out one above all others, it might be recognition. And the reason for it is that if an office holder is to be appointed to a debtor or to a group of companies, its fortunes and the success of that process are invariably governed by the actions that are taken in the first 5 hours or the first day. We call it day one. No matter how old you are, day one is always a most thought-provoking event. It's when you announce your presence, you announce the commencement of the insolvency, and there are so many people who want to know what's going to happen, whether it's employees, suppliers, customers, and unless you are recognized, and I've been blessed in the zone of automatic recognition in the EU, you can't even get off the ground. And in those crucial moments, you have to deliver confident messages, particularly if you're going to trade the business. So you're going to make promises to your suppliers that you're going to pay them for post-insolvency supplies. You can't make those promises unless you're validly appointed and you're recognized. You can't even begin to do the insolvency. So that's recognition at the outset. And then I think there is one has to start to peel back the question, recognition of what? Because recognition at the beginning, i.e. to stabilize and to work out what you're going to stabilize and trade the business. And if it's a healthy business, we will propose a restructuring plan. But if your plan is not cast in the right way and that is cast in a style that is acceptable to the various jurisdictions, it won't be recognized. It has to meet certain statutory norms in each jurisdiction, and it has to meet the public policy test. So recognition towards the end is slightly different, but it's equally important. And one will be very carefully scrutinized at the end whether you're doing a distribution insolvency, distributing assets to creditors. Is that going to be recognized? The creditors in particular countries, in cross-border jurisdictions, they will be very thoughtful that they are being treated fairly and in accordance with their own normal expectations. And I don't think any court is going to just allow through without pause for thought a restructuring plan without very careful consideration as to its proper foundations. So for me, you start the job with recognition. And when you pack up and go home, you've got to have recognition that you've done it properly.
Thank you very much, Stephen. I'd like to turn to Josipa, perhaps to say a few words in the context of your experience on the Agricor case and other cross-border insolvency cases. Thank you.
So, as colleagues earlier in the panels that were today, prevast ću se opet na hrvatski. Pardon. Imali smo inicijalni dogovor da ćemo pričati na engleskom i sad smo se malo dogovorili drugačije, ali dobro, da i to riješimo. A ja krenem odmah kada čujem na engleskom, na engleski. Dakle, što se tiče Agrokora, rekli smo i prije da nije bilo puno tih međunarodnih stečajeva i stečajeva sa tako jednim velikim međunarodnim elementom u Republici Hrvatskoj. Agrokor je bio jedan od njih, definitivno. I moram se složiti sa sucima, kako su danas iznijeli svoje mišljenja, zašto nisu priznali taj postupak u Sloveniji i u Srbiji, a i sa profesoricom, jer zaista taj zakon je bio donesen u roku, mislim, tjedan dana. Nismo imali nikakve upute niti mišljenja kako će ići njegova provedba. Sama mišljenja o tome kako bi neke odredbe trebalo provesti su se mijenjale iz dana u dan. I od toga što je potrebno da biste vi prijavili tražbinu i na koji način, i to je sve bilo na neki način vrlo ubrzano, međutim to nije bio jedan crno-bijeli postupak, da možemo reći da je to sve bilo loše ili da je to sve bilo. Bilo je zaista kompanija u Hrvatskoj koje su bile u teškom položaju, ali moje osobno mišljenje je da nisu trebala sve kompanije ići u insolvenciju. Oni su stavili u insolvencijski postupak u Agrokoru svaku kompaniju koja je imala minimalno 25% temeljnog kapitala u vlasništvu Agrokora ili neke njegove povezane kompanije. Vi ste tako imali, temeljem tog zakona, u insolvencijskom postupku kompanije koje su uredno poslovale, i kojima Agrokor nije bio većinski vlasnik. Tako da je došlo do jednog apsurda da je netko dobio izvanrednog povjerenika i neku nametnutu upravu koja mu zaista nije trebala. A onda opet bilo je tih kompanija u kojima se nije bilo više niti za plaće radnicima, koje su bile jako velike, koje su određena područja u Republici Hrvatskoj dosta održavala i bile su gospodarski bitne za njih. I na njima je trebalo provesti nekakav insolvencijski postupak. Sad, da li je to trebalo biti nekakav stečajni postupak konkretno? Ja mislim da se to se moglo stečaj provesti, jer naš stečajni zakon, ono što je Tomislav spomenuo malo prije, pravo financiranja od strane trećih osoba. Znači, ako ste vi imali jednu kompaniju koja je u stečaju, uvijek postoji mogućnost stečajnog plana. Tu su dosta široke mogućnosti, pa tako jedna od tih mogućnosti zapravo da vi nađete nekog tko će vam isfinancirati i sve troškove stečaja i preuzeti u nekom trenutku tu kompaniju i možda u nekom dijelu namiriti vjerovnike, ili ćete vi staviti te vjerovnike da oni budu dio vlasničke strukture u novom društvu ili da ćete prenijeti na novo društvo. Dakle, to su sve opcije koje smo već mi imali u našem zakonodavstvu, ali jednostavno se došlo do tog zaključka da treba taj jedan novi zakon koji je donesen tako kako je donesen i sad svi živimo s tim i s njegovim posljedicama. Tako da, kažem, nije crno, nije bijelo, sivo je, a vidjet ćemo možda za par godina u kojem će smjeru ići, možda dobije neku novu boju. Hvala.
Thank you very much, Josipa. Turning then to you, Luca, and taking the model law and the instruments of access, recognition, relief, and cooperation. What is your experience of seeing the application of the model law in Serbia? Do you have any comments on how any of this can be strengthened in the Serbian context? Thank you.
Pa, mislim da, kao što smo rekli, u Srbiji je bilo relativno malo primjera. Po meni ono što je model zakon, odnosno taj naš odeljak zakon o stečaju uspeo da postigne, to je da se to priznanje omogući. Jedna od suština model zakona je, dakle, jedno ubrzano priznanje te odluke bez onog uobičajenog postupka koji bi inače mora da se sprovodi za neku drugu sudsku odluku. Mislim da je to nešto što smo postigli, znači kao država posle oko 20 godina, iako toga ima, kao što sam rekao, malo u praksi. Što se tiče drugog aspekta, to je relief, odnosno ta neka pomoć, odnosno posledice priznanja, to ide ruku pod ruku, dakle, priznanje samo po sebi nema nikakav značaj ako ne proizvede one automatske posledice, to je zabrana izvršenja namirenja, zabrana raspolaganja imovinom od strane, da kažem, bilo kakvih lokalnih zastupnika, stečajnog dužnika, dakle, te dve stvari su možda ključne po meni i to je nešto što u praksi funkcioniše. Saradnja, možda ponajmanje, iako su sva četiri ta elementa, znači pristup sudu, priznanje, pomoć, odnosno posljedice priznanja i saradnja, iako su svi značajni, očigledno, možda je saradnja ponajmanje u praksi prepoznata kao nešto što je i od praktičnog značaja, a i ponajmanje se primenjuje. I taj pristup, access, on je po meni samo delimično primenjen, dakle vrlo retko, osim prava stranog predstavnika da se pojavi pred našim sudom i da zahteva priznanje, u određenim aspektima se iscrpljuje takođe posle toga u pravu na unovčenje imovine. Dakle, to je, ajde da kažem, neki osvrt na ono kakva je praksa i iskustvo u Srbiji.
Thank you, Luca, for those comments. And yes, indeed, we did hear that the model law isn't widely used, but may be more widely used in the future, especially as the cross-border insolvency elements extend perhaps beyond the Balkans. I just wondered whether I could invite you to comment on this issue with relation to initiating non-main proceedings, because I think that came up earlier.
Da, pa mislim, to je jedan specifična situacija koja je možda za Srbiju čak i najinteresantnija. Dakle, sam model zakona i naš odeljak u međunarodnom stečaju nisu potpuno jasni u pogledu toga može li se pokrenuti non-main proceeding. Mi ga zovemo sporedni postupak, a da prethodno ne postoji strani postupak. Dakle, u situaciji kada je domaći, na primjer, poverilac zainteresovan da se namiri i zaštiti njegovo namirenje i ako želi da spreči rasparčavanje imovine koja se nalazi u Srbiji, dakle, postoji situacija kada postoji ogranak stranog lica u Srbiji koji ima neku imovinu, da li on može pokrenuti takav postupak. I naši sudovi su zauzeli stav pre par godina da ne može. Mi smo imali recimo u praksi slučaj pre 10 manje da može, pa je stav promenjen. Ali činjenica je da je za Srbiju to značaj zato što ovde postoji situacija da u inostranstvu neće biti stranog postupka, taj neko ko je dužnik ne želi da ga pokrene u domaćoj zemlji, a domaći poverioci njegovog ogranka ili samog tog stranog društva nisu u mogućnosti da dobiju pravo na pristup tom kolektivnom namirenju i zaštiti, da kažem, od pojedinačnog izvršenja i, da kažem, uklanjanja sredstava iz Srbije. Dakle, to je nešto što, ajde da kažem, po meni, i tu se slažem sa sudijom Radovićem, verovatno je moguće po našem postojećem zakonu, ali očigledno nije dovoljno jasno ili barem praksa je do sad bila na liniji da nije dovoljno jasno. Eto, to je bio problem, ali to nije, da kažem, suština model zakona, to je jedna onako bočna situacija.
Thank you, Luka. I'd like now to turn to Tomislav and to invite you to join the discussion and perhaps tell us a little bit about the practical issues you've encountered in your asset recovery work. Thank you.
Hvala. Slažem se sa kolegom Lukom, dodao bih neke stvari. Najbitnija stvar vezano za stečaj i asset recovery je vreme. Ovo što pričamo je divno ako ne možemo da povratimo asete nazad. Živimo u vreme kada novac ide okolo kako ide, a pogotovo kada digitalna imovina se prenosi na način koji common people, običan čovjek, ne može ni da isprati. Jedna je stvar priznanje stranog stečaja kao deo modelova u okviru postupka u Srbiji. To je super, ali nije do kraja praktično. Druga je stvar direktno priznanje proveravanja strane odluke, strane recimo privremene mere pred stranim sudom u stečaju u Republici Srbiji, pre nego što priznamo strani stečaj. Takva privremena mera se treba donositi ex parte, bez prisustva druge strane. Mi te instrumente imamo u načelu opisane u zakonu o izvršenju. Znači, zakonski okvir postoji, treba malo sinhronizovati postojeće zakone i znači pre nego što se prizna Republici Srbiji, priznati mere koje su donete u inostranstvu i blokirati imovinu u Srbiji. Na primer, Anglosaksonci, Englezi imaju privremenu meru koja se zove Worldwide Freezing Order, koja se donese i važe eksteritorijalno za ceo svet, a koje druge zemlje direktno priznaju. Istu takvu meru i mi možemo uvesti u naš sistem i tražiti od drugih zemalja direktno priznanje. U poslednjoj tački, kad budem pričao, ću objasniti pravni osnov za to, neće ovde. Znači, vreme, ex patri i direktno priznavanje strane sudske odluke. Imam jedno pitanje za publiku da ih malo probudim. Jel imamo ovde stečajnih upravnika prisutnih u sali? Odlično. Koliko vas zna da se može direktno pojaviti pred sudom Sjedinjenih Američkih Država po čapteru 11 i 15 i tražiti priznanje odluke koje ste našim sudom vi kao stečajni upravnici? Znači, direktno se možete obratiti sudu u Sjedinjenim Američkim Državama, chapter 11, chapter 15, i tražiti priznanje odluke koju imate. Ne treba vam međunarodna pravna pomoć, ne treba vam odobrenje našeg predsjednika suda, predsjednika države i tamo ćete dobiti priznanje odluke koju imate. I kad novac odavde ode tamo, možete ga sprečiti da ide dalje, ako ste dovoljno brzo. Te stvari su bitne, mimo pravne teorije. Nastavit ću na sledećoj tački. Hvala.
Thank you very much, Tomislav. So I'd like to now turn to our final topic of today's discussion, which is about the role of the state and also public policy in cross-border insolvency. So some cross-border insolvency proceedings can attract a lot of public interest, especially where jobs and livelihoods are at risk. And all of the UNCITRAL model laws recognize the sovereignty of the state and expressly recognize the power of the court to refuse to take any action that would be manifestly contrary to the public policy of the relevant state. So I'd just like to ask, perhaps starting with Jasnica, just to comment on the types of public policy issues I think we've alluded to earlier, but maybe you could develop on this in the cases that you've been involved in, and how do you perceive, or how have you perceived the role of the state in those cases? Thank you.
Uloga države je vrlo bitna u stečajnom postupku. Kod Agrokora je to jasno došlo do znanja. Dakle, država je napisala novi zakon samo zaradi jedne kompanije kako bi riješila njihove financijske probleme na jedan način. Ali u redovnom stečajnom postupku koji se odvija u Republici Hrvatskoj, država ima također jako bitnu ulogu. Znači, država je skoro u svakom predmetu vjerovnik. Više od 90% slučaja, ako mu nekoj moje procjeni. I vrlo često i najveći vjerovnik, ako nema nekih banaka koje su tu uz financiranje i tako dalje. I sad je isto tu bitno kakav je postupak u igri. Dakle, ako se radi o nekakvom redovnom likvidacijskom stečajnom postupku, država je vrlo često tu vrlo susretljiva, razumna, daju sami svoje neke prijedloga kako nešto novčiti na jednostavniji način, jeftinije, ne protive se zaključenju i jasno im je u kojem to smjeru ide i tu je s njima suradnja, moram priznati, vrlo produktivna. Državni odvjetnici u Republici Hrvatskoj, odnosno njihovi zamjenici, zastupaju Republiku Hrvatsku i to su obično osobe koje imaju znanja o samom tijeku stečajnog postupka, kako se on provodi, o svim njegovim izazovima. Kada imamo neko restrukturiranje, konkretno imamo u Hrvatskoj taj postupak predstečajne nagodbe. Tu je država malo teže, blago rečeno. Dakle, predstečajna nagodba obično podrazumijeva da se neki dio tražbine otpiše i da onda to društvo koje je ušlo u taj postupak nastavi poslovati i otplaćuje možda dio duga ili se isto tako preuzme neki vlasnički udio u tom društvu, zavisno sve. Većinom to ide na otpis većeg dijela dugovanja koje je utvrđeno na neki grace period nakon zaključenja i onda otplata kroz dugi niz godina, a nerijetko te iste kompanije nakon proteka grace perioda završe u stečaju. Dakle, to je recimo jedan postupak koji nerijetko prethodi samom stečajnom postupku kojeg pokreću sami dužnici, same insolventne kompanije. I tu država obično ne pristaje na te otpise. A najveći problem sa državom i u predstečajnim postupcima i u stečajnim postupcima zna biti kada je zapravo država onaj vjerovnik koji je doveo do pokretanja insolvencijskog postupka, a upravo iz razloga što se više o nekakvom poreznom pitanju, kada postoji između samog dužnika i države neko neriješenje. Dakle, tumačenje poreznih propisa. Da li su oni dužni platiti neki porez ili nisu. Država tu vrlo često ima ovršnu ispravu koju vi ne možete samo tako lako pobiti ili staviti van snage i ona vam blokira račune. Vi čim imate više od 60 dana blokiran račun, imate stečajni razlog. I ako imate dulje od 120 dana blokiran račun, vama u Republici Hrvatskoj stečaj se otvara po službenoj dužnosti. I nema natrag. Ako nemate stečajni plan, jednostavno nema natrag. Kad ste stečajni upravitelj u toj situaciji, vi ne idete osporavati takvu ispravu, jer to je ovršna isprava. Dakle, vi morate sami pokrenuti taj postupak, morate snositi te troškove, to je vrlo rizično, na pitanja i po meni je tu zapravo veliki problem tumačenje poreznih propisa. To su vrlo rijetke situacije, ali ih ima i one znaju dovesti neka društva nepravedno do same insolvencije, jer one znaju čak vrlo uredno poslovati, ima dobar poslovni plan i njihovo poslovanje znači ići vrlo dobro.
Thank you very much, Jasnica. Stephen, what has been your experience? You've had to appear before different national courts. have you noticed the presence of the state?
The answer is definitely yes, and I agree with virtually all of your points. The state is going to be very interested when a foreign practitioner is on its soil, and rightly so. Right from the outset, the practitioner, whether the state is a creditor or not, will be watched. And the state will take a great deal of interest in whether he or she is doing the right thing and doing things right. And when you have tax authorities involved or redundancy funds involved who fund the sort of minimum redundancy payouts for employees and things like that, they are, of course, going to be very, very concerned as to how their money is utilized and whether it is right to do so. And I think there's a class of issues which are so obvious we just take for granted. So the role of the preferential creditor tells us a great deal about the economic and social values of each jurisdiction. And it's an act of utter futility if a visiting practitioner is not going to recognize the importance of those local values, like preferential liabilities, be it tax or VAT or value-added tax or employee liability. So there's a class of what I call obvious state involvement. And then there's a different class of state involvement, and it's when something happens that it is so left field, is so unexpected that nobody ever thought this could happen in our country. And the state, you know, I use that term quite widely. It's not just the ministries or the legislators or the regulators, but everybody is thinking, gosh, can this really be happening to us? Is this right? Is this fair? So we had an appalling incident which originated from the United Kingdom on the Nortel case. It caught everybody by surprise. The company in the United Kingdom had a very old-fashioned type of pension arrangement for 44,000 former and pending employees. And the liability that was owed by the UK Nortel company to that pension fund was £2.4 billion. So the pension liability was the largest of all. And you wouldn't know this unless you lived in the UK, but in the UK is a quango, a quasi-autonomous government authority. It's called the Office of the Pension Regulator. So delete from the record my word quango, but that's what I think of it. And I know certain judges in the United States think the same of it. And the pension regulator has the power under a unique act of parliament to require people to make contributions to the pension fund. So here is Nortel UK, it owes the pension fund 2.3 billion, and the pension regulator, after 9 months of insolvency, just before Christmas in 2010, it sends 3 lever arch files to each Nortel entity in mainland Europe and Israel and Nigeria and South Africa and the Ukraine. And these files require these companies, you know, Germany, the Netherlands, Belgium, Sweden, Italy, Portugal, Spain, everybody, to pay a pension fund. And it's quite challenging to explain to the local creditors in Germany or to Spain or to Portugal why it is right that the UK pension fund should benefit from this very specific legislation. So there's this most glaring issue which is attracting state attention. And everybody goes away and thinks about it very carefully. And it was hovering over us for years and years and years. And it was a major burning platform as to whether this liability could ever be enforced in each jurisdiction. And I do assure you, every single state, other than the United Kingdom, was very, very thoughtful about this particular claim that was asserted. It was absolutely fascinating. It was absolutely fascinating. And I had the most difficult conversation ever when I had to travel to Germany to speak to the German pension regulator who was stepping in to make good potentially the deficit in the German debt. And I explained to him what this purple box contained. And he just sat there looking at me. And then after about half an hour, he just said, well, Mr. Harris, why haven't I got this type of legislation? And I said, I don't know, but if you'd like a copy of the Act of Parliament, here it is. So the role of the state is very important, and it's an important safeguard.
Thank you very much, Stephen. So, Luca, I would be interested in your views on the role of the state as a creditor, and how also in Serbia, what would be considered perhaps grounds of public policy not to recognize, in a theoretical, maybe just taking the case of Agrokor, but also expanding.
Da, dva aspekta, znači uloga javnog poretka, drugim rečima nešto što će sud da ceni, ali će nekada, kada su u pitanju predmeti tako velikog značaja kao što je Agrokor, i sam sud neminovno, da kažem, državnog uređenja i državnih organa, i to je na kraju krajeva neminovno bio slučaj i u tom predmetu. Dakle, to je jedan aspekt, drugi aspekt je kada je država poverilac. Kod nas je država poverilac najčešće preko poreske uprave i ono što je opisala Josipa u pogledu njihovog ponašanja je, ajde kažem, i ovde vrlo slično. Naravno da kod nas, na primjer, ima jako mali prioritet država i poreska uprava, takav je naš zakon zadnjih unazad 20 godina. Tako da oni nemaju neku preveliku ulogu vrlo često u današnjim stečajima. Imali su pre 20 godina više u onim starim državnim društvenim preduzećima, gde su veliki dugovi bili prema državi. Ono što je meni poznato su samo 2-3 predmeta, neki su bili nevezani za sam stečaj u Srbiji, ali jesu bili vezani za stečaj, na primjer, u Americi. I tamo su, da kažem, određene sudske odluke u Srbiji nisu priznate. Jedno konkretno sad mogu se setim sa pozivom na javni poredak, gde je sud dosta široko to tumačio. Dakle, pozvao se na neke stvari koje možda ne bi nužno bile deo javnog poretka. Dakle, kod nas nema jasne tog instituta, ali je on primenjen neminovno, ja mislim, u širem smislu kod Agrokora, dakle, kada je odbijeno priznanje, to je učinjeno sa pozivom na neke od bazičnih zahteva našeg zakona o stečaju koji bi se mogli poistovetiti s javnim poretkom. Dakle, da li je postupak usmeren na kolektivno namirenje ili na zaštitu nekih drugih interesa. U tom smislu sam Agrokor je možda, da kažem, i dobar primer, ali i izuzetak, jer tako nije bio, kao što je Josipa objasnila, klasičan stečajni predmet. U ovim drugim predmetima koji su mi poznati sa prekograničnim stečajem, odnosno međunarodnim stečajem, nije bilo pozivanja na javni poredak, tako da nemam u glavi ni jedan drugi slučaj koji bi bio dobar primer za taj institut.
Thank you, Luca. Thank you for those comments. And passing the floor now to Tomislav. As an asset recovery lawyer, have you engaged with the state authorities and other jurisdictions? And how has that engagement been? And has it been necessary? Thank you.
Ovo mi je omiljeno pitanje, hvala. Javni poredak se u konkretnoj stvari treba gledati kroz pitanje aktivne legitimacije države pred stranim sudom kao parti civile, kao građanske stranke. Osnovno pitanje je da li za to postoji pravni osnov. Postoji pravni osnov, član je 53 UNCITRAL konvencije, koji nosi naslov Direct Asset Recovery. Primenjuje se isključivo u civilnim stvarima. Znači, kada jedna država ima potraživanje prema bilo kom entitetu u drugoj državi i kada želi da ta država bude parti civile, građanska stranka, ona to može da bude, insolvency procedure, bankruptcy procedure, stečajni postupak građanskog postupka, znači može da bude i poverilac u stečajnom postupku. 3 stvari može jedna država da traži kao parti civile u drugoj državi pred stranim sudom. Može da traži repatriaciju aseta u potpunosti. Može da traži title ownership, bilo koji nosilac svojine ili pseudo svojine na tom asetu. I može da traži kompenzaciju. Domaći sud mora po toj UNCITRAL konvenciji članu 53 da preferencijalno pruži sav servis stranoj državi u odnosu na sve drugo. To se primenjuje. To se primenjuje. Zbog pitanja aktivne legitimacije i stava nekih država koje nisu potpisnice UNCITRAL konvencije, da nemamo direktan pravni osnov, države su pribegavale pravljenju, sačinjenju aktivne legitimacije kroz prenos potraživanja na posebna pravna lica. Daću konkretan primer iz Srbije. Postojala je čitava masa sporova koji su proizlazili iz postupaka privatizacije. Masa sporova. Ja znam da je kolega Luka takođe veoma verziran. I pošto su ti sporovi u inostranstvu bili odbijani i odbačeni na savet nekih ljudi, država Srbije je formirala agenciju za vođenje sporova u inostranstvu koji proističu iz postupka privatizacije. Onda ta agencija na koju je preneta aktivna legitimacija ima svoj pravni entitet, pravno lice, više nije nosilac suverene vlasti. Se javlja kao parti civila u zemljama koje nisu potpisale UNCITRAL, uspešno vodi sporove i naplaćuje, naša kancelarija u tom učestvuje. Tamo gde postoji član 53 i gde je potpisnik UNCITRAL, tamo je direct asset recovery i uopšte nije potrebno da se ide preko drugih entiteta. G20 u martu mesecu ove godine, moja malenkost je bila prisutna na ovu temu i takođe pričala, podiže awareness vezano za člana 53. Prvi direktan sporazum između dve zemlje je potpisan između Brazila i Italije prošle godine, gde javni pravobranilac Italije će zastupati državu Brazil u svim postupcima koja država Brazil ima u Italiji. Da bi zaobišli privatne advokate, privatne praktičnare zbog budžeta i svega ostalo. Znači, to ide u tom pravcu. Slobodan sam za pitanje. Hvala.
Thank you very much, Tomislav. As we are approaching the end of today's session, I'd like to open the floor to the audience for questions. I think there's a question over there. Do we have a roving microphone? Sorry.
Ne bih htjela da dobijete dojam da, jer sve malo danas promatramo kroz taj Lex Agrokor, ali zapravo to je toliko loš zakon da uopće nema odredaba uopće. Bilo je naravno i puno prijedloga za ocjenu ustavnosti, međutim naš Ustavni sud kad je donosio odluku, odlučio je da je u skladu sa ustavnosti, međutim nije, objektivno nije. Uopće nema niti jednog stručnjaka iz stečajnog prava među našim ustavnim sucima u sadašnjem sastavu koji je o tome odlučivao, a predsjednik našeg ustavnog suda čak nije niti smatrao potrebnim da angažira nekog ko se bavi stečajnim pravom da napiše mišljenje, nego je angažirao profesora ustavnog prava koji nikada u životu nije objavio niti jedan rad o stečajnom pravu, niti se ikada time bavio. Pametno me sapienti satis, pametno me dosta. Međutim, mislim da je važno za vas stečajne upravitelji u Srbiji, a naravno i za svakog stranog upravitelja kad je riječ o imovini u Hrvatskoj, da imate iznimno velika ovlaštenja. Dakle, vi možete direktno pristupiti Hrvatskom sudu na čijem području se nalazi imovina, odnosno podružnica u prvom redu, a onda i imovina, ako je glavni postupak otvoren u vašoj državi, i tražiti, najčešće će to biti formalni postupak. Izuzev ovako, kao što sam danas ujutro već rekla, gdje je možda samo jedna parnica i gdje se postavlja pitanje da vi zastupate stečajnog dužnika u nekoj parnici koja se vodi u Hrvatskoj, ali to je rijetko. Dakle, u pravilu vi možete, ako je u Hrvatskoj imovina, tražiti direktan pristup, tražiti priznanje i za samim tim prijedlogom za priznanje vi možete staviti prijedlog za osiguranje te imovine u Hrvatskoj, da od tog trenutka kad ste stavili prijedlog, taj stečajni dužnik, odnosno bivša uprava, ne može raditi nikakve malverizacije sa time. Ako se prizna strani stečajni postupak, dakle vaš stečajni postupak ovdje u Srbiji, vi imate iznimno velika ovlaštenja kao strani stečajni upravitelj. U situaciji da u Hrvatskoj nije otvoren sekundarni postupak u okviru tog postupka priznanja, vi zapravo gotovo da imate ovlaštenja koje imate prema srpskom stečajnom zakonu, zato što mi kažemo u pravilu mjerodavno je lex fori concursus države koja otvorila stečaj u pogledu ovlaštenja koje stečajni upravitelj ima. Jesu se, danas ujutro sam već spomenula, najprije morate namiriti radnike i javnopravne tražbine. Druga priča je ako kao rezultat vašeg prijedloga za priznanje strane odluke mi otvorimo sekundarni postupak protiv hrvatskog stečajnog upravitelja i tu se otvaraju vrlo široke mogućnosti za međusobnu suradnju, čak šire nego što u ovom trenutku UNCITRAL model zakon kaže u svojim odredbama. Primjerice, svi vjerovnici koji su prijavili tražbine u vašem glavnom stečajnom postupku, vi te tražbine možete prijaviti u hrvatskom sekundarnom, a to znači da vaši vjerovnici ne moraju putovati niti trošiti na svoja sredstva da bi sudjelovali u sekundarnom postupku u Hrvatskoj. Isto tako, vi možete osporavati tražbine koje su prijavljene u sekundarnom stečajnom postupku. To također UNCITRAL model zakon ne predviđa. A da ne kažem onda da možete stavljati prijedloge što zapravo činiti sa imovinom u Hrvatskoj, naravno u suradnji sa sekundarnim postupkom. Isto nešto što UNCITRAL model zakon nema, mi čak dopuštamo da se povežu mase glavnog stečajnog postupka i sekundarnog. Dakle, maksimalno smo otvoreni suradnji. Evo, toliko o tom našem međunarodnom stečajnom pravu koje doista otvara velike mogućnosti. Samo treba proučiti zakone i vidjeti koje su vam mogućnosti na raspolaganju. Evo, toliko. A što se tiče te javne politike i osviještenosti naše države kako uopće regulirati stečaj, posebno služba stečajnog upravitelja, ipak moram reći da u posljednje vrijeme raste ta svijest, kao što je naša odvjetnica rekla, od 2012 samo pravnici i ekonomisti mogu biti stečajni upravitelji i Ministarstvo pravosuđa je ovdje doista preuzelo na sebe jednu veliku zadaću da kontinuirano održava radionice. Dakle, imate preko 30 vrsta radionica, čak i više. Skoro svaki tjedan se održava nekakva radionica u Ministarstvu pravosuđa. Naši stečajni upravitelji moraju posjetiti najmanje 2 radionice unutar 3 godine da bi smjeli ostati na listi stečajnih upravitelja. Čak je donesen i etički kodeks za stečajne upravitelje. Dakle, ne možemo reći da država ovdje ništa ne radi. To znači da svaka osoba koja smatra da je stečajni upravitelj napravio nešto krivo, može staviti zahtjev za pokretanje etičkog postupka pred Ministarstvom pravosuđa koji će onda odlučiti je li ili nije došlo do etičke povrede, s time što u tom povjerenstvu je jedan sudac, predstavnik stečajnog upravitelja i Ministarstva pravosuđa. Dakle, to je jedno miješano. To naravno je dobro. Bilo bi još bolje da imamo komoru, što neki od nas godinama predlažemo u Hrvatskoj, jer smatram da bi se to diglo još na jednu veću profesionalnu razinu, jer kao što je naša odvjetnica rekla, jako zavisi tko vodi u određenom trenutku asocijaciju. Asocijacija je na dobrovoljnoj bazi bez financijskih sredstava, tako da njezina moć je vrlo, vrlo niska. Eto, hvala toliko.
Thank you very much, Professor. I think I can see a question at the back from Samira. From the UNCITRAL secretariat.
Thank you for this excellent panel presentation. And I have one follow-up question. In fact, it applies to all practitioners, not anyone specific. There was one concern raised about remuneration of insolvency practice. Very often practitioners in this region may need to work with zero asset cases when insolvency estate doesn't have any assets. And of course, then insolvency practitioners may not be interested to take up those cases because risk is that they would not be remunerated for their services. And this very much linked to micro and small enterprises, insolvency, really zero asset cases. So my question is, what's your practice and what your approaches to pursuing actions, for example, against directors for wrongful actions taken in the period approaching insolvency, and also, for example, avoidance. Because if you avoid particular transactions, then you may get resources to the insolvency estate. So insolvency estate may only seem to be zero asset, but there are many actions of value. And UNCITRAL, for example, consider assets of the insolvency estate in a very broad sense. Anything of value is considered to be an asset. And are there any practices in the region to pursue successfully avoidance actions? And, for example, actions against directors for wrongful training, for other wrongful actions that in fact led to insolvency. And this would in fact make insolvency estate then full of valuable assets. And then insolvency practitioners would be remunerated for their services. So what was the practice? And also, of course, to representative of Nortel, that would be also very valuable to hear. Thank you.
Thank you very much, Samira. I think Tomislav will take this particular point.
Thank you, Samira, for your kind question. Te tužbe pripadaju u korpus takozvanih kompanijskih tužbi protiv odgovornih lica zbog različitih stvari, sukoba interesa, propuštanja dužne pažnje. Vraćam se na pitanje da li stečajni upravnici kako pokreću sudske sporove, sve zavisi od volje kreditora, od poverioca i od budžeta kojima raspolažu. U pravu Srbije postoji još dva dobra instrumenta, od čega je po meni jedan još bolji. Imamo akciju Polijana, čuvenu polijansku tužbu, ali po meni je najbolji instrument u konkretnim slučajevima član koji se ne primenjuje često, mi ga primenjujemo često, to je član 452 Zakona o obligacionim odnosima. To je da bez obzira kojim pravnim poslom, ne pričamo o nezakonitom pravnom poslu, ne pričamo ni o štetnom pravnom poslu, bez obzira kojim pravnim poslom ja sam završio kod nekog trećeg lica, stečajni dužnik ili poverilac, mi zastupamo poverilac, može da tužbom traži naknadu štete od tog trećeg lica, bez obzira da li je to stekao legalnim putem, ali samo do visine aktive kojima je prenet. Ako i postoji aset na koji je usmereno konkretno potraživanje, onda se traži naplata iz konkretnog aseta, nepokretnosti, ali ako je zahtev novčani, onda iz bilo kog aseta koje to treće lice posjeduje. Znači, to su uglavnom tri vrste tužbi, akciju Polijana, kompanijske tužbe i 452 ZO. Hvala.
Thank you very much, Tomislav. I think it would be interesting to pick up the point on, just very briefly, on directors' duties as well, if possible, and any comments you may have, because I think there isn't a wrongful trading test in Serbia, or maybe it may be more difficult to
pursue directors. Luka.
Da, pa nemamo sve te, da kažem, sva ta oružja na raspolaganju. Ovo što je Tomislav rekao, da, wrongful trading nemamo na takav način, a mislim da odgovor na u stvari pitanje o zero asset case-ima, znači najčešće to neće se desi, zato što u takvim predmetima nema novca ni da se finansiraju takve aktivnosti. Stečajni upravnici vrlo često izbjegavaju da ih uzmu, ako ih uzmu samo gledaju da što manje troškova imaju, ne bi li ih što pre završili. Znači, tako da nemamo tu mnogo zaista sreće sa pokušajima.
Jasnica.
Dakle, što se tiče pobijanja pravnih radnji, to ako vidim da imam dokaza, uvijek predlažem. Nama je sad posljednjom izmjenom stečajnog zakona produljen taj rok na 2 godine, inače je bio nešto kraći, 2 godine od otvaranja stečajnog postupka. Dakle, ako u tom roku ja nađem dokumentaciju koja mi je dovoljna za uspjeh u sporu, ja svakako predložim sudu da mi odobri takvu radnju, da se to pokrene, ali i skupštini vjerovnika, jer trebam imati 2 odobrenja da bi se to pokrenulo u Hrvatskoj. Ako smatram da nemam dovoljno dokaza i da ne mogu uspjeti u takvom sporu, ja jednostavno izvijestim sud u svom izvješću i svaki vjerovnik može pokrenuti pobijanje takve pravne radnje i onda ima pravo i naplate ako uspije u tom sporu. A što se tiče ovakvih kaznenih postupaka koje radi bivša uprava, ja to prepuštam svima. Kaznenu prijavu može podnijeti bilo tko. Ako nemam baš nekakvo izravno oštećenje koje znam da mogu dokazati, jednostavno nemam resursa da trošim ih na takve postupke. Vjerovnici koji znaju za to također mogu to pokrenuti. Kao što sam rekla, država je vrlo često uključena u stečajne postupke i ja sva saznanja tamo iznesem, tako da ih imaju i oni i mogu pokrenuti kazneni postupak. Sad, kazneni odjel je po meni vrlo spor u takvim postupcima, dakle kazneni odjel države, dakle naši ti državni tužitelji, i to se vrlo često ne procesuira kada se i podnese i vrlo rijetko su takvi postupci dokazivi. Tako da nekako imam dojam da je to onda u jednom trenutku borba sa vjetrenjačama i obzir sve što moram raditi kao stečajni upravitelj, to je jednostavno možda i višak za mene i prepuštam ostalima da se time bavi. Ja nisam stručnjak za kazneno pravo.
Thank you. I know that we are almost out of time, but I'd like to allow Stephen, or we are out of time. I'd like to allow Stephen to comment briefly, and then thank you.
So very quickly, the liquidator should be the office holder of last resort. He should turn over all the stones. And when the liquidator has got no, it can be a bad situation. There are other important considerations, I think, for legislators. So the ability to disqualify a person from acting as a director of a company is quite a good sanction for society if that person is just blatantly incompetent or dishonest. So that's out there, and it doesn't cost a lot of money, compared to litigation and asset recovery. So it's not ideal, but there are ways in upping the quality of governance across the corporate.
Which indirectly will help with avoidance.
It will help with avoidance. And the other really important tool is a director who knowingly worsens the position of creditors. He can be liable for losses. It doesn't matter that he ran off with the money. If you dissipate assets when you know that there is going to be a deficit to creditors in certain jurisdictions, you can be on the hook for that deficit. It really focuses the mind.
Thank you, Stephen. And just one final question, if possible.
Dobar dan, Nemanja Nikolić, advokat. Imam pitanje I have a question for Mr. Harris. You can do it in English. What I would like to know is how does the Institute of Selling a Bankrupt Debtor works in the UK? Meaning, does it always work through a pre-pack procedure, which involves selling off the company as a going concern to interested parties and through a subsequent judicial proceedings? Or does it happen within open bankruptcy proceedings? And on the other hand, do you require consent from the shareholders? Because here in Serbia, a bankruptcy debtor can be sold without the consent of the shareholders, and it basically leads to their, let's say, erasing or from the capital? Thank you.
So a very good practical question. How are assets of a debtor sold? A director or a board of directors with shareholder sanction, if necessary or not, could sell the business and the undertakings of the company. But if it's going to result in a suboptimal outcome, either for shareholders or for directors, they will not do it. A board of directors will not sell the business if there's going to be a deficit to creditors. They will get an insolvency practitioner who will hopefully know what he or she is doing and will understand. Now, your next question, does it have to be a pre-pack or can the business be traded? And that is a very fine balance. So if trading the business is not going to elicit a better return for creditors, if there's been appropriate marketing of the business, if disfranchised creditors have had an opportunity to protect their position, and if further marketing is going to be value destructive, then the office holder is entitled to enter into the sale of assets agreement. And provided all of those boxes have been ticked prior to his appointment or her appointment, it can be a pre-pack. The fundamental question for the insolvency practitioner, has proper value been achieved?
I think that's an excellent way to end this panel. And I'd like to thank all of the participants and our panelists for this very engaging discussion. And of course, the Serbian Bankruptcy Law Association for their hospitality, and UNCITRAL for making this possible. I'd like to pass the floor now to my colleague, Natalia Pagu.
Thank you very much. So, if I'm not mistaken, we are having a short break now. Please correct me if I'm wrong, and then we are continuing with the concluding remarks. So, thank you everyone for being here today. I think it's now time to conclude this multinational conference. I will try to summarize some of the key messages delivered today, but I promise to not take much of your time. The main messages are that and the UNCITRAL border insolvency has been fundamental in helping to achieve this among enacting states. More practice and capacity building are needed for all insolvency professionals and specialists, from judges to bankruptcy administrators and lawyers. The aim of the conference was to encourage clear rules and practices on cooperation on cross-border insolvency and the use of UNCITRAL model law texts. It was also to enable all of you to meet, exchange experiences, and develop professional contacts for the future, as cross-border insolvency will become increasingly relevant as trade increases among neighboring countries in the Balkans and elsewhere. Also impactful has been the European Union insolvency regulation, which we heard has transformed the landscape in member states such as Croatia. As highlighted by Samira, insolvency laws really do matter to economic development, and Zsoka made the case that foreign direct investment is a key driver of economic growth. Harmonization matters for smaller economies and for small and medium enterprises, which are the cornerstone of all economies in the Balkans region. As Professor Omar mentioned, the UNCITRAL model laws act as a bridge to connect national insolvency systems in an increasingly globalized world. Model laws on recognition of insolvency-related judgments and group insolvency are importantly complementing the 1997 model law on cross-border insolvency. We heard from Mr. Zebre from the European Commission that we experience an increasing momentum in harmonizing European insolvency systems. We are evidencing the results of the optionality provided by the 2019 European Directive on Preventive Restructuring, which also brings complexity in transposition and in its interpretation. The European Union insolvency regulation will be reviewed in 2027, and the new proposal for the directive to harmonize insolvency laws addresses topics such as pre-packaged sales and simplified liquidation for small and medium enterprises. Serbia is an early enactor of model law, but some loopholes remain in domestic law. For example, the lack of clarity on whether Serbian judges can open non-main proceedings. The point is a gray zone, as stated by both Professor Radovic and Mr. Andrić. The channels are still closed for cooperation and coordination. Professor Radovic and Judge Frankovic stressed the importance of capacity building of insolvency professionals around available texts and options. Often we experience a by-the-book legal framework, but without successful application in practice. Professor Moustaira gave an excellent example of how Greece created building blocks around cross-border insolvency by including provisions in the Civil Procedure Code from an early stage, even before the UN UNCITRAL text appeared in practice. Croatia, unlike Serbia, has not enacted model law, and there is no need, as stated as Croatia comprehensively covers the 4 elements in its domestic legislation. It was well explained by Professor Garašić, though, that UNCITRAL text should serve as a starting point or point of reference, even for the EU member states wishing to further develop their insolvency frameworks. I cannot neglect to quote Judge Đorđević, who told us that mutual trust in transactions and the resolve of disputes is fundamental. Red tape can often be an important impediment for the recognition of foreign proceedings and can lead to dismissal of cases. Judge Marko Radovic's insight was to reconsider opting for lex specialis instead of model law for group insolvencies. It has been highlighted that the reciprocity condition makes the model law rarely applicable, so the benefits are lost. Common law and civil law influences in the interpretation of model laws are subsequent recognition of foreign decisions are common in practice. I believe that all of our speakers agree that the role of the state, either as a creditor, the UK pension fund situation, or the public policy, or on the public policy field, as in the Agrokor case, can be a game changer. What insolvency practitioners need to handle cross-border insolvency is still a question. Insolvency practitioners need a thoughtful skill set. Restructuring and liquidation are a huge responsibility. One size does not fit all, as Mr. Harris mentioned. We should take into consideration when we speak about harmonization and cross-border insolvency that bankruptcy practitioners' background is not always the same. In different jurisdictions, lawyers, judges, or accountants can take up this role. I cannot omit to mention the 3 C's, cooperation, coordination, and communication, as mentioned earlier by Judge Radovic. I will stop there. I want to sincerely thank our speakers for their presentations and insights, our audience for its engagement, and last but not least, our fellow contributors, the Serbian Bankruptcy Law Association and the UNCITRAL Secretariat, without whom this conference couldn't have been materialized. Thank you very much.